Shall we start, please? Commissioners? Let me first apologize for the late start. We had a similar problem yesterday, but I've just talked to our camera people. I don't know if it's IT or cameras, I don't know what to call them, but they have been responsible for our time delays. We were ready to start at 9, but you've seen them busy fiddling with the equipment. But they have promised not to, well, to get their act together from now on. So, good morning, Judge Potterell. Are you well? Or is your mic on?
I've put it on now. Thank you. Sorry, I didn't for a moment. Good morning, Deputy Chief Justice.
How are you?
I'm okay.
All right. Are you comfortable?
I'm comfortable, thank you.
Good. Right. You hold 3 degrees, a BProc, an LLB, and an LLM.
Yes, I do.
Where did you obtain those qualifications?
My BProc I obtained at University of Pretoria. My LLB I did part-time while I was working. And then my LLM I also did, at UNISA. And then my LLM I did at the University of Pretoria.
You have a long career in the legal professions and the judiciary, starting in 1983 already.
Yes.
Can you just take us through your CV in that respect?
Yes.
Just briefly tell us where you started and where you are now.
I will. I've got 35 years in the legal fraternity. I started off doing estates, then a prosecutor, then a magistrate, civil and criminal. Then I went to Justice College where I trained other magistrates. Then I went to an independent bar because I fell pregnant with my child and they wouldn't let me work from home, so I went to an independent bar, and then I became a judge, and that's in short my career.
Mm-hmm. When did you become a judge?
In November 2009.
Mm-hmm. You practiced as an advocate for 10 years.
Yes.
Before that?
Yes.
All right.
I've been on the bench for 13 years, but the minister has accepted my 18 months continuous acting service, so I've actually been on the same bench for close to 15 years.
And I see that you've also acted at the Land Claims Court and the Competition Appeal Court.
Yes, I have.
And of course the SCA.
I have, yes.
Mm-hmm. How many terms have you acted at the SCA?
I did 4 terms, in other words, 6 months, 6 months.
And you are there now?
No, I'm not there now.
Last term?
I ended September last year.
Yes, all right. How many judgments have you produced at the SCA?
10 judgments.
And before that, in the other court?
Safely, I see the bar, I didn't look, but it's 265, but Safely only started in 2003, so before that, it's close to 400 judgments.
I see that you've also been active outside the legal sphere. You chaired the Veterinary Council of South Africa at some stage, for a long time actually.
Yes, I did.
And you're a member of the Appeals Authority of SAPS.
Yes. I did that while I was an advocate.
Mm-hmm. And all sorts of other involvements. What is the SSSBC, PSBC, and GPSSBC?
Those were bargaining councils.
Sorry?
Bargaining councils.
Oh, I see. Okay. All right. How did you find your acting stints at the SCA? Did you cope well with the workload?
Yes, I did. I didn't find it. Look, you work hard, but I didn't. I really enjoyed it. In fact, I learned so much, and I never had an outstanding judgment. The judges, of course, gave comments, and you learn through their comments, but the substance of my judgments weren't ever changed. The only problem happened when, in 2016, my husband passed away. The last judgment was in the last week of that term, and I still sat, and then Judge Shongwe kindly said to me, because we didn't have COVID, so we didn't really work by email then. But he said to me, go home, write the judgment, and we'll do it by means of email. And I went home, did it, and the judgment was out within the first 2 weeks after that.
Yeah, we realized just what a stoic you are during that period, because you're quite prepared to plow on and work despite your devastating bereavement.
Yes, it was difficult, I won't lie. Yeah.
You have always managed to have your judgments delivered on time. Do you have any reserved judgments now?
Yes, I've got one, which comes from 3 weeks ago when I had 14 opposed motion judgments that I had to write, and the last one is still outstanding, but it's halfway and it will be done before Monday.
So it's a fresh matter,
It's a
freshly
very
had matter.
fresh matter, yes.
All right, thank you, Judge Botterill. I'll hand over to my colleagues now.
Thank you very much.
Do you have any questions for the candidate colleagues? AP Betsy. Okay, go ahead.
Good morning, Judge Potter.
Good morning, Acting President of the
How are
ACA.
you this morning?
I'm well, thank you. And you?
I'm surviving, that's all I can say. Thank you. Yes, you've already told the Commission that you're close on to 15 years as a judge.
Yes. Yes, IP.
And that you acted at the SCA for 4 terms, you say?
Yes, IP.
And from the list which forms part of your bundle, you have written many judgments in the High Court.
Yes, IP. I have. We're in a busy division, so you write a lot of judgments.
And how did you find judgment writing at the SCA?
I found it very interesting because no matter how you had read the SCA judgments in coming to your own judgments, when you're writing at the High Court, there is a different style. It's shorter. You must get to the crux immediately without leaving anything out. So I learned a tremendous amount from all the other judges at the SCA. Identify the crux and then write. And then if you've identified the crux, you also normally write correctly because you're not flopping around with what is the issue.
The feedback which I received from my colleagues about your judgment writing skills is not entirely satisfactory in that most of the writers informed me that when it came to judgment writing in the SCA, you were not, as it were, cruising on your own. You needed much assistance from the other senior members of the bench, especially the presiders.
I'm sure that there were many comments, but I can, for instance, say that the Shelton judgment, which I wrote for Judge Lewis, and the judgment that I wrote for Judge Mapati, very little comment, and those are the 2 reportable judgments, came forth And those two judgments are often quoted in our courts. But I'm dead sure that some of the others may have said that they felt that they needed some comment here and there. And I took their comments to heart and accepted the comments where I thought that it was really, really necessary, and learned a lot from that.
And during your last acting stint, September, was it 2021?
Yes,
I too allocated you a judgment to write.
yes. In that term, I wrote 4 judgments. I was allocated 4 judgments.
You wrote how many judgments
4
in one term?
in one term.
How did it come about that you, as an acting judge of appeal, overloaded with 4 judgments?
I don't know. I was surprised, but of course I wasn't going to question it. But 2 of them, I must be honest, were non-reportable judgments.
Yes. And did you receive any helpful comments from the other members of the bench in the matter that I had allocated you, which, as it were, enriched your judgment?
I received comments from yourself. As I can recall, I received comments from Judge Mabata, and I can't recall from who else, and of course it enriched my judgment, and I accepted those comments.
Yes. Okay, let me leave it at that at this point in time. Thank you, Judge Potterell. Thank you, DCJ.
Thank you very much, IP.
Thank you very much, Deputy Chief Justice. Good morning to everyone, and good morning, Judge Potterell. I'm here.
I see you. Thank you, Commissioner.
My name is Sylvia Lucas. So first of all, let me comment on something that I have observed since yesterday. I think sometimes people come here and they expect us to treat them with kid gloves. Now you are applying for a very, very senior position. And I would expect the commissioners to be very tough on the candidates that come here. I want to commend your attitude on the way you responded to the question where negative issues was raised from others that are working with you. And I've noticed it's actually the woman that can take that kind of harsh questioning. Thank you, I like that. I like the attitude that you displayed. Because I know where I stand and I know what I'm trying to do for women in South Africa, and it's very difficult. Now my question, what is your view with regards to how the outlook of the bench generally is now, and with regards to transformation within the judiciary? That will be my question.
Thank you very much, Commissioner. It looks better, but it's not there. If you look at the statistics, if you look at the people appearing before us, let me first of all start with the people that are appearing before us. When I acted as Deputy Judge President, I had to call the civil roll. And it was really heartwarming to see that in that we have a big roll. I had like over 100 matters. So there's 2 counts on each side in 100 matters. So we sit in a big court. And it was heartwarming to see that more than half was black and at least half were women. And the women knew what they were doing. They didn't take nonsense. They fought their case. But what is not good is we don't see them yet in big matters. I don't know why. I know the minister has taken some steps for briefing patterns. I see women as a third counsel or a second counsel. But I think what must happen is that the senior must give that woman an opportunity to talk. Us in court, we don't mind if they split the argument. It often happens. So give them an opportunity to talk. Because it doesn't help they sit there and they're feeding the senior counsel, because they know what's going on in the matter. You can see it from the bench. They're telling them it's this page and it's that annexure and that whatever. So I'm unhappy that there aren't women doing the big matters, if we can call that. On the bench, our JP has transformed our bench very well. I think the white people are in the minority. The people that he's appointed is good people, and they are women. And some of those women were also here for the interview. So it's better, but it's not there. That's my answer.
So what do you recommend more? Should be done more? Besides briefing patterns, but I can hear you say they've got the potential. They just don't get the opportunities.
Yes.
So what is your proposal?
I think as far as the bench is concerned, I think if they implement again that aspirant judges training course, because from that a lot of people were appointed, so I think that will really help. They must continue with the training. There is training for attorneys, and there's at the bar training. So I think that must continue. So training is important. Also, the JP will know this, and I think he can support me in this, that whenever I sit with an acting judge, I will write to the JP and say, this woman has got potential, please call her again. This woman has got potential, please ask her to apply. I do so only when I've worked with that woman, but I do that on a regular basis.
Thank you. I just want to make a comment to say, I think you will agree with me that what we need in the judiciary is consistency.
Yes.
And that is what will be important. Thank you, CJ.
Thank you very much, Commissioner.
Thank you very much, Deputy CJ. Good morning, Justice.
Good morning, Commissioner.
Yes, the last time you appeared before the JSC was last year in April.
No, I've not appeared before the JSC in April. My last time was, I've never applied for the SCA post.
Is it for the first time you are applying?
It's the first time I'm applying.
Yes. Now, there is a big problem within the judiciary of briefing patterns, especially for women, black women. What is your view on that and how that can be improved, since in terms of your CV, you advocate for women emancipation and empowerment?
Yes, definitely. Women are good judges. I know that's a general statement, but as a judge, you need to organize. You need to be able, especially in a big division like us, where it can become overwhelming. So you need training, because judgment writing is not a skill that you come with. You've come from the bar, or you've come from the attorney's profession. So you may have drafted heads, but you haven't written judgments. So when acting judges come, you must help them with their judgments. You can't leave them on their own and say, oh, this is a bad judgment. So all of that I'm saying because training is absolutely necessary. We need to train people to do that. The briefing patterns, we can just keep on urging. I can say, why is this council not saying anything? But from the bench's side, there's not much we can do except say, please brief women, because we're not doing it. And when I train, which I do at the bar a lot, I say this. I say it over and over. And I do think that it's getting better. I just wish it would be perfect, and it's not perfect yet.
All right, thank you. Thank you very much, DCJ.
Thank you very much, Commissioner.
Commissioner Moimang?
Thank you, Deputy Chief Justice. Good morning, Justice Potero.
Sorry, I can't see you. Oh, there,
Side.
thank you, sorry.
Thank you, Justice Potero. My question relates to one of your judgments that impacted on the composition of the cabinet. I guess the Fireblade Aviation versus the Minister of Home Affairs rings well to you.
Yes.
Yes, because of the disputed facts from the minister that he did not grant the Fireblade an ad hoc facility or a port of entry, you came to a different conclusion. Was that not an overreach? Thank you.
No, I don't think so. I don't think it wasn't a question of me having to make a different decision. I had to decide whether, in fact, he had made that decision. So I don't think it was an overreach. And they did appeal, and the petition was not successful.
The basis for that decision, was it informed by the discretion that the court has in terms of resolving the matter where there are disputes of facts?
Yes. You do it then in terms of the Plascon-Evans rule, or which has now been, as the SCA, entrenched with NDDP versus Zuma and the Whiteley matter, etc. Yes, so you do it in terms of the Plascon-Evans rule.
Thank you, Justice Potero. Justice. Thank you, Deputy Chief Justice.
Thank you very much, Commissioner.
Commissioner Nyambi?
Thanks, DCJ. Morning, Judge.
Good morning, Commissioner.
Have you seen the objection by Mr. Masuku
I did.
alleging that you lack understanding of the law? What's your comment about that?
It saddens me that he thinks that. I don't know who he is. But I think he's, sorry, I'm under correction. Didn't he say I'm ill-treated, the public protector? Did he, sorry, I'll just have to look. Did he say I didn't have an understanding of the law? But I'll answer your question in that vein then. I do think I have an understanding of the law. I think my judgments speak for themselves. Of the 15 years, I could find 5 matters that the SCA had overturned. I couldn't find any more.
What is the difference between judicial independence and judicial accountability, if any?
Judicial independence means exactly that you are impartial, that you aren't influenced by anybody, and you look at the facts, you look at the law, and you apply them, and of course the Constitution is always part of that. That's judicial independence. Judicial accountability means exactly what the Code of Conduct of the Judicial Code of Conduct and the norms and standards say. In other words, you must be diligent, you must be impartial, you must be transparent, you must do your work diligently, you must apply the Constitution, you must try and be transformative in your judgments. That is judicial accountability.
My last question is about the acting stint as a JP in Gauteng Division.
As the DJP, deputy, yes.
Yes. If you can share with us your experience. coupled with your acting stint as a judge in the Constitutional Court of Lesotho?
Yes. Can I start with the Lesotho first? I enjoyed that tremendously. I wasn't alone. I went with Judge Musi and, oh gosh, now I can just remember his name. And it was really very interesting to do constitutional work there. We sat at the hotel, wrote the judgment together, and we did 2 or 3 matters against the president. So they get people from outside to come and do that because everybody there is just too close to home to do that. So that was very interesting, and we delivered the judgments. As the acting deputy judge president, it was a difficult time because it was just when COVID hit. We didn't have any computers. The computers we had didn't have cameras. The registrars had desktops that weren't compatible, but we managed to keep the court roll going. And in fact, I managed to go and look and draw statistics, and I just drew one statistic. And that statistic was that from the 5th to the 30th of October 2020, as the civil trial role, which was my main duty besides all the administrative work, I allocated 1,705 matters, of which 1,895 matters were RAF matters and 152 matters were non-RAF matters, and there were 58 removals by the parties. It also happened that because of the malfunctioning, sometimes matters weren't placed on the roll. We made WhatsApp groups so that the people could reach my registrar so that I could see if I could place the matter on the roll. And the matters that we couldn't allocate, at the end of each week, because if there weren't enough judges, I'd arrange with the registrar that in the next 6 months, 4 weeks were left open, and those matters were placed in those weeks so that the people could get speedy justice.
Thank you, Judge. Even though I thought that there's no president in Lesotho, I misunderstood you and said president of Lesotho. Thank you, TCJ.
Thank you very much. Thank you.
JP Mlambo?
No,
Thank you very much, TCJ.
sorry, JP.
Is it a follow-up?
Yeah, just on this one.
All right.
What do you mean by president of Lesotho?
Yes, I'm sorry. That was a miss. It was the minister that was in fact party to the proceedings. Thank you, Mr. Malema, Commissioner Malema.
I'm covered.
Thank you very much, TCJ. Good morning, Judge Potter.
Good morning, JP.
I just want to deal with the judgment writing experience. Before you went to the SCA, am I correct that you'd sat in a number of special motions and full court appeals in which you were the senior judge?
Yes, that's correct, JP.
And am I correct that you took a lion's share of those judgments? That is, you wrote them?
I do. If a judge offers, I will give them an opportunity. But as the senior judge, you are supposed to take the role.
Yeah. And in writing those judgments, am I correct that a number of them have been appealed against unsuccessfully and have been upheld up to the Constitutional Court?
Yes, that is true. There's only, as I say, 5 that I can find that wasn't upheld.
Yes. But this is a point I want to come to. Your judgment writing was that of a High Court judge. But when you went to the SCA, you found that judgment writing was a different animal altogether there.
Yes.
And you were prepared to learn and embrace the learning you got in terms of how you write SCA judgments.
Well, the first thing that you have to learn is that you're not writing for yourself.
Yes.
You're writing for 5 people.
Yes.
So that in itself is a different experience. And you've got to satisfy them, and because that is a national court, that the rest of the country, of course, excluding the apex court, looks to, it's got to be a superior judgment, if I can say that. So yes, you have to learn. It's not a skill that you have immediately, but I do think that I've conquered it and will conquer it completely.
Thank you, DCJ.
A follow-up, DCJ?
So, go ahead.
Thank you very much. Good morning, Judge.
Good morning,
I just want to follow up on that issue because it's something that really troubles me. That a judge will have 200 plus judgments from the High Court, and you get to the Supreme Court of Appeal. Suddenly, there is this view that perhaps your writing is not up to par, and you need to conform to a particular style. And we know that that style is not even consistent with the style of the Constitutional Court. I'm not really, I just want to understand this style of the SCA, shorter judgment, get to the, because I've read of late very concerning judgments from that court. What informs this view that if you write shorter, suddenly the judgment becomes of quality? Obviously, if you write longer, doesn't necessarily mean that it's quality. I just want to understand, what is this thinking at the Supreme Court of Appeal in relation to the writing of judgments? That when you get to that court, suddenly there's this style that we need to conform with. And for me, it seems like judges who are coming from the High Court, or certain judges that are coming from the High Court, suddenly when they get to that court, they appear not to be good enough because of this style. I want to understand this style.
I understand what you're saying, but I just want to say to you that when you get there, you're not treated badly. Or I wasn't treated badly. It's not as though they say, go and write it over. So they sit down with you in the conference. When we have a conference, it's not a situation of you feel like a complete idiot. I think it comes from them being able, after so many years, to write a good judgment concisely. Where we start off like, if I can say like you would write in an essay. When we start writing at the High Court, you sort of say who the parties are, what the pleadings are, what's the common cause facts, what's the problem, and where they condense all of that beautifully without having long-winded, unnecessary. And I'm not saying all long judgments are long-winded or unnecessary. Sometimes a long judgment is necessary. So I agree with you. But it's a certain style, and remember, it makes it easier for a High Court judge to read, because we've got to read their judgments, because we must conform to their judgments in that sense. So yes, it's daunting. You're right in that sense, because you after you've written so many judgments, you think you know, and then you come there and you don't. But it's a learning curve, and it's not a bad learning curve. It's a good learning curve.
Thank you very much, Deputy Chief Judge, but I just need to say this, but it is surprising that the very same judges of the Supreme Court of Appeal, they then get elevated to the Constitutional Court, and they start writing long judgments. Like, for me, it doesn't really make sense. Thank you.
Thank you, Commissioner.
Is that a question, Commissioner Professor?
It was just a
You're venting. Commissioner Matolo-Dlebu?
Thank you, dear Deputy Chief Justice. Good morning, Judge.
Good morning, Commissioner.
How are you?
I'm well, thank you.
Okay. Well, one of the things that I wanted to find out, I see that there was a comment that you are very committed to transformation. But I just want, everybody is committed to transformation, but I want you to tell us that you were self-employed practicing attorney advocate from 1998 to 2008. how many young black females did you take along? And how are you satisfied that you really, because you can't suddenly complain about transformation when you are a judge. Did you play your part when you are an advocate?
Yes, I did play my part, not only by means of training, but also, you can see I trained at everywhere. I find that because you get to know people and you can take people along if you train. Training is such a good basis. And because I wasn't a senior counsel ever, I couldn't always have a junior. Like, you know, I had to look at the bar rules. But wherever I couldn't do something, I gave to a black. I must admit at that stage, and I'm just going to be dead honest, there weren't a lot of black women. But I gave to a lot of black men. And if there was a black woman, I would give to her. The question about the transformation was about the Lawrence judgments, I think, from the SCA.
Thank you. A follow-up. The BLA has made a comment that one of your judgments, just trying to get to it.
Yes, it's the Lawrence judgment.
Yeah, the Lawrence, that it shows your lack of understanding and conscious of transformation. Can you just clarify that and please put my mind to rest?
Yes, I would do so gladly. What happened was, it was a matter which we had at the SCA. Lawrence was a white magistrate who had applied for a post and he didn't get the post. And he then asked for a review of the Magistrates Court Commission. I beg your pardon. It was really, for me, quite an important judgment to write at the SCA because it was the first time that I could see that there was going to be a judgment on Section 174, and specifically Section 174.2, which of course says that the judiciary must reflect race and gender. And of course, Mr. Lawrence does not do that. He's not race or gender in that sense. But the Magistrates Commission had a policy with criteria, which they had to follow to get to an appointment. And they did not follow that process, first of all. And secondly, of course, it's a constitutional imperative that race and gender must play a role. They made it the guillotine. So if a white person had applied, they just threw that person off the table. And that is what the judgment says. So the Magistrates Commission, the Constitutional Court has said, you can't not comply with your own process, you can't have a rigid system, you can't have a quota system. But the Magistrates Commission could have complied with Section 174 by just adhering to their own policy. In other words, what they would do, which would satisfy everybody, is put Mr. Lawrence on the table, because it was common cause that he was an excellent magistrate. He was training, he was helping, he was whatever. So put him on the table with other candidates, and then use Section 174 in brackets 2 and say, but he does not comply with race and gender, and therefore we cannot give him the post. So that is what was wrong. Judge Mola wrote a minority judgment on the Botshabelo post. She felt that the Magistrates Commission, if you read the record, didn't do that to Mr. Lawrence pertaining to the Botshabelo post, but did do it for the Pietersburg post. And she phoned me. We had a decent discussion, and I said to Mahubi, or Justice Malum, write and let me look at it. And when she did write, and when the rest of us looked at it, we disagreed with her because it was common cause on the facts that they used exactly the same process. The Magistrates Commission did not appeal this finding. Because I think that they realized they didn't follow their own process. And if they just followed their own process and used the criteria correctly, they could have gotten to the same result.
Thank you, Deputy Chairperson.
Thank you.
Thank you, Commissioner.
Commissioner Malema, your hand had been raised earlier. Do you still want to pose questions? Go ahead.
Thank you very much. Morning, Judge.
Morning,
There is
Commissioner.
this thing that you are the most preferred person when it comes to high-profile cases there in Pretoria, and where JP sits in those cases. If it's a full bench, you are likely to be part of that full bench. Is that correct?
Sorry, can I just rephrase? Are you saying that I sat on a lot of full benches with the JP?
Maybe let me start with the first one.
Okay.
There is this thing that you are the most preferred judge when it comes to high-profile cases, one. Two, despite the fact that there are more senior judges there, you'll always be picked for high-profile cases. And two, that you'll sit in the most cases where there is a full bench led by the JP.
Can I start with the second question?
Yes.
I sat in one full bench with the JP. No other full bench have I ever sat with the JP. So I don't think that's correct. I don't know. The workload is divided as follows. There's no preferences. The JP has a roster which he hands out the 2 weeks or 3 weeks before the next term. So you get a roster, and you allocate it according to that roster. So I want to say that except for the equal education matter, which I'd said to the JP, there's 3 urgent matters. We haven't got enough judges when I was DJP. I'll do one unless he can get me another judge, and we can do the others. I've been allocated according to the roster, not special circumstances. The only one, as I said, that I can honestly say was equal education, where I sort of offered because there just wasn't another available judge. You must also remember that urgent matters come in, which would be high profile. Okay, and they write to the DJP and they say, look, I'm issuing this, you must get me a full court, you must whatever. So we then write back to them and say, okay, that's fine, we'll try and see, and you're sitting praying, hoping a judge becomes available. We don't have extra judges. So by the time the matter is ripe for hearing, the DJP then phones the JP, and the JP, and he says, I've looked, no judges come free on the opposed motions, no judges come free on the third court matter. Can he free up somebody? And we often then go to the civil trial court because there we can free up somebody. So there isn't a preferential system.
Have you ever written a judgment for another judge in a matter where you are not involved?
No.
There has never been such a request?
No.
I see you were in the Transnet Group Tender Board.
I was what?
Have you ever been in the Transnet?
No.
Okay. Thank you, Deputy Chief Justice.
Thank you very much, Mr. Malema.
The alarm that just went off a minute ago was indicated the expiry of her 40-minute allocated time. So let's keep that in mind going forward. Commissioner Matthews?
Thank you, Mr. Good morning, Judge.
Good morning, Commissioner.
I think I've only one question.
We can't hear you, Commissioner Matthews. Just bring the mic closer to you.
All right, thank you, Tishay. Would you agree with me that the appointment of a judge in the High Court and the appointment at the SCA or Constitutional Court at least should apply different standards? In respect of the High Court, at least a candidate must have some potential, and then you move from there. But with the SCA, certainly it must be conclusive.
I would agree with that, Commissioner.
And therefore, in that exercise, your judgments are a consideration. That's where we should be starting from.
Yes, I agree, Commissioner.
I'm not too sure whether you have read this. I don't know what it is, whether you responded in the objection. The first one was what Commissioner Nyambe talked to the objection by Mr. Masuko.
Yes.
Then there is a second statement, which is from Melanie. I'm not sure.
I'm not sure who that is.
But you have read this.
I've read it.
And you had time to reflect on the issues that are raised. The allegation is that when you write judgment, you use harsh language, disparaging, and I mean, as it is said. What is your comment on that? That is, you use strong language to an extent that the higher court, the constitutional court, had to rebuke, has to express its concern about that.
Yes.
Do you agree that that did happen?
No, I don't know where that happened. I've never seen a constitutional court judgment where they addressed me on harsh language. I take note of the criticism. And in fact, when we had a Sajay training session, we spoke about it.
Yes.
Because it wasn't only me that was saying, they weren't only saying that I wrote hard. So you've got to take cognizance of what people are saying. Yes. It can't affect your impartiality. Yes. But you must look at what they say. And so we must, I think what one must do is read your judgment, put it down aside. Next day, take it and read it again to see if you think there's any harsh language. But the language that I was, as I understand it, what was said was that I had used the word nonsensical. And that word I grew up with. If you look at the case law in the SCA and even in the Constitutional Court, and I can quote the matters to you if need be, they use the word nonsensical. So I didn't find it harsh, but I take note.
Yes. Oh. Otherwise, you did acknowledge that, at least referring to nonsensical, whilst from your own perspective, you don't intend to sell, but
no.
Culturally and other people would interpret differently.
Well, now that you use the word culturally, I've in fact asked my colleagues, is there something culturally wrong with nonsensical? Now, most of them have said no, but one says to them it means you're nonsensing them. And I take that to heart.
And then, were you not involved in the reserve, were you not writing in the Public Protector and Reserve?
No, I was not involved in that at all.
Okay. Lastly, in terms of you seeking an appointment to the SCA, can you state what is your jurisprudence? What is your judicial philosophy? And how you have applied in your case law?
Yes. I think the Constitution has given us as judges a because remember, a judge is not a lawmaker. We can't write laws. But what you can do is you can develop the law. And the Constitutional Court, the Constitution, Section 39 in brackets 2, has given us a free hand within the pleadings and within what the parties have put before us to look to developing the law, developing, and even, I want to say, I always, when I'm writing, try and think of a rights-based law. In other words, what rights are here, not only precedent. And of course, I must follow what the Constitutional Court says and what the SCA says. But you can develop in between those borders, and you can develop a more rights-based. jurisprudence than just following precedent. And I think I've done so. I think I've done so in the Naduma matter, and I think I've done so in the equal education matter.
Commissioner Mokonish?
Thank you very much, Commissioner.
Thank you very much, Deputy Chief Justice. Good morning, Judge Potro.
Good morning, Commissioner.
I have 3 quick questions. The first one, what would you say to people who believe that the law is the weapon of those who owns the means of production to consolidate their power in society? Do you have some sympathy with that view?
Rich people can litigate, that is true, and they can use the best counsel, that is true. But they can't manipulate the law.
Are you done?
I'm done.
Okay. So you don't have any sympathy with that view?
I do.
Okay.
That's why I started off by saying, rich people have an advantage.
Okay. The second one, there is also a view that says the Supreme Court of Appeal, in terms of access to justice, is an unnecessary layer. It must be merged with the Constitutional Court. Do you have sympathy with that view?
I think if it can practically work, then yes. I just don't know. I've never acted in the Constitutional Court, so I don't know the workload. I assume that the extra justices will have to be appointed. So I just don't know the practicalities of that. But there is a lot of talk about that, and I've got no negative view or. The nice thing about the law and the functionaries of the law is that the law is never finished. That is why our symbol is not a round circle, because it's never finished. And so development will take place. And whenever that is suggested, I'm sure the powers to be, like two learned colleagues sitting there, will know how to go forward pertaining to that, whether it's wise or whether it's not wise.
The last one, in your experience as an advocate and a law lecturer, don't you think that there is something that I would call malicious compliance to ensure that people are perpetually trained and not much is being placed on sharing the cake in the briefing patterns, that as much as training is important, but it is being used to avoid to radically transform the legal profession in ensuring that people get the actual work, meaningful work, that people just use this issue of perpetual mentoring and training as a way of sabotaging transformation? I'm not sure whether I must repeat.
No, I did
Just
get that.
hold on just 1 second.
Thank you.
Judge Potro.
I'm happy it happened when Commissioner Magwanishi was speaking.
Why, Commissioner?
He knows. And all of them next to him know why.
Oh. Commissioners Bernard and Breitenbach, are you back with us?
To ask a question, please.
Oh, I was just checking if we had a blink, we were just load shedding. And I just wanted to make sure that you're still on the platform. Carry on, Judge Potteril.
Thank you very much. Training and not leading to a result means nothing. So I agree with you in the sense that training and mentoring must lead to active participation, and that we must ensure that.
Thank you very much, Deputy Chief Justice. Thank you very much, Judge Patrol.
Thank you, Commissioner.
Commissioner Pillay?
Thank you, DCJ. Good morning, Judge Patrick.
Good morning.
And just to follow up on the question from Commissioner Mahwanishe, I heard you answer your questions about the transformation of the system and the advancement of women. You did it in the context of women at the bar. You did it in the context of aspirant judges. And I just want to turn for a second to the experience of women after their appointment. In other words, I just want to touch on advancement within the ranks of the judiciary. Now, for me, it's a cause for concern that there are 15 heads of court positions, and not one of them occupied permanently by a woman. I think there's one position where there's an acting woman appointment, that's Judge Meer. But apart from that, the positions that are occupied, and I think there's one or two that are not occupied, but the positions that are occupied by men. Mm. Now, that raises the question as to what are the obstacles to advancement for women within the judiciary, and why is it that we're not seeing women fill these crucial positions of leadership within the judiciary?
Yes, you're right. I mean, it's glaring that there is, except for Judge Meyer, just nobody. I am thankful to see that for some of the posts now, which are DJP posts, at least they are women, and I'm sure they'll get it. So there's a start. But I think there must also be leadership, because leadership courses, and I think we must suggest that to Sajay, because what happens was, I think, I'm sorry for the men here, but I think women have a natural ability to organize. And I'm not saying men don't, but a lot of women, so that we've already got that. But I think you're so trained in the law that I think we must put ourselves out there for leadership. Because I think we're so trying to prove ourselves as judges that we're not even thinking of leadership roles. But I see that when we now have conferences at the IAWJ, people are talking about leadership. We need to fix this, because I'm sure we'll be able to fix this. So I think I'm so glad you raised this question, because I think we must put ourselves out more for leadership. I don't think the women are putting themselves out for leadership. And there's now enough women who has experience that can really do that. Perhaps 10 years ago, women didn't have enough experience, but now there's enough women who has experience to do that.
Thank you, Judge Patrol. And you see that touches in with a point raised by Commissioner Mahwanishe, which I wanted to raise with you. It answered to one of the questions around transformation. You said that there needs to be more training. And I have a very great concern with the narrative that women have to be trained, because inherent in that narrative is that there's a lack of opportunity for women at the moment because they're not up to the task, because they're not equipped for the task.
I hear what you say, and that is a problem. But if they're not getting briefed, so they're not getting practical experience, at least the training is a substitute. So I hear what you say. It means as though, women need training and men don't. But at least that gives them a foot in the door, I feel, versus because they're not getting briefed, or they're not getting, so I think that's the purpose of training. But I agree with the other comment. Training per se is not going to help if it doesn't lead to a result.
And what that leads to, Judge Patrol, is at some point, us as women and society as a whole, we need to start dismantling and exposing the system for what it is. We need to grapple with the elephant in the room. Why aren't women accessing the work? Why aren't women accessing leadership positions? And the reality, unfortunately, the stark answer is there's just a lack of political will. No matter how much women are equipped, no matter how much they are trained, no matter how much of experience they are simply unable to access these opportunities. And then the big question is, how is it that we grapple with that elephant in the room, with the lack of will out there? It's really men clinging onto power and perpetuating that power as they go forward.
Yes, I agree with you, but I'm very confident that we'll get them off their thrones.
Thank you, DCJ.
Okay. Thank you very much, Commissioner.
Go ahead, Prof.
Thank you very much. Judge, I just want to talk to you because I've had occasion of reading several of your judgments. And quite frankly, I find the judgment that you wrote at the High Court way much better than the judgment that you wrote at the Supreme Court of Appeal. And I will explain to you why. I will explain to you why. There is a matter where you appeared, Smith versus Kleinhans.
Yes.
You remember that matter?
Yes.
In this matter, I think you arrived at the right conclusion, where you came to the assistance of Mrs. Smith. But the reasoning leaves much to be desired in this way. In that matter, the issue was re vindicatio, as I understood it. It is not clear on the judgment what then should be proof of ownership where there is an installment sale agreement in order for you not to be able to claim your property from the person who lawfully possesses it. And the judgment is relatively short, of course, but you reject the fact that re vindicatio is applicable here because ownership could not be proved. But in the judgment, we don't know why ownership could not be proved. There's no an explanation of why re vindicatio under these circumstances is not applicable. And I think that particular explanation is important. There is this perception of people saying judgment must be short for the parties. Judgments are not written for the parties. In South Africa, judgments are written for the public. The outcome is important for the parties. But the judgments are important as teaching tools as well as university. So when I'm confronted with a judgment like this and I'm teaching property law, I'm unable to assist my students to understand why I say the outcome is correct, but I'm saying the reasoning is wrong. I'm not sure, do you have any view then?
I haven't got the judgment with me, but I do recall it. And I'm now going to be under correction from you.
Yes.
Because I haven't got it in front of me. But as the claimant could not come with the re vindicatio because in terms of the installment sale agreement, she's just the bona fide possessor. The bank is still the owner of the vehicle. So the re vindicatio is not applicable. So the question then was, what stronger right did she have to possession of this vehicle than the respondent in those circumstances?
You are right, but that reasoning doesn't come out in the judgment. That's where the problem that I'm trying to raise. That's why I'm saying that the conclusion is correct. Thank you very much. Thank you, Deputy Chief Justice.
Thank you.
Any questions from the virtual platform colleagues?
Please, Acting Judge present, but Mr. Bonner can go first, it's fine.
Okay, go ahead.
Thank you, DCJ.
Just look at the TV screen in front of you.
See.
Judge.
Thank you.
Yes, good morning.
Good morning, Commissioner.
Morning, Judge. The commissioners might, I'm going back to the Lawrence matter, so commissioners might easily be tempted to focus on the section 174.2, you know, the need for the bench to reflect the race and gender composition of South Africa, and use it and exclude category white males or other category of race and gender. But the Magistrates Commission versus Lawrence matter, you dealt with the dangers of this. Which mistakes would you say the JSC in these interviews should avoid Particularly in these interviews and the SCA posts, there are various white males and females that are applying, and there's 11 posts, sorry, 5 posts, but 11 candidates. So what are the dangers that we should avoid, or the mistakes that shouldn't be made if you think back into the Lawrence SCA judgment?
Well, I'm most certainly not going to prescribe to the JSC commissioners how they should come to a conclusion. And they've got the constitutional imperative to look to race and gender. So if I use myself as an example, they can put me on the table if they think I have the competence and I have the experience and I've proved myself. And then they must look, okay, gender perhaps, but race not. And then they must apply that whether in their circumstances a white woman is acceptable or not. But I'm definitely not going to prescribe to the JSC commissioners how they must come to a conclusion.
Thank you very much. And the specific mistake made in that matter, what was the problem with the Magistrates Commission?
What they did is they simply did not consider any white candidate.
Thank you very much. Thank you, DCJ.
Commissioner Bredenbach.
Thank you, Justice. Good morning, Judge Potro.
Good morning, Commissioner.
You'll agree with me that ethics, courage, and integrity are important attributes in any judge.
Yes.
And I would like you to explain how you think these attributes manifest themselves in the way you conduct yourself on the bench.
Ethically, transparency.
The end. But before we let you go, I just want to say something, and I don't mean to irritate my colleague, Professor Marumo Akai. It pertains to the concern he raised twice with you about the SCA's judgment writing style. And what I liked about your response is how you described it. And I'm going to sum it up in my own words, that you learn to identify the real issues in the dispute with precision. You get rid of the clutter and red herrings and produce an opinion that is written simply, whilst keeping everything in, all the substance, but it's written simply in simple language such that everyone, anyone who reads it can understand it and read it to the end without getting tired. Did I sum it up properly?
Perfectly, and that is a skill.
It is very difficult to write like that.
It is a skill.
Is there anything you would like to ask of the Commission before we let you go? All right. Thank you so much for presenting yourself to the Commission.
Thank you very much.
You're excused.
Thank you very much for having me.
Good morning, Judge Smith.
Good morning,
Are you ready?
Deputy Chief Justice and Commissioners.
How are you this morning?
I am fine, thank you.
Good.
As fine as could be.
Don't worry, we'll handle you gently.
Thank you. Thank you for that.
You were born in Herschel.
Yes, I was.
Did you spend any time there?
Not, we left, my family left when I was still a baby, but we go back often on pilgrimages, family pilgrimages, and go and look at where we grew up and ran around. Yeah.
Well, my family is originally from there, and I remember it as one of the coldest places in South Africa.
It is. You definitely don't want to spend winter there.
Nah.
Yeah.
You have a BA Law degree from UWC, an LLB from Rhodes, and a diploma in labor law from UCT. Is that right?
That is correct, yes.
And you did your articles of clerkship with Mdlalana attorneys?
Yes.
In the early 80s?
Yes, I did, and I was there with my two future partners, Tabata and Van Heerden, and we all did our articles with the Templeton and Mdlalana attorneys. Yes.
Oh, is that where this liaison was initially formed?
Yes.
I didn't know that. And you were an attorney with that firm of attorneys from 1984 until 1996. Is that right?
Yes, that is correct, yes.
And then there was a break. You became an MP for
yes,
an
that
ASMP for 2 years?
That was about 18 months or so before I came back to the legal practice again.
The lawyer in you kicked right back and you came back.
But tail between my legs and begged my partners to take me back.
And you were with that firm until 2020? Sorry, 2010?
2010, yes, when I applied for a permanent position, yes.
And when did you become a judge? Then?
In 2010, yes. I think it was in July 2010.
In which division?
In the Eastern Cape.
In Grahamstown?
In Grahamstown, yes, Makanda.
All right. You have acted at the SCA for a few stints. Just remind me how many times were they?
I started, I think it was 3 terms. I started in October. October last year until May this year. So 3 terms.
How did you find your time there?
It was challenging, Deputy CJ, different, very different from how things work at the High Court.
How so?
You need to, first of all, there's a lot of reading to be done. I nearly had a heart attack when they delivered all the boxes containing the records to my home, because when I started initially for the first term, it was everything was still being done virtually at the time. So all these records came, and you realize now it's now time to read everything, and you need to find your feet very quickly and work out a system, how you're going to manage your time, which record you're going to read, and by what time you need to finish with a particular record. So you need to plan very quickly, otherwise you're going to be sinking. And one of the Supreme Court judges who hail from the Eastern Cape also advised me that, you read your record first time, you make notes in all the matters where you will be sitting, whether you are the scribe or not, because you're going to be required to make contributions, you're going to have to be prepared for the hearing, and you will have to engage with counsel, and after the hearing, there's going to be a post-hearing conference where your views will be elicited, and you need to be able to make a contribution. So it dawned upon me very quickly that I need to work out a system for myself, and I need to plan so that I can be prepared when the term starts.
Did you get an opportunity to write judgments?
Yes, I did. I think I wrote 5 judgments in all. There was one, it was going to be 6 judgments, but there was one matter where Judge Piet Meyer and I were going to be scribing together because it was a complicated matter, long matter involving liquidations and business rescue proceedings. And what happened was that during the course of argument, the point on which I was going to write was conceded. So unfortunately, then it was not necessary for me to write, and Piet was then just wrote the judgment by himself.
After all the reading you'd done?
After all the reading and preparation that I had done.
Did you struggle to write judgments? How is your judgment writing, your judgment writing skills?
I don't think that I struggled. It was different because, of course, I was told at the very first opportunity, I was told that you don't write just for yourself, you write for the court. So it is very different, but the style of writing appealed to me immediately when I was given what is called the style guide and became aware of what is required from me. I took to it immediately because I have a particular way of writing my judgments. It is sort of encompassed in an article that I wrote at Madlanga Jay's request for the CJ Journal, which is entitled The Case for More Accessible Judgments. And there's a number of the things that I personally mentioned and advised readers on how to approach judgment writing that were told to me at the Supreme Court of Appeal, that this is how things work here and this is what is required of you. So I think, of course, the judges who sat with me and the presiders, and in cases where I sat, would be better able to to judge my judgment writing and whether the drafts which I presented to them were, in their view, good enough. But I thought that I did okay. I like judgment writing. It's the part of being a judge that I enjoy most.
Well, it is the core function of a judge, after
Absolutely, yes, I enjoy it. And I enjoy it even more if I get a draft out immediately, and that's one of the core issues that I also mention in my article, that if you want to enjoy judgment writing, make sure that you do get a draft out immediately. Otherwise, you're going to put yourself under pressure, and then mistakes and omissions will creep in. So I try to do that, and in my experience, it has worked well. Gives you an opportunity after your first draft to let it stew a bit, so to speak.
Yeah.
And then you look at it again, and you can look at it with fresh eyes. So that is my approach. And I also, unlike some of the judges that acted in the SCA, where they thought that the judgments are, shall I say, extraordinarily concise. To me, I didn't get that impression. The impression that I did get was because when you get to the Supreme Court of Appeal, issues would have been ventilated in the court below, There would have been points that had been taken in the court below and on which a judge would have had to pronounce. There would have been a set of facts that may have been relevant to pronouncements or findings made in the court below, which are conceded an appeal or not pursued with. So then it is not necessary for you to go into all of that. You then just concentrate on the issues that has to be decided, the facts upon which those issues are founded, and the law that you have to apply, and then you take your decision. And I do subscribe to the belief that anything more than that, you are waffling. If you say more than you need to say, if you have set out the facts, you set out the law, you apply the law, you deal with the arguments for and against certain points, then you make your findings, and then that is it. So I found that at the Supreme Court of Appeal, that is what happens, that you are required to concentrate, first of all, on the facts that are relevant. You are required to summarize those facts, and it takes a lot of work. Prolixity is easier than concision.
Yeah.
Takes a lot of work to concisely summarize only the relevant facts upon which you're going to base your conclusions and findings, and also to steer away from whole-scale importation of quotations. It's very seldom necessary, just by way of example, it's very seldom necessary to quote the notice of motion when there's a long paragraphs on relief. It's not necessary to quote the entire notice of motion. It may be necessary in certain circumstances, but in most circumstances, a short paragraph that encapsulates the relief that is being sought, and the same with regard to quotations from other cases. If you quote, whole-scale importation of quotes makes for prolixity. Sometimes you cannot avoid it. Sometimes you want, because it has been set in a particular way in their judgment, and you want to repeat that, you do that. But often you can read the judgment, read the portion that you want to rely on, and summarize it concisely and in simple terms for the reader, so that he or she can understand what you're saying. It also makes your judgment less intimidating if you do that. So what I'm saying in a roundabout way, Deputy CJ, is that I immediately liked the style of the SCA, and I've tried from my first judgment to comply with that style, and I hope that I was successful in doing that. But I must admit, it's a very steep learning curve. It is different. You need to work hard. You are under pressure because your judgments are scrutinized by 4 other fellow judges, who are, at least 3 of them are far more experienced than you are. So very intimidating, but I found that if you work hard and if you apply yourself, I think you should be okay. Obviously, you'll get better the longer you're there, but I do think that I was able to overcome that first hurdle.
And did you get good feedback from your colleagues there, especially the senior ones?
I did.
On your work, that is.
Yes, I did. In most of my judgments, there were like comments and suggestions. I don't think that they were issues of substance, in that they fundamentally would change the core of my reasoning, or the application of the law. Some of these comments were, wouldn't it be better if you put it that way? And you look at it and say, well, I didn't think about that, but it actually does sound better, and it would make it clearer for the reader if it's put that way. So, yeah, there's been some comments, and obviously you often make errors also, the spelling errors that creep in, and no matter how many times you read it, they will be there. And it's good to have other judges to look at it, because what also, especially when we went back physically to the SCA, it's a bit intimidating when you sit there in the conference, when you've presented your judgment, and it's literally scrutinized and taken apart sentence by sentence. So if you go through that process, the first time it's very daunting and intimidating, but if you go through it, you gain, especially if the first time you hear the comments and you think, oh, well, okay, at least I didn't completely miss the point here. I'm making sense to my colleagues and they agree with me, then you get a bit more confident.
Were you able to deliver your judgments in time, promptly, that is?
I think so. I don't think there was any of the judgments that were out of time. There was one occasion when the acting president here gave me a heart attack when he wrote to me, or rather his secretary, I think, wrote to me and said, look, it's almost a month now and there's no draft yet. What is happening? And I looked at it and I thought, oh no, they forgot about the fact that the case didn't proceed on the date that it was supposed to proceed. It was actually 2 weeks. In fact, it was just on the last day of my acting appointment, right at the end of the term. So yeah, after that, fortunately, didn't hear what I was saying, but
I'll be sure
but
to
that
tell
was
you, though.
but it was in time also. So I cannot recall. I think all my judgments were delivered in time.
All right. I'm going to hand over to my colleagues to put questions to you, and I have just a small piece of advice to give. Try to keep your answers as short as possible. Otherwise,
Sure.
you'll find yourself sitting in that chair for hours.
Yes, I'll do that. Thanks, CJ, for the advice.
Okay. Do you want to go there? Go ahead. Okay. Go ahead, Prof.
Thank you very much, Deputy Chief Justice. Good morning, Judge.
Good morning,
Yeah,
Commissioner.
still good morning. I've read all the 6 judgments, I think 5 actually,
Yes.
that you authored in the Supreme Court of Appeal, and 2 were most concerning to me. The one dealing with trademarks, where I think the presider there was the Deputy Chief Justice, then President of the court at the time. I'm not sure you remember that case.
No, I think
You don't?
dealing with trademarks.
Yes.
No, I didn't. I didn't write such a judgment, Commissioner.
Yes,
What
the
is
parties are Cochrane Steel Products versus Jamulu. It says here, Mayor AJA. Oh, it's Smith. Oh. No, I'm sorry, Deputy Chief Justice. I'm sorry.
Who did you think you are questioning, Commissioner?
No, I'm sorry. No, I'm sorry.
Yeah.
The one that you
I am relieved, Commissioner.
No, I'm sorry.
because-
The one that you wrote. No, I'm sorry. Yes, you are quite right. The one that you wrote is Municipal Employees Pension Fund versus Modal.
Yes.
Yes. That's the one that actually I want to talk to you about. I'm sorry about that, Deputy Chief Justice. This is an important judgment.
Yes.
Because the issue here was whether a retirement fund can amend its rules retrospectively
Yes.
to affect accrued retirement funds. And the pension funds adjudicator said, you cannot do that. The Court of Code said, you cannot do that. The full bench, 2-1, the majority said you cannot do that, and the minority said, well, you can. In your judgment, you said that, yes, retirement funds can actually amend their rules, which is true, they can, in terms of the Pension Funds Act, retrospectively. But the question that was alive was whether accrued benefits can actually be reduced if the amendment was not approved and registered by the authority, the FSCA. Are you with me?
Yes.
Yes. Now, in this judgment, my challenge is you do not refer to the Interpretation Act, Section 12, which actually has the answer, that you cannot amend to affect accrued rights. You don't deal with that in this section. But most importantly, you appear to have overturned a locus classicus, Musteri. I'm not sure you remember that judgment.
No.
On the same matter, which was referred to by the adjudicator, was referred to by the court of co, was referred to by the full bench. But in your judgment, you don't even refer to it, but you overturn it. Because in that judgment in Mustad, the Supreme Court of Appeal said you cannot amend your rules retrospectively to impact accrued rights. Well, you can amend retrospectively, but not to impact accrued rights. I'm not sure, what is your comment on that? Because I find this judgment quite unfortunate.
I'm not sure. First of all, of course, I wrote the judgment and I came to that conclusion. But not only I came to the conclusion, it was the entire bench that came to the conclusion.
Yes, that's where the problem is.
The issue is simply that retrospectivity, by its very nature, affect pre-existing rights. Otherwise, you can never have anything operating retrospectively. It doesn't mean anything if you say an act operates retrospectively, but it cannot affect rights. It simply means that it is then prospective. And I think that is the basis on which we dealt with it. And I think what you're referring to is that there is a very strong presumption against retrospectivity, and for good reasons, that you cannot just willy-nilly interfere with existing rights. You're right about that. But the fact of the matter is that if either the legislature or any institution or organ of state is vested with the power, has that power to make a rule or a law retrospective, it's going to affect existing rights. But it needs to be clear. And we said that unfortunately for Mr. Madau, and it wasn't as if we were unsympathetic to his plight, we said unfortunately for him, the rule was very clear in what it sought to achieve. But that's how we saw it, and that is how we called it, and maybe the matter will go to the Constitutional Court and they will look at it differently.
Yes.
But fundamentally, as I understand the law, as I say, just to summarize quickly, yes, strong presumption against retrospectivity for good reason, but where the law is very clear that it has retrospective effect, then the courts must give effect to that particular clause.
No, thank you very much. I just want to refer you to the law that you say it's clear.
Yeah.
Section 12(2)(c) of the Interpretation Act says, where a law repeals other law, then unless the contrary intention appears, the repeal shall not affect any right, privilege, obligation, or liability acquired, accrued, or incurred under any law so repealed.
Yeah, but just go back, just reverse back and just read the first portion of that, and your answer will be there, and that's exactly what I was trying to explain to you. Unless the contrary is clearly evident from the law itself. So you have to interpret it and have to ask yourself, is there a clear intention here to interfere with existing rights?
But again, sorry, Deputy Chief Justice, if you can just be patient with me, because I think this is important. I'm going to try to keep it short, but if I just beg for your indulgence, because really this is has really impacted a lot of members out there, so I just want to deal with it. Yes, the law that is applicable is actually Section 12, 1 and 4 of the Pension Funds Act. And when you read that section quite clearly, it allows for retrospective application of the law, but it does not allow for the retrospective impact on accrued rights. And that's where the issue is. And before we debate that, I want to take you to Musted, where actually the Supreme Court of Appeal deals with this issue. And I would have expected that even if you have a strong view on it, at least what you will do is you refer to Musted and you tell us as to why it is wrong and why your approach is right. And that's what I'm taking issue with you. Because that particular judgment, it clearly states that you cannot impact. In fact, it deals with the Interpretation Act, it deals with Section 12, 1 and 4 of the Pension Funds Act. It deals with it, and it explains to us in that context, in the context of rule amendment, you can retrospectively do what you are doing, but you cannot impact accrued rights. But in your judgment, you overturn that judgment, you and your colleagues, of course. You overturn that judgment, but you don't refer to it. And you don't tell us why it is wrong. That's what I'm taking issue with.
Yes, no, I understand what you're saying, but I don't have that case before me now, but I can say with a great deal of confidence that that judgment cannot say what you say it says, because you just read the Interpretation Act. It would be anomalous for there to be a provision for retrospective enactment of legislation or a rule or anything. But you say it's going to be retrospective, but it's not going to have any effect. With all due respect to me, it just does not make sense, and I do not believe that the judgment can say that. Our law has always been strong presumption against any legal instrument that purports to interfere with existing rights, but where the context and on a proper interpretation, applying accepted canons of construction, if it is clear that that is exactly what was meant, then it must be unless there is a challenge to that particular rule, a challenge that says it is unconstitutional because this is the consequences, but before us there was no such challenge. So the constitutionality of the rule was never an issue. And I'm with you, there may well be an argument to say that if it is implemented in this way, it is going to have these unfair consequences and impact on the rights of existing rights of individuals. But we were just required to interpret the provision and to decide whether by a proper reading thereof it has the effect of retroactively interfering with rights. And it was very clear that that was exactly the purpose, because that is why it was done. So unfortunately, we couldn't come to Mr. Mdao's assistance.
Thank you very much, Deputy Chief Justice, but it's unfortunate that you did not even refer to the case, that you say you think. But anyway, I will leave it there.
Yeah.
All right. Commissioner Lucas?
Thank you very much, Deputy Chief Justice. Good morning.
Good morning, Commissioner.
Judge Smith, you see me now. You are not afraid anymore.
Can you please just maybe
you
sit
are
closer?
not afraid.
I can't.
You are not afraid anymore because you see me now.
Yes.
So I was going to ask you the same question that I asked the previous candidate.
Yeah.
And that is with regards to what is your view with regards to the transformation of the bench and also the outlook of the bench as it is currently. But I want to go further and ask you a question that I think Honorable Advocate Pillay asked it before now, is do you also believe that women with the same training and the equal qualification still needs to be developed more before they can qualify to become a judge. I'm just adding it to the issue of transformation and the outlook of the bench.
Yes.
Thank you.
Do I understand your question to be that is it necessary for women to be developed more to become judges, even though they have the same qualifications and same experience as their male counterparts?
Or should I put it like that? Do you think with the same training and the same qualifications as yourself, any woman with that kind of background is on the same level as yourself to be appointed as a judge? I'm putting it very simple.
Yes, no. No, of course, the answer, Commissioner, is of course a woman must be entitled to be considered on the same basis, and accepting also that if you have regard to our patriarchal society and domination, and how women have been treated in the past and discriminated against, then one must accept there is a need to put measures in place to level the playing fields. But a lot has been done, but clearly we are not there yet. So I have to concede that in a situation where the requirements of demographics and representativity of a court requires the appointment of a woman, then I must yield to that. Unfortunately, that is the reality. One can hope, if you come here, that there being 5 positions, that you can be accommodated without the Commission having to compromise those important considerations of representativity and demographical makeup of the courts. I hope I've answered your question, Commissioner.
And your general view of the outlook of the bench in terms of transformation, just your view, and how do you see, how can we really reach equality or equity in terms of making sure that transformation is really a living imperative within the judicial?
Yes, thanks. Thank you, Commissioner. Yep, I can only speak from an Eastern Cape point of view, knowing what is going on in the Eastern Cape. And the Judge President of the Eastern Cape has gone out of his way to invite women to act. On any particular term, there would be more women than men, or there would be equality. But the outlook in that particular division, if I have regard to women who have been acting there, who are clearly ready now to come to this august body and present themselves for appointment, I am encouraged. It's a bit more difficult for me to make a comment from a national point of view, but I can only speak parochially about the Eastern Cape, and it looks, the outlook is encouraging, if I can put it as high as that.
Yes, we are speaking about women, but also generally in terms of representation on the demographical spread, generally, if you speak about race, if you speak about gender and all of that. What is your view?
I think, first of all, it is a constitutional imperative that all bodies, I'm talking about organs of state or other bodies which are really governmental bodies, must make sure that that constitutional imperative is implemented. And where, as is in the case of women, for example, there has been a history of oppression and pushing aside isolation and all those things, then measures need to be put in place to enhance opportunities for women So I'm talking about affirmatively making sure that, that the playing fields are leveled in all those respects. To me, it is a constitutional imperative, and it just must be done. Whether there are certain sectors that like it or not, it really doesn't matter. It's something that needs to be done. And we all know that while there's clearly a lot has been done in this regard, but we are clearly not there yet. One cannot deny that, so a lot more has to be done. But I am encouraged because I can begin to see the seeds of these measures being implemented. And as I say, I can only speak from the Eastern Cape High Court point of view, and already if that is representative of what is going on in other parts of the country, and I don't have any reason to believe that it is not, then I think we're in a good place so far as that is concerned.
Thank you. Thank you, TCJ.
Thank you, TCJ. Good morning, Judge Smith.
Morning, sorry, I lost you a bit.
I think I'm partly covered by Commissioner Lewis here, but I just want you to share with us as to what is it that you as an individual have contributed in seeing that women are being assisted in getting work or assisted in being empowerment while you were still an attorney in your law firm?
Oh, yes. Now, at our firm, we had a policy of making sure that we employ young women as candidate attorneys. We have produced, I cannot even tell you numbers because there's been so many of them that has gone through the firm. And it was a deliberate policy which we implemented, and even though initially there was some resistance in the firm when we were doing that, because obviously there were some people that wanted family and friends to be appointed, and when we preferred women over them, they were a bit unhappy. But those objections and concerns vanished very quickly when they had to concede that the appointments were good ones, that they covered themselves in glory, all of them, that they didn't have to stand back for their male counterparts, and they acquitted themselves with distinction. So yes, we have done the firm. I can't say ever since I left in 2010, but while I was there, many of our products, if I can say that, or protégés, have gone on to become magistrates, and some of them are successful advocates today, and some of them have their own legal firms. So we're very proud of that achievement.
Okay, thank you, Judge Smith. Another question that I'm having for you as a judge, what assistance are you giving acting judges, particularly women, to be better judges?
No, I think in the Eastern Cape, with the leadership of the JP, it is a policy that we go out of our way to assist not only women judges, but all judges, all acting judges, particularly those that come for the first time, because we know how daunting it is when you become a judge for the first time, when you act, and you are a bit bewildered. So we do go out of our way to give them all the assistance that we can. The one thing that you can do, that you cannot do, sorry, is to write judgments on their behalf. They have to do it themselves. But where they come, we make it very clear that give them all the assistance, and if they come to you for advice, you give it and try to assist as much as you can. And it becomes clear very quickly which of those acting judges are going to go on and become permanent judges and be very successful in the future. So it is a fulfilling exercise to be able to do that when you're generally, my experience, not only myself, generally my experience is that all the senior judges enjoy doing that. They go out of their way to do it. And I don't know if there's ever been any complaints to the judge president that they have been treated badly.
My last question, Judge Smith, you were born in the Eastern Cape and you were raised there. I assume that now you understand isiXhosa very well.
Yes, I do. I must admit that my understanding of isiXhosa is very basic, which is a bit of a I won't say embarrassment, but I should have done better because I grew up with friends who were Xhosa speaking, and instead they all learned to speak Afrikaans fluently, and I was left behind a bit. But I understand.
Okay.
Other members of my family are fluent in isiXhosa.
Okay, what is your thinking on the notion that judgments must be written at least in one African language?
Oh, I agree with it. I can just imagine I referred earlier to the article that I wrote in the CJ journal, and of course the core message in the article was that judgments should be accessible, and what can be more accessible than being able to read a judgment in your own language? So I think it's a good idea. I know that the deputy CJ has written a few judgments, and the idea that litigants, or shall I not say lay people, but non-lawyers are not interested in reading judgments I don't subscribe to that idea. I don't think it's true. People want to understand. If a case especially if a case goes against them, they want to understand the basis of the pronouncement, and if that can be expressed simply and in the vernacular, all the better. So I think it is a good idea. It's still. I was born Afrikaans speaking, but it's still surprising how many judgments you would still find in Afrikaans, when in fact there's none in isiXhosa, for example, that come before us, at least in the Eastern Cape, where you expect those judgments. Unfortunately, I will not be in a position to produce such a judgment myself, but I think there are judges, and I think the idea has been born, and I'm sure that soon you're going to find many judgments written in isiXhosa.
Thank you, Judge Smith. Thank you, DCJ.
Thank you, Deputy Chief Justice. Good morning, Judge Smith.
Good morning, Acting President.
Would you care to remind me when you were invited to come and act at the SCA for the first time?
It was in October last year, CJ.
Thank you. And you will recall that I gave you a call and we had a long chat.
Yes.
About the do's and don'ts, what would be required of you.
Yes.
and the practices and conventions of the SCA.
Yes.
And I strongly recommended to you that you should ask your secretary to send you a copy of our style guide.
Yes.
And that style guide has an addendum to it, which is a template for SCA judgments.
Yeah.
At this point, I want to refer you to your judgment, Municipal Employees Pension Fund,
Yes.
but for a different reason.
Yes.
It's at page 16 of your bundle.
Yes.
It's one of the judgments that you...
Yes.
Yes. Are you there?
Yes, I am.
And if you look at page 2 of that judgment,
Yes.
just below the 2 transverse lines order,
Yes.
then first of all, it shows or indicates where the appeal from which court it emanated,
Yes.
and it gives the name of the judges,
Yes.
but nowhere does it indicate whether those judges sat as a court of first instance or as a court of appeal. Do you see that?
I see that, yes.
And yet, this is what you would have been told or seen by reading the style guide.
Yes.
And if you turn over to the next page, paragraph 1 of your judgment, the last sentence. Perhaps even before I pose my next question to you, shall we settle this? Those 3 judges sat as a court of appeal, that is the full court. They constituted the full court.
Yes.
And in paragraph 1, the last sentence says, the appeal is with the leave of this court. Meaning the SCA.
Yes.
Was that factually correct?
I cannot, I must confess that I cannot recall, Deputy President.
Because the appeal emanating from a full court, Section 16(1)B of the Superior Courts Act tells us that it can only go to the SCA by virtue of special leave, which can only be granted by the SCA.
Yes.
And that was lost on you.
I don't understand. Are you saying that it should have stated that this is with the special leave of the
Yes,
of the appeal court?
because that was what it was.
Yes.
And that was lost on you, as is apparent from your judgment.
Yes.
There's one instance when one of your judgments delivered which had to be recalled a day or two after its delivery. Do you recall that
Yes,
incident?
I do. I do recall that, yes.
And would you enlighten this commission as to how that came about?
Yes. What happened was that I think that was the cornerstone. That was the cornerstone judgment, and if you have regard to that judgment, you will see that there was a plethora of different companies involved at different levels, and I think the mistake came in when a reference was made to one of the other companies. But if you had read the paragraph in context, it would have been clear that this was just a mistake. It was a typographical error that crept in. And I think it was Judge Govan who drew it to my attention. And we immediately, with the acquiescence of the presiding judge, we decided we're going to correct that. That is the circumstance under which that happened.
That mistakes and the elementary ones relating to your municipal employees pension fund judgment, are they not indicative of the fact that you pay less attention to detail?
No.
On issues that matter?
No, Deputy President. I pride myself that I am a person that I'm meticulous in writing my judgments. I think an overview of my judgments, including those that I have penned at the Supreme Court of Appeal, will testify to that. Mistakes do creep in. I have had a look at many reported judgments where there were obvious errors in the judgments, which had to be subsequently corrected in the law reports. So I do not believe that it is an indication of me approaching the drafting of judgment in a perfunctory or superficial manner.
But that's all belied by what happened in the matter of municipal employees' pension fund, because the style guide was there.
Yes.
That you paid attention to it, these elementary mistakes would have been avoided.
Yes, it is there, Deputy President. What can I say about it? Those things, I want to believe that they do happen. We all as judges try to limit them as much as possible, going through your judgments every now and then. But I do think that they do creep in from time to time. If, of course, they fundamentally vitiate your judgment, then it is a different matter. But I mean, it's as far as I can take it.
You have been on the bench for 12 years.
Yes.
And according to the report from comments by the GCB, the list of judgments written by you, which they considered,
yes,
they listed only 3 reported judgments.
Yes.
Is that the sum total of reported judgments?
No, there are other judgments that they missed. There's one particular judgment, I think I mentioned that in a previous application when I was still acting, there was a reported judgment in 1998. I can look at it if you want to. And then also there was another judgment that was reported, which is Randall versus Law Society, but I didn't list that one because that was the one that was overturned by the Supreme Court of Appeal. There are two other judgments which I thought clearly would have been reported if it were not for the fact that that they had to go to the Constitutional Court first for for confirmation of an order that I made declaring a law to be invalid, which was the Shoprite Checkers matter and the Mdodana versus the Premier matter. The Shoprite Checkers matter was then, the Constitutional Court judgment was then reported. I do not think that my judgment was reported. I think they were holding back for the Constitutional Court confirmation of my judgment. But you...
So you only had about 5, it's 5 now?
Yes.
Over 12 years?
Yes. The Deputy President, I have written many judgments. I'm sure that some of my colleagues will also agree. You mark those judgments as reportable, and where you think clearly that either because of new law being made in the judgment or confirmation of a legal principle based on a novel set of facts, or where the subject matter of the judgment is topical, and I suppose that gets presented to the people who decide whether or not judgments should be included. I have never actively attempted to push for the inclusion of my judgments, and maybe I should have done that. I know about some colleagues who have done that, and I think that maybe I should have. But I think an overview of my judgments will indicate that I have made a contribution to the law, to the understanding of the law, over a long period of time. I cannot answer for why some of those judgments were not reported, when in my view they clearly should have been reported.
But you would know that judgments are reported in the law reports, that is Juta or Butterworth, if they have any precedential value.
Yes, that is correct.
And there is a world of difference between a judgment written by a judge who indicates that it is reportable and a reported judgment.
Yes, yes, there is.
Thank you, Judge Smith.
Thank you, Deputy President.
Thank you, Deputy Chief Justice.
Thank you very much, DCJ. Good day, Judge Smith.
Good day, Commissioner.
Thank you. Just to follow up on the question that the acting president raised in relation to your reported judgments. In the questionnaire, where you are asked to provide at least, up to 10 judgments which you consider significant, you only list 7.
Yes.
Is that out of modesty or is a factual situation?
Now, I don't want to exaggerate, but I must have written over 200 or 250 to 300 judgments over the period of time. Contrary to what is believed, the Eastern Cape courts are very, very busy. I have been doing recess duty for the past 2 weeks, and I walked away with about 5 reserved judgments, which I have to deliver within the next few weeks. So I've written many judgments. There are so many of those judgments that I believe that made a contribution, and I listed the important ones. If you can just allow me to give you an example of how it is the essence of being a judge, that there's always this possibility of colleagues differing with you. I wrote a judgment on, which is referred to in my list, which is Shoprite Checkers versus the MEC, the matter that went to the Constitutional Court for confirmation. That judgment dealt with the crucial issue of what is property for the purposes of Section 25 of the Constitution. And it dealt with that issue in particular in the context of a liquor license that had been issued to Shoprite Checkers. But to complicate matters further, it was not only a liquor license, it was what was called a grocer's wine license, which meant that they were entitled to sell wine in their grocery stores. They didn't have to have separate premises. So the question that arose as a first question to be determined was whether that particular governmental largesse, which is essentially the government giving a license to you, if it qualifies as property in terms of Section 25, because Section 25 is clear that it's not only land that is property. I found that it has all the characteristics of property, namely that it is clearly definable, that it is identifiable, it has commercial value, it can be transferred, there's permanency, it's permanent for as long as you comply with the regulations and conditions. And there were other issues as well, of course, whether there has been deprivation, whether there's been deprivation, yes, of the property, or whether there needs to be the justifiable limitation exercise in terms of Section 36. But on that issue, the other issues, of course, on that issue, the majority agreed with my finding on the issue of property, but disagreed with me on the issue as to whether, in fact, there has been a justifiable limitation of the property, because I found that the license had been taken away in its entirety. The majority disagreed. They said there was a justifiable limitation, and the reason provided by the province was sufficient. But even on that score, the majority, there was a judgment written by Madlanga J, which I think one of the acting judges concurred in, which agreed with me whole scale on all the issues. Judge Moseneke disagreed with the finding of the majority that that license constituted property, and I think including the then Chief Justice also disagreed with that. So what you have is that in one panel, there were more than 4 or 5 different views on the same aspect. And I have no doubt that if you superimpose another court on top of the Constitutional Court, you will find that there may be judges who make different pronouncements. So you're always going to find that colleagues may disagree. Your judgments can be overturned. Even in the SCA, there are cases where judges decide to write minority judgments. Simply means that if you had decided that issue on your own, you would have been overturned by your colleagues. But what is important in my view is that anybody who reads your judgment say, I disagree with this finding, but but must not be able to say that, look, he missed the point completely, misconstrued the law, didn't get the facts right, he was just off, then that is bad. But where on the facts, the proper facts, and it's common cause that those are the facts, that's the factual metrics on which you must now apply the law and make your findings. If you give a reasonable exposition of why you reach that decision, I think that is the duty of a judge. And even with regard to the issue of reportable judgments, I've many judgments that I can refer to. For example, I had one judgment that I wrote on the circumstances under which the corporate veil of a corporate entity, a company or a corporation can be pierced. And I thought that those were unique circumstances. The application of the law demanded a unique approach, and I put that judgment forward for consideration for reporting, and nothing, just simply nothing happened. So unfortunately, you don't have control over that process. You can just do the best that you can with the case and the facts that is presented to you.
Just a follow-up, TCJ. So your position is that the 7 listed is an understatement?
Yes.
And now the second question, how does it, as a judge, how does it make you feel if your judgment finds its way into a law report?
I mean, we were proud of that fact. Even when I was an attorney, we had many cases reported in the law reports. And yes, it does make you feel proud that others have recognized your judgment and have seen in your judgment what you thought were there. But sometimes it just doesn't happen that way. And I have been less and less. Initially, it bothered me quite a lot, and I spoke to some of my colleagues, and they said, look, you need to be more proactive, because they gave examples as such and such a case where I had to phone so-and-so and say, look, do you understand what is going on in this case, and why is it that you don't consider it reportable? But I haven't done that, and that is for one reason only. I don't want to minimize the law reports or the fact that judgments are reportable. But the fact of the matter is that things have changed so much since I started practicing. Now, you go on to the Supreme Court of Appeal website, you can find any judgment that you would not find in the law reports, and some of those judgments are very helpful for your case. You go on to SAFLI, you can find any judgments. It is just the technological advances has just opened things up. I'm not saying that Judas have become obsolete, because I am one of those that still enjoy reading on paper and remember better when I enjoy reading. But very soon it's not going to matter any longer, because even now when I hear cases, most of the judgments, well, on the established points of law, you'd always have reported judgments. But most of the judgments are judgments that you won't find in the law reports. But because they are so accessible, counsel is able to pick and choose and give you judgments that you never heard about. And you read those judgments and you think that, well, this is actually such a good exposition of the law. It should have been in the law reports, but it's not. But I'm just saying that, to answer your question, I must admit that it does make you proud, but soon it is not going to matter. Nobody's, and I think you will find that most of the counsel and attorneys are using the electronic medium more and more, and have better access to judgments.
I take your point, Judge, that with Sorry. Yes, no, maybe let me leave it at that, TCJ, taking into account what you are saying. Thank you so much. Thank you very much, Judge Smith.
Yeah.
No. I take that into account, Judge. Yeah,
Yes.
I mean, TCJ. Sorry, thanks.
All right, thanks. Commissioner Nuccius?
Thank you, TCJ. Good morning, Judge Smith.
Morning, Commissioner.
Judge Smith, is quick questions. In respect of the comments that have been made in respect of your candidature by various bodies, they speak so well about you, especially the GCB at 5.1, where they say the candidate's commitment to the Constitution is reflected in his participation in the Eastern Cape Democratic Lawyers Association Secretary from 1983 to 1985, and in Nadel, National Vice President, 1989 to 1990, and so forth.
Yes.
Have you, what could be, how that assisted you in terms of your contribution to transformation of the legal profession?
It played a very, very important role in my approach to any case that I sit on. If you just allow me, in order to illustrate my point, if you just allow me to say this, it's either not recognized or people forget about the fact that in 1992, already 1991 or 1992, when the then military government purported to introduce a constitution decree, that is what it was called, and brought into being a justiciable Bill of Rights. They didn't intend to do that, but the fact of the matter is, when we read the Constitution, we saw, wow, this is what they've done. Imported whole-scale international concepts of jurisprudence insofar as the recognition of rights are concerned, the justiciability of rights, the derogation of rights, and the limitation of those rights. So we were then, and of course we didn't know much about constitutional law. All these issues were new, having come from a jurisprudence where Parliament was supreme. But we were then able to challenge the National Security Act insofar as it provided for detention without trial, and also a blanket ban on meetings. But in doing that, we had to prove, of course, there was this repugnancy between these acts and the Constitution, which was now introduced. And there was even an attempt, when they realized what they had done, there was an attempt to repeal that Constitution. So, but we succeeded. And in the second leg of the case, first, there was a declarator of repugnancy, and that it actually derogates from those fundamental constitutional rights. And as a second leg, we went back to court and actually got those laws to be declared invalid. So the long and the short of it was that the Ciskei government, which was then even just Ciskei Security Police, was just an extension of the South African Security Police, were no longer able to detain people. And also the assaults in prison also almost came to, well, not a complete halt, but there were not so many of those assaults any longer. But I'm saying this because that is the jurisprudence that have informed me when I became a judge. And I look at all the cases from that point of view, rightly or wrongly. That is who I am.
Yeah. Now, there's this question about the report or the reported judgments.
Yeah.
I think it's not only a question to you. All candidates have been asked this question.
Yes.
The concern I have is if you have marked your judgment reportable, thereafter you just don't have a control, somebody else takes over. That is, it is dealt with by
Yes.
editors, some other person who takes their own decisions, taking into account. How best can we, how best can we ensure that this process of reporting judgment, taking into account what you've just said about the new technology, other means of,
Yes.
of reporting judgment, how best can we balance this and make sure that at least there is transparency on how, because we find out that some other judges have many reported judgments,
Yes.
others simply don't have, though they mark their own judgments
Yes.
reportable. Well, how that can be done?
I
What
think
is your
the problem is that what I have been told, at least by one of my colleagues who knows something about what goes on there, is that the publishers get flooded with judgments. You can just imagine how many judgments come before them and how many have been marked reportable or not. But I think the fundamental decision that we have to make is that still going to be the basis on which you're going to be assessed? Is it still the end all and the be all if your judgment does not appear in JUTA or the all law reports? And if we recognize that things have changed, that there are many judgments that have not been reported, and some of them not even on SAFLI, that was another one of my difficulties. I spoke to our registrar once and asked him, how are these judgments placed on SAFLI? Because I had delivered, in about a month, I delivered many judgments, and some of them, although I didn't think that they would be reportable in the sense of you put them in JUTA, but I thought that if this, and I referred it to my other colleagues as well, and I thought that if other judges see this and the research that I have done in this judgment, it can help them. So if it is placed on SAFLI, it is going to be so much more accessible to them. And then it's not there, but what is there then is a one-pager that I wrote on leave to appeal. And I say, but why is this even on SAFLI? What contribution is it going to make? Because I wrote a simple judgment that doesn't say anything new, that simply say that I am of the view that there's no reasonable prospects of success. Why do you place it here, and why are those other judgments not here? And all that he could say to me is that, well, I just give it to them and they decide what to do. But it's those type of things which it's a bit anomalous and incongruous, and it also led me to say, well, I can just do what I'm supposed to do. What I take a particular care to do is that if I write any judgment where I think my colleagues would benefit from that, then it is make sure that I have a special effort. Well, we circulate all the judgments, make a special effort to say, you may want to look at this judgment because it's a matter that can come before you in the near future. But I think that is, maybe we must just accept that things have changed fundamentally. That, yeah, I'm going on a bit.
Thank you, TCJ.
Thank you, TCJ. I'm covered. Thank you.
Do we have questions from the virtual platform? Commissioners Bernard and Breitenbach? Yes, Commissioner Bernard.
Thank you. Sorry, I might have spoken over Breitenbach. The judgments, you mentioned the matter of Randall versus the Cape Law Society, which was a judgment that you and I think Judge Makaula, another candidate that appeared before us in the interview, But you were the scribe. So in that matter, you ordered the stay of a striking off application where the legal practitioner involved had misappropriated substantial funds that were intended for an education trust. So that's just to summarize the fact, hopefully. I call it the education trust because there was a primary school as a beneficiary.
Yes.
So the criticism from the Supreme Court of Appeal in overturning your judgment, they seem to indicate that you pay too much attention to the legal practice involved and the trust account conduct of the particular practitioner, and not enough attention to the protection of the public in the hands of the unscrupulous practitioner. So, just on that, do you have any comment on this?
Yes.
Why did
Yes.
judgment occur, and then, what lessons have you learned from that matter?
Yes, I have. That is the one judgment that I still mull over my mind over and over. You will recall that one of the core issues in the judgment is whether the court has discretion to stay such proceedings pending criminal action, criminal proceedings to be instituted, or criminal proceedings which have already been instituted, where the person say the following: look, if you force me to face this disciplinary inquiry, I am not going to have any resources to defend myself in the criminal matter. I'm going to exhaust all my resources. And it was an issue that and I think I referred to it in my case as well, that internationally has occupied many courts internationally on this issue. I was of the view that yes, the court must have, even though some of the appellate division decisions, the old appellate division decisions held in the circumstance where there was a statutory obligation or imperative on the person to appear before the body, that in such a case the court, but those cases never said that the court, as a part of its inherent discretion, cannot, where the circumstances justify such an order and where otherwise an injustice would be done to the person. So I approach it from the point of view, so if you force this man to fight this case, he is going to be, is not going to have any resources. He is going to be compromised insofar as his criminal case is concerned. And in a sense, it was a judgment call on the circumstances of that case. And the reason why I was inclined in that direction was exactly the lethargy and the supine attitude of the Law Society in taking such a long time to take action against the man. It must also be remembered that what happens now is that it's viewed through the wisdom of hindsight, because it has been established in the criminal case, it has been established subsequently that he has actually defrauded the school in that manner. But at the time, those were allegations. In the end, he had a version that he put before me. And I often think whether I should have decided the case differently, but I think that if I were part of a panel facing those set of facts, I would probably not have decided differently. And I differ with respect with the ratio and the gist of the judgment that says that the court doesn't have that discretion as a matter of course. It cannot do that, otherwise the administration of justice would come into disrepute. I don't think that can be the case, because what I also said in my judgment is that there's a discretion, but it needs to be exercised conservatively and only in deserving cases. So I thought that maybe if the court found differently, it would have differed with me on the facts of the case and say that, well, we do have a discretion to do that in appropriate circumstances, but in this case, the applicant has not made out a case for such relief. But yeah, I still think it would be very interesting with the right set of facts, for example, what the Constitutional Court would say about whether or not courts have that discretion to make such an order in appropriate circumstances, provided that it be used as conservatively as possible. I hope I've answered your question, Commissioner.
Thank you. Well, you have answered it. The second, just a last question I have. If the JSC were not to appoint you to the SCA, what would the SCA be missing out on?
I think it appears from my judgments. I have a good understanding of the law. I've got experience in my legal practice. I had vast experience in constitutional law. Even before I came to the bench, administrative law. I have reasonable experience in other areas of the law as well. The Law Society, the GCB, I think, refers to one of my recent judgments in the matter of Funda versus MEC, which involved complicated cases of medical negligence issues, where I had to assess the evidence and the weight of the evidence of many authorities, neonatal pediatricians and obstetricians and all other experts, medical experts that gave evidence before me, and I had to make sure that I understand what they're saying, and I think that judgment is, as far as I'm concerned, is a good indication that I do have the ability to look at complicated facts, complicated legal situations, and give a reasonable judgment that makes sense.
Thank you. Thank you, DCJ. Thank you, Judge Smith.
Thank you.
President Betze has a follow-up question for you. Go ahead.
Thank you, Deputy Chief Justice. Judge Smith, you would have been provided with the comments from the GCB.
Yes.
By the Secretariat.
Yes, I saw that, yes.
And from which you would have seen that they say they considered only three reported judgments from you, and
yes.
also listed unreported decisions,
yes.
which in total are 19.
Yes.
And you say that over the years, you wrote more than 200 judgments.
Yes. No.
Did it occur to you perhaps that you would need to, to prepare a list of all those judgments and provide the list to the Commission?
I must admit that it did not occur to me. I thought that if I provide judgments that would show this body that I have a good understanding of the law, that I'm able to make sense of a factual matrix, and I'm able to apply the law and give a reasonable, concise judgment that tells the reader why I came to a particular conclusion that would be sufficient.
Thank you.
Of course, many, Deputy President, many of those judgments are matters where on 4 or 5 pages you simply dismiss the case or grant the relief. They're not all erudite expositions of the law, so I wouldn't have wanted to burden this body with some of those.
Thank you. I'm satisfied, Judge
Thank
Smith.
you.
Let's leave it at that.
Yes, thank you.
Thank you, DCJ.
Lastly and quickly, Judge Smith, I forgot to ask you earlier, You mentioned in your application form that you were involved with the CFM task team. What is that?
Oh, I'm sorry, I actually saw late on that. I just assumed that that acronym would have become quite well known. It's a case flow management task team,
Oh, is that
which
what
was
it's
established by the previous Chief Justice, and I and Judge Griffith served on
No,
there.
I know
Yeah.
what it is. I
Yeah.
just didn't know the
Yeah,
the
sorry,
acronym.
sorry, I should have, I should have
Okay.
made it clear.
You listed two outstanding reserve judgments in your application form from the SCA.
Yes.
Have those been delivered?
Yes, they have been.
Both of
They've
them?
been both delivered in time, yes.
All right.
Yes.
Thank you so much, Judge Smith. We've reached the end of your interview.
Thank you.
Unless you have anything you want to ask us, you're free to go.
No, definitely not. I thank you very much, and to all the commissioners also, thank you.
Colleagues, I don't know if you'd want to take the tea adjournment now. We were supposed to break off at 11. We still have 3 candidates to interview in this batch. Maybe we can take a 15 minutes? All right, we'll be back at, it's 10 to now, at 10 past 12. 10 past 12, please. Judge Valley, do you need assistance? Over here. Straight ahead. Straight ahead.
So sorry. Yeah, what is this? My apologies.
No problem at all.
And what is this one? I'm sorry, Deputy Chief Justice. I'm now finding myself.
All right.
Thank you, Deputy Chief Justice.
Good afternoon.
Good afternoon, Deputy Chief Justice.
How are you?
I'm fine. How are you, Chief Justice?
I'm fine, thanks. Let's get to it. You have many university degrees, Judge Valley.
Yes.
Not just in law, but in commerce and science as well.
In commerce and in sociology, yes.
Sociology, oh yeah.
Yes.
Your career, I'm just trying to trace where you started. Oh well, you have long experience in the labor law sphere. You worked both as a mediator and arbitrator under IMSA.
Yes.
For a total of 8 years.
Yes. I was also on the IMSA Board of Trustees at the time. But I think it needs to go a little bit back. I was involved in the union movement, so it was a natural progression to go into to IMSA and to do that because I'd already been active in the labor movement. So.
And I find it a bit odd that you did not end up in the labor courts. Were you not interested to follow that progression?
My practice, I did a lot of labor law work because it came very naturally to me. I appeared a lot in the labor court and the labor appeal court. But I also did other work as well. As you will see, much of it you can't see here, but they would have gone in my application for senior counsel status. And so I did a lot of constitutional, administrative, and some commercial work at the time. So I thought High Court would have been more appropriate for me. And that's how I ended up in the High Court.
Yes. And you were appointed in 2010.
2010 I acted, 2012 I think I was appointed.
Or you were only acting
in 2010.
In 2010 for a stint, just a short stint. Oh, I see. And you have been involved with the Competition Appeal Court since 2016?
Since 2016, that's correct.
So you are no stranger in the appellate court?
No, I'm no stranger in that. And I sat in a number of three-bench appeals in the High Court as well. So yes, no, I'm no stranger to appeals.
Yes. You have produced an impressive body of reported judgments since your appointment as a judge in 2012. How many are they? Just an estimate would do, but it's a lot.
The number of judgments in journals, like SA law reports, all South African criminal law reports, would come out to about 30. The judgments, including SAFLI and JDRs, competition law reports, what I didn't put in here because I couldn't find them was tax law reports. There are quite a few in tax law reports, but I didn't put them in. So in total, if you added all of them, they're 57, but 30 of them are in SA law reports, all South African law reports, SA criminal law reports added together. I do give the citations of each of the judgments that I've identified as reported and where they've reported as an annexure in my, to my application.
And you've published a few articles as well.
Yes, particularly when I was in the labor law field, and I did publish in sociology as well.
You have not acted at the SCA.
That is correct.
Should that disadvantage you in any way?
I would think not, and I would like to say why I think not.
Yes, please.
In my view, Deputy Chief Justice, is that, yes, it would have been an opportunity, it would have been good to act in there, it would have been a privilege to act in there, but unfortunately for me, it just didn't work out. I wasn't lucky enough. But I believe that the quality of my judgments, I believe my work ethic, I believe all of which are demonstrated in the application, Deputy Chief Justice, make me a suitable candidate to be in that court. So, yes, I do accept that acting there would have been advantageous, but I don't believe that it's in any way a handicap that should prevent me from sitting. I believe that I'm actually a suitable candidate to sit in that court. And I think many of the people who commented on my application have said so as well, you know. But it's unfortunate. I was just not lucky. Sometimes luck doesn't come with you, you know.
Yeah.
It's one of those things.
You would be aware that a huge bulk of the work that we do, that is done at the SCA, comprises applications for leave to appeal, well over 1,000 per year.
Over 1,000 years.
It's quite a lot. Do you know the difference between leave to appeal and special leave to appeal?
Yes. Leave to appeal, I said, as a court of first instance, I deal with leave to appeal.
Yes.
I've explained in a number of judgments what the test is available in there. In fact, one of them, I've written a lengthy judgment on that. That was the one in which I applied Rule 53 to an executive decision, and then there was an application for leave to appeal in which I wrote quite a much longer judgment than what one generally writes for an application for leave to appeal. I know that. Special leave and then also exception petitions, if that's what you're referring to, Deputy Chief Justice, yes. I'm aware of that. I look at some of those and I want to see whether there's anything special that calls for it. And I'm also aware that there must be some sort of public interest over and above the test of whether another court would come to a different conclusion having been invested with the same facts. I'm aware of those differences, and I'm aware of the differences, and then the need for exceptional circumstances.
Yeah. I know you work in a very, well, probably the busiest division in the country.
Quite a busy division, yes.
And you straddle two courts in addition to all of that. So you are used to hard work. But the work pace at the SCA is quite frenetic.
Yes.
It's extremely demanding. And what adds to the pressure is the convention there to produce judgments in the same term that the appeal would have been had. So that's it just piles on.
Yes.
The tremendous pressure that there is already. I just want to know, well, your CV shows a person of good, strong work ethic. But I just want to hear from you, if you think you'd be able to keep up with the pace there.
Undoubtedly so, Deputy Chief Justice. These are some of the things, I must be honest, I find difficult to speak about because one is really trying to sell your candidacy and kind of, it's sometimes like kind of self-praise, But I can say without fear of contradiction that I've produced a lot of judgments in very short time involving voluminous papers. What I did learn from them is sometimes you need to just step back because you get so engrossed in it and you work till late hours in the evening because you've got other work to do in other times during the day, and that it can be difficult. I accept that, but I've found a way of meeting those challenges, and fortunately I've been able to perform at the pace required in my courts. I mean, in my courts, as you say, Deputy Chief Justice, are not light courts in terms of workload. The workloads are very heavy. Yep. There's something, Deputy Chief Justice, that I think, I need to just say it so that the public out there also gets to know. Because they tend to think that we sit on judgments, etc. There's a lot of extra, I don't even call it judicial work, but extra work from a court. I do case managements, and I do quite a lot of them. And nowadays, because of the digital system, the benefits of a digital system, of a virtual system, I do a lot of that between 7 and 9 at night. So a lot of my case managements are done in that time. There's a lot of other things I deal with. I have dealt with some petitions that come when there's no leave to appeals given in, I can't remember when, but they did do those. So yes, there is a lot of extra work, the reviews, surrogacy agreements, and I've done quite a lot of those as well. And that takes quite a lot of one's time, and it's not exactly shown in what the public and what others see about the amount of work one puts in this profession, in this vocation. There's a lot of work, and I've learned to accept, or I have accepted for a while to go, that there's no escaping doing the hard work yourself, and that there's no escaping reading the documents yourself, and going through everything yourself.
On to a thorny issue, and I was reminded of this when I went through the comments from the professional bodies, especially that of the GCP. Your interview in April 2018, I had recently become a member of the JSC then, and I vividly remember those interviews. And I remember being left with a very unsettling feeling after your interview when you were questioned by the then JP, Judge Dennis Davis. That was quite an unpleasant exchange, to put it mildly. And that just made me wonder about your temperament. As I experienced it, you lost your temper, and it just unsettled me that a candidate for a judicial position would actually allow themselves to lose their temper in front of the JSC. Do you want to comment on these observations of mine?
Yes. Look, I'm sorry. It's clear to me anxiety got the better of me on that day. I'm sorry about that. It has never been a problem between me and Judge Davis. I mean, we've worked together very well. But on that particular day, I did get riled, and I think I regret it. I mean, I did say to him that your eye contact with me is beginning to disrupt my trend of thought. And yes, I didn't intend to insult or hurt him, and he never saw it as that. And as I understand it, the JSC never thought that it was something that I acted out of order. But if I did, I do apologize for it. And I certainly regret that. But it's certainly not an indication me losing temper all the time. I mean, that's just, that would be an inappropriate conclusion.
But then there are the comments made by the JSC. I'm just going to confine myself to those relating to your temperament. And they report on what they say council has told them, that you have been described as abrupt and discourteous at times with council, that is. That to me tends to show a pattern, a quality that you have.
I don't think that's correct, Deputy Chief Justice, and I'd have to say why. Firstly, I know some people dissociate themselves, because the way that comment is written, it says thereafter, that other senior counsel do not agree with it and dissociate themselves from that comment. But that's not what I would rely upon. I do accept that I can sometimes be firm with people, and I have said this before in front of to this body, that I have sometimes been forced to be firm in court in order to make sure that there's order in my court, in order to ensure that there's decorum in my court. And if you don't do some of those things, then you can lose control of the process. So I have sometimes been that. And yes, I'm a human being with some flaws. I'm not going to sit here and say I'm a perfect human being. That would be,
None of us are perfect, Judge Bali.
Sorry, Madam.
No, I was just saying none of us are perfect.
Thank you, Chief Justice, yes. So I don't think that that's entirely correct. I mean, I have never received specific complaints from any one of them. And sometimes people don't like the decisions you take it, and you have to tell them about it, and they sometimes see it as being harsh and discourteous. I don't know, I can't speak for them, but I'm just speaking generally. So no, I don't think that's a fair comment of my general approach in my court. I really don't think so. In fact, the contrary.
Sorry, have you finished?
Yes, I am finished.
All right. I raise these difficult questions, and I'm sure you can tell that I'm quite uncomfortable putting them. I raise them because the Supreme Court of Appeal, being an appellate court, requires a team player. Yes. You would not be sitting alone there. Well, you are in the appeal court as it is now, so you know what I'm talking about.
Yes.
Most of the time you work with 4 other people.
Yes.
And it's, wherever you get more than one person, there are going to be personality clashes and all of that. So it is important, and the SCA, coming with its history, coming from where it has been, collegiality matters quite a lot there, and it's a delicate exercise. So, and I mean, quite apart from that, you mentioned the decorum of the court, so judges need to behave in a specific way. There's the judicial code of conduct that requires us to be a certain way, especially towards the counsel, the people who ply their trade in our courts, the litigants. So a judge cannot be rude, a judge cannot be impatient. Yes. A judge, you understand what I'm trying to say to you. So it is, issue of temperament is quite critical. And that's why I need an assurance from you that you can be a nice person, if I can put it simply.
No, I can give you that assurance, unqualifiedly. I've sat in a number of 3-bench judgments. I've sat in the Competition Appeal Court, quite a lot, in fact, in the Competition Appeal Court. So yes, I've been sitting with other judges. I've accepted the lead of other judges when they're leading it. I've led benches. I've led the 3 benches. I now lead almost all in every competition appeal matter that I sit. I'm the lead judge now. because I'm the most senior judge in that court. So yeah, I've done that, I've had the control process, and in none of them can it ever be said that I've not acted collegially. What can be said is I have dissented in my judgments, but that's not uncollegial. I have issued dissenting judgments. In fact, they're on record there. But it's never been uncollegial at all. I mean, it has been very polite, and this is our differences of view. We've sometimes have a discussion that can be quite, that has been robust, but it has never been rude. It is never, nobody's ever told me, or I have told anybody that I think their views are silly or stupid or whatever, or I got no respect for them, and nobody's treated me with disrespect. That has happened. So yeah, I can't remember, but there has been, it's not an easy process, I'll accept that. I'll accept personalities can clash, but I'm careful to recognize that there are clear boundaries. So, unless, Deputy Chief Justice, whether I've trespassed on any of that, I can't tell off the hand now. And I've obviously haven't got any complaints, and I've acted in so many, I've participated in so many appeal processes, and I've led in so many of them.
All right. Now, thank you, Judge Valley. I'm going to hand over to my colleagues to put questions to you if there's any.
Thank you, Deputy Chief Justice.
Okay, I noted you. Minister?
Thank you, DCJ, and good afternoon, Judge Valley.
Good afternoon.
Yes, my question is in relation to the matter that you handled of the Democratic Alliance versus the Minister of International Relations.
Yes.
What is your view to the fact that diplomatic and international relations matters should be left to the executive because of the nature of the polycentric laden type of matters that often arise?
Minister, I'm more than other people, I think, more than some of my colleagues, I'm sensitive to separation of powers. I really am sensitive to it. And if it might come up in one of the cases that I'll have dealt with, and I'll explain my view on separation of powers. The judgment is quite careful not to trespass on the areas that fall within the jurisdiction of the executive. However, I had to apply what I believe was a fair application of our law. And our law is slightly different than the US law on this question. In the US, there's much more deference towards an executive decision conferring diplomatic immunity. In our law, it's not. It has to comply with certain requirements, and I deal with that. I think it's something to do with the usus and an opinio juris, and I go in thorough detail with that in my judgment. So I don't believe that I trespassed the role of taking over, or trespassed the role of a judge, or entered the terrain of an executive decision-making power. As far as polycentric nature of it, I respect that, I accept that there is polycentric nature of executive decision, and that's the main reason why we should stay clear of it. But the executive has to comply with the Constitution and the law. Judges have to comply with the Constitution and the law. And in that case, I found that did not occur. And I gave my reasons. And they've been very carefully expressed and sensitively taken, sensitively articulated. I should hope so. I never got an application for leave to appeal. If I did, I probably would have granted them, because it was a matter that does give one anxiety. Because this is a matter that involves government policy and that has implications for government actions. I'm aware of that. In fact, it's clear in most of the cases I read for that judgment, and I referred to them in that judgment.
Yeah, my last one relates to the one on Transnet and IJS Consulting, where you are dealing with a contract which you believed was loaded in corruption, and you went beyond just declaring the contract invalid. Do you think with the prevalence of corruption in our country, we have reached a stage where there should be more judgments like this, where you don't only declare it to be illegal, but you should ensure that those that participated, if you believe there was some kind of corrupt activity, should not benefit or be enriched through such contracts?
Absolutely. But, and I think it's going to be a difficult issue, because sometimes you can't just supply public law principles to it. Sometimes you can, I don't know. But yes, if a contract has been marred by irregularity, and I've said this in a number of my judgments, then I believe that contract should be set aside. And I believe that whoever benefits therefrom should be deprived of those benefits. I must say this, Minister, you find some of that in the competition matters as well, collusive practices, etc. And I've not taken a lenient approach to all of them. If you look at my judgments, you see that I take quite a hard line where I see illegal and irregular practices coming out.
Thank you, DCJ.
Thank you, Minister.
Thank you, Deputy Chief Justice. Good afternoon, Judge Farah.
Thank you, Acting President Pete. Good afternoon.
During your previous interview for a position in the Constitutional Court, I raised with you the number of your judgments that were overturned by the Supreme Court of Appeal. When I put to you that according to the report by the GCB, close on to 50% of your judgments that went on appeal to the SCA were overturned. Do you wish to respond to that?
I said then at the time, and I still hold on to that, I believe that it's not a fair reflection or correct reflection or accurate reflection of the number of judgments that went to the Supreme Court of Appeal that were overturned, because there was many we don't know of where there was applications for leave to appeal. We never have that. Those that we do know, there were some that have been overturned. In fact, in my application where I'm asked to indicate how many of my judgments were overturned, I said there were 6 that I could find and 3 that were upheld. I've subsequently found that there were even more upheld, that I haven't put in there. So it's very difficult to say how many were overturned. But that I have been overturned, I accept. I've been overturned a number of times. If it was 6 that I could find, then there were 6 judgments that were clearly found to be wanting by the SCA. But I don't believe it's fair to say 50% of my judgments before the SCA were overturned. I think it's less than that.
Okay, and during your interview, I think last October, you were asked by the chair of the commission to share with us the number of reported judgments that you had written. And your response to the Chief Justice and to Commissioner Malema on that aspect left me none the wiser. You were not able to tell the Commission how many of your judgments were reported or found their way into the law reports. The closest you came was that you had marked your judgments reportable. And the sense I got was that you regarded those judgments as having been reported because you had marked them reportable. Would you like to respond to that?
Acting President Petse, thanks for that question. I accept that at the time I could not tell how many were reported and where, but I could tell the list indicated which particular ones were reported, or where they were reported. Yes, it said reportable and it didn't say reported. Yes, I said that I didn't compile that myself. Commissioner Malema chastised me for it. I believe he was correct to do so. I accepted it at the time, and I believe that since then I've now cleared that up. I've done this myself. You have a list before you as an annexure that tells you all the reported judgments. The Deputy Chief Justice has just asked me that question earlier, and I've told you where they are reported, which ones are reported, and I've given you a full list. I must say that it's not even a complete list, but that's to my detriment because it doesn't cover what's in the tax courts and what's in the competition appeal courts. And that's because it's just been very difficult for me with the limited resources available to actually find out where and what is going on. But I tried to do this myself. So yes, at that interview, I was not able to inform you what they were, but I certainly am able to do so now. And I've given you the full list. And it has been out there for anybody who wants to comment on my application to check it out.
Thank you. Earlier on, you told the Commission that one of your greatest attributes is work ethic.
Yes.
I don't know whether you would still recall this matter of Kadak Pension Fund and others versus the executive officer of the Financial Services Board. It's a matter which had served before the SCA on the 17th of November 2017, was remitted to the High Court for further evidence and determination of certain issues set out in the order. The matter served before you pursuant to that order on 11 October 2021, council ready to run a hearing, and you sent them away and said that that order was ambiguous and they must seek clarity from the SCA.
I don't have a full recollection of the matter. I've got a vague recollection of it. If there's an allegation that it was sent away because I was running away from work, that's not correct. If there's a judgment call that I made that may be wrong about what the order meant, that's a different issue. On the issue of it being, on it being clarity being sought, there was a debate and a dispute between the parties as to what the order meant. Neither of them could agree on that. There were certain things that were said to me about what happened. If I recall, yes, if I recall, what had happened is the parties had written the order. It was an agreement, if I recall correctly, an agreement between the parties as to what the order should be. And the one party said that they were the parties that drafted the agreement and not the other party, and the other party said we did not agree to that. The court had just endorsed it. And so it caused a problem, and I wasn't willing to make a decision that impugns the court or that makes a decision against what that court says. I said, that court is more than capable of saying what had happened in its situation. I think that particular matter, if I remember, yes, that matter is still before me on the case management. They were not ready. They were the ones who brought this to me saying there's debating and they can't agree on it. They went back, they still came back to me. And I've had to force them to try and get the hearing held. One of them, or some of them, gave me the impression they're not wanting to go ahead, and they wanted to go and seek these issues, and I gave them that opportunity. In fact, I may have set the matter down recently again and asked for papers to be brought in quickly. There was an intervention application I dealt with at 7 o'clock at night. So there's a lot more going on in that particular case. That case, yes, now it's coming back. That case has its origins in 2010 or something, or 2012. It's gone very far back, if I remember. It's the issue about a pension fund, an administrator having a dispute with the ex-trustees, etc. There's quite a lot involved in it. And of course, I don't remember all of it because I'll have to read it, and I will read it before I meet them again. And of course, the less I say about it, the better, because the matter is still before me.
Yeah. I think we can leave it at that, Judge Valley.
Thank you, Acting President Petzer.
You would have been provided with a copy of the comments by the GCB.
And yes, I have.
And the aspect that I wish to take up with you appears in paragraph 11.1.3.
Yes,
Is that-
President.
Are you there?
Yes, I am.
There's a reference to a matter that served before you in October 2018, which was opposed. Counsel for the applicants presented argument, and counsel for the respondent did likewise in answer, and sought to rely on a case not referred to in his heads of argument, and handed up a copy from the bar to you. And you took an adjournment to quickly go through the case. And when you came back, you didn't continue with the hearing. You, in fact, adjourned the matter sine die, and it had to be re-argued before another judge. Again, costs wasted. And counsel believed that you left them in the last year. You had no reason, after you had had argument, and counsel for the respondent had argued, handed up a judgment that he wanted you to have a look at. You accepted the judgment, adjourned in order to consider it, and when you came back, you adjourned the matter, effectively leaving the parties in the lurch.
That is not correct, Justice Acting President Petse. And really, honestly, it is not correct. For anyone to accept that this is absolute truth would require them to actually be satisfied that all the facts are contained here. And they're not. I don't run away from writing judgments. On the contrary, I write judgments quickly, I write judgments well, and I write considered judgments, and I write scholarly judgments. That's a fact, Acting President. I would never have done this. What happened, to the best of my recollection, is the other party fell ambushed. And I thought that was not in the interest of justice for one party to be ambushed. I don't know the full details, but I also take a firm hand when someone tries to ambush somebody else. It happens all the time in our courts. So I don't believe it's fair to say that I ran away or I run away from matters. The opposite is the truth, and my record speaks for it. You have a list of judgments here that have given you absolute full details of all the cases. If anything, parties feel unhappy that I do not wish to give up the matter, that I say, let's finish the matter here and now, or as soon as we can, or can you file on a certain date, we'll then come back and hear on that. But there's no allegation, there can be no allegation that I run away from it or that I don't have a good work ethic. My work ethic is demonstrated by the quality, by the amount of judgments I've written, the quality of those judgments. Acting President Petse. And that's what one should focus upon. They're there in front of everybody to see.
Well, the judge's work ethic is equally important because it serves no purpose to be allocated work to do and you don't do the work.
Oh, absolutely. But
because the comment here goes further and say that the matter had to be taken to another judge who had the parties and dispose of the matter
Justice Petse,
by granting the application.
Sorry, Justice Petse, let's read that carefully. If it was postponed sine die, it can't just go to another judge. No other judge will just pick it up and take it. It will have to be put back on the roll, and they would have had to do and correct what was and address to any issues or problems they had before that. And that's what would have happened. So when it came before Justice Tsoka, it wasn't as if it came the same day. If that's the impression you're getting, it's not a correct impression, Acting President Petse. It's a matter that was postponed sine die. Once it's postponed sine die, it means it goes back in the roll. It goes back and they will address whatever issues they have and any concerns they have. And if remember there are two parties here. There are always two parties. And one party felt that you're not taking me off guard, you're ambushing me. And you shouldn't be allowed to do that. And I haven't had the opportunity, and you can't, and this happens quite often, you can't just stand up and say after it's your turn to argue, I've got such and such a judgment, and you could read this judgment, and not even provide it to the other party beforehand, and then hand it on the side. This happens all the time, and say, here's a copy for my learned friend. That's not how justice should work, Acting President Petse. And I take a view on it. I try and make sure both parties have a fair opportunity to go through all the cases that each other wish to raise, and that they have a fair opportunity to present their own submissions with regard to that. So, and this is no reflection on my work ethic, Acting President Petse. if you want to really look at my work ethic objectively and fairly, look at the judgments that are written, look at the amount of pages those judgments, look at the number of cases that are referred to in those judgments, look at the amount of self-research I've done in those judgments. There is no doubt that there's this substantial wealth of information to show that the work ethic is very high.
Thank you, Judge
Thank
Valley.
you,
We'll
Acting
leave it at
President.
that.
I'm going to interpose and put you something I should have addressed with you at the outset. I do apologize. There is a pending complaint against you
yes.
with the JCC.
Yes.
Lodged by Econ Oil, the respondent,
Yes.
in a review application you had brought by ESCOM. And the complaint is that you relied on a non-existent affidavit in making your finding, and the complaint just focuses on your erroneous reliance on non-existent evidence. It's a matter that arose, I believe, according to the record, when you interviewed for the Constitutional Court vacancy earlier on this year.
Yes.
You are aware of that complaint,
I've responded to it.
or you have? Because
No, it's all done. The complaint was lodged 9 months ago. It was brought to my attention about a month ago, or 2 months ago.
the one I'm talking about was lodged on the 28th of August, just last, a few weeks ago.
I thought it was 28 August 2021. I'm
Sorry?
not sure. But it was lodged because it refers to my candidature as in the Constitutional Court. But I don't want to skirt the issue. I think I want to address the issue. I think one person sitting here was probably counsel in that matter. But yes, I did, and it was pointed out to me that I referred to an affidavit. I said that there was a confirmatory affidavit, when in fact there was not. And now I've looked into the situation, I've come to the conclusion, yes, there was no confirmatory affidavit. But I must say this, and I said this then, that if there was an error, it is blown out of proportion. It is not a significant error. It did not affect the outcome of the judgment. It would not, and I can refer to it now. In fact, if people want to go and look at the judgments, they are before this. I have submitted that judgment as one of the judgments for people to consider. And I think, I don't know where it is in this document.
TCG.
What are you looking for?
The actual
Let me see
reference,
something they have finished.
Okay.
sorry,
Sorry about that, just carry on. Did you find what you were looking for?
It's on
I would-
page 311, Judge Valley.
thank you, Commissioner. 311.
And while you are looking for page 311, I may just mention that the concern actually is that you would just cursorily dismiss that kind of error as a minor issue. It's your approach to your committing an error of that nature.
Let me start by saying a few points. First point, this was a matter involving, it's a special motion, and the papers before me were over 4,000 pages. This is one matter that taught me, be careful of working till late at night all alone with all these papers. But let's look at the error, and let's look at this point you raise, Deputy Chief Justice. The error is to be found on page 5D or 5E, paragraph 5D, national test. Right. Right, on 5D, in that page 315, I record that the very person had issued or had made a report. I put down what his memorandum states. And he says what happened with regard to this issue. Then I say in 5E, and this is where the error lies. It says, Mr. Shitangano and Mr. Hewu have both provided sworn testimony in the form of confirmatory affidavits. That's the only error they've identified. It should have had only Mr. Shitangano has provided sworn testimony. Mr. Hewu did not. That's what they're saying is the error. Looking at the judgment as a whole, it's an insignificant error insofar as the outcome is concerned. That's been confirmed by the Supreme Court of Appeal. It has been refused leave to appeal. They've then petitioned that to yourself, Deputy Chief Justice, and they've brought that to your attention. You have refused them the petition. So, Deputy Chief Justice, that error had no impact on the outcome. There is a lot of other testimony that goes on. Mr. Khalib Kesem gave a supporting affidavit. I simply mistook the view that Mr. Hewu had provided a confirmatory. In the amount of paper on me, I thought I saw it. When I wrote this particular paragraph where this said so, I thought I had done it. It was wrong. I admitted it's wrong. It's a regrettable error, but it has not affected the outcome of the judgment, and the judgment has been upheld. It has been upheld by the Supreme Court of Appeals.
Yes, indeed. What you said in the latter part of your statement is actually what I think these parties themselves, including me, were looking for, that expression of regret for committing the error. Because
No, it was a regretful error, and I really regret it. I mean, I've made many errors of fact in many judgments I've written. That's why you get overturned. And this is one of those, but fortunately or unfortunately, it did not affect the outcome of the judgment. In fact, the judgment, as I say, is quite lengthy. It goes on right up to page 350.
Well, the SCA did dismiss the application for leave to appeal, and that was the end of it.
Yes, it was, they petitioned.
Yeah.
What I must say, in fairness to the person who brought the complaint, in fairness to that person, is this. The person felt that when I said to this body that this issue is being blown out of proportion, now remember, this thing was a newspaper article that supposedly came a few days before my interview. And so it was just brought to my attention at the interview, and some members of the commission complained that I was being ambushed. And they tried to cut it short, and they said it's not fair upon me. And I said, that error was never pointed out to me. It was never pointed out to me at the application for leave to appeal. So what I said is, had it been brought before me at the application for leave to appeal, perhaps I should have. And now that they've petitioned, perhaps the SCA will take a different view, because it's been brought to their attention that there is an error in this judgment, which error is simply that did Mr. Hewu confirm? Mr. Shitangano does it, Mr. Khalib Kesem does it, but did Mr. Hewu also do it? It's just a third confirmatory affidavit. And I said he did, and that was wrong, and it's regrettable. And they said, well, if I said that, then why did I not grant leave to appeal? But it wasn't brought to me when I brought the application for leave to appeal. It was not brought to my attention at that point. And I dealt with this judgment till late hours in the evening. Counsel is sitting here. They tried there was all attempts to try and get this matter moved on. First attempt was to say, let's call 3 bench or something. There was some other attempts afterwards, and I said, no, you file your heads, leave them limited time, and I went through and I gave the judgment. I think I finished it in 2 weeks' time or weeks and a half's time. 29 June. Took me about 20 days. And it was very, very, very large matter, voluminous matter. But I regret the error. I honestly say to you, I sit here remorseful about that error. Small as it may be, it is an error.
Thank you,
Thank you,
Judge Vali.
DCG.
Thank you, Deputy Chief Justice. I'm sure you would I want us to correct this for the record. When Judge Valley was responding to what the acting president was saying, he said, "Don't bombard me," was something that was never brought to my attention. But according to the records in front of us, it is something that was raised by the GCB, and all the candidates received the objections that are coming to them. So this thing of synergy,
I'm confused.
this thing of synergy, it's here in the objections coming from GCB. And that was what was raised by Acting President Petsy. I just want to put it correct for the record, because he said we are bombarding him, and the JSC have got this negative name outside of bombarding people. So I'm putting it for the record that that is not something that is coming out of the blue. It is part of the records that was there, and that is what I want to correct, please.
Thank you for bringing that to our attention, Commissioner. It's noted. You want to say something, Judge?
I'm not sure. I'm not sure I understand what's going on.
DCJ,
I have to
perhaps,
ask.
If I may just come in before the candidate does. I think with respect what Commissioner Lucas is referring to is when Judge Valley was reciting what was happening before him in a matter. Not that he was accusing you of bombarding him with new issues.
I'm quite confused.
Unless I'm mistaken.
I must say I share Commissioner Singh's understanding that Judge Valley had said in the previous round, the newspaper article had just come out, and it was at that point that someone had raised that he was ambushed. He's had no complaint in this hearing.
That was my understanding of what he said.
Because as Commissioner Lucas says, everything that's been raised so far has been in the GCB's report. So I think is that a fair?
I think it's fair. I think I have said, and I've tried to be as fair as possible to the person who complained. I've responded to it, and I've said, I've accepted that there was this error. What happened last time, what the complainant does is afterwards, I said, but this is how you answered in the JSC, and it indicates that you should have granted us leave to appeal because you now show that you accepted you were erroneous. And I'm saying no. The difference is that issue was not brought to my attention at the application for leave to appeal stage. And that's why I did not say anything to this body at that interview that contradicts what I'm saying now.
All right.
Because that's what the difference is. As far as the ambush issues, I'm never saying that Acting President Petsy is ambushing me. No. No, he's never done that. Nobody's done that. This is something different. I think our lines are crossed.
All right.
Thank you.
Thank you, Judge Valley. And may I just ask that going forward you try to keep your answers concise, because when you say a whole lot of things, then the brain tends to switch off and we miss some of the things.
I will do so. Thank you. Thank you. Thank you.
Let's just try
Thank
to
you for the advice. Thank you.
Thank you. Judge Pillay, your hand had been up at some stage. Do you still want to put questions to him?
I do. Thank you,
All right.
DCJ. Judge Valley, good afternoon.
Good afternoon,
I just wanted
Commissioner Pillay.
I just wanted to refer to the letter received from certain silks at Tulamela Chambers. I think it's by Maleka SC, Maroka SC, Bukaba SC, Mukwena SC, Nalani SC, and Brian Lichoche SC.
I think you left out Kabashi SC.
I'm not seeing her name on the letter.
Is it
maybe.
not? Okay.
I think she's probably left the Barsons.
Oh, I see.
I'm talking about the latest letter.
I'm sorry, yeah.
No, you're absolutely correct. The latest letter also has Babashe SC as well.
Yes.
Where they raise their support for your candidature, and they want this commission to take into account their view that any criticism about your temperament, that is not a view widely shared by members of the Joburg Society of Advocates. I don't know if you see that in their letter.
I'm going to look for their letter. Can anybody?
It's not paginated.
I'll find it.
It's under a folder called Letter of Support.
Letters of support. Yes, I found my version of it.
Yes.
I brought my own copy, yes. The one dated 26 August 2022?
That's correct. So, and what that letter does is it endorses an earlier letter, again sent by the same set of silks, dated the 9th of September 2021,
Yes.
in which they go at length into describing your work ethic. And you'll see
Yes.
that in paragraph 14 of that letter. Now,
Yes, that's the earlier letter you referred
yes,
to.
so the later letter incorporates the earlier letter.
Yes.
And perhaps you just want to take us through what it is that these silks are describing. They go at length and they identify specific incidents or kind of work patterns that you've adopted in order to meet your obligations
Yes.
in the Joburg High Court.
Commissioner Pillay, I find myself really inundated with a lot of work. And they were some of those people who had to appear before me in some of those matters. And I find that it is really difficult to just work within working hours and finish my work. And I tell that to council and I try and get it done. They witnessed it. They've also witnessed me in a number of other matters. And it was very kind of them to come and bring it to the attention of this committee to say that their experience has been very different from the experience of other people, or the unnamed persons in the GCB one. And they said they want to go on record saying that I've had this high work ethic. And I can't take it further than saying that I'm actually humbled by what they say, that I have considerable diligence, self-sacrifice, and devotion to my role. They say he avails himself, he hears matters late into the night, he avails hearings into hearings in the evenings. I mean, when I sit in an urgent court, I go through, if I have to go through till late, I do so, you know. But even in these special motions, they're very difficult to deal with because the paper is voluminous. And they've seen it. And they've also had discussions, I suppose, with each other, I don't know. But I'm humbled by what they say about it. And I would certainly think that's a fair reflection of my work.
Judge Valley, the second issue I wanted to ask you about is the fact that you sit now as the senior judge on the Competition Appeal Court.
Yes.
Now, when you were a member of the bar, did you do any competition work?
None. And some of this is going to come out in the next interviews, so I don't want to say too much. But what had come out to me when I got there, and I got there after 6 years on the bench, that this was water over duck's back for me. It was just anybody can do this work. I have been asking other council to get involved in this work, and I'm going to raise this when we come back here another time. It's not work that's given to a lot of council, most council, in fact. And yet it's work most council can do. And there's a handful of council that only had that work, but from my sitting on learning the matters and deciding the matters and writing judgments that have received the praise, I found that this is really an area that is unnecessarily presented as something special and outside of the reach of all council. That's not true. I think many council, yourself included, and you've appeared before me, and I've had your heads of arguments in some matters, would easily walk into this area. I think many council. So I didn't appear in that court, but it did not handicap me from sitting in that court. And now I'm what's effectively the acting judge president of that court.
Thank you. Thank you, DCJ.
Commissioner Pillay, the judgments I've written in that court have been upheld by the Constitutional Court. They were dissenting judgments or at least I know one of them.
Go ahead, Prof.
Thank you very much, Deputy Chief Justice. Good afternoon, Judge.
Good afternoon.
Now,
Commissioner, I can't see your name.
Oh, Marumo Achai.
Marumo Achai.
Yes.
Thank you. I know Marumo. I've never heard Marumo Achai.
Now you
it's
have.
The first time. Thank you, Commissioner.
There is, picking up on what Commissioner Pillay was talking about, it is not the matter I wanted to ask you about, but it really triggered my mind because I remember reading one of your judgments in competition law, just don't have it in front of me now. Isipani. Yes, you remember that matter?
Yes, Isipani.
Yes. Where you had to deal with...
Is it not in my list of judgments?
It might have been. It might have been. I read it quite a long time ago. I think that judgment dealt with Section 4.1 of the Competition Act. And in particular, collusive bidding and rigging and all those things, cartels basically.
Yes.
And I say this because it's something that happened in my classroom, right, in my lecture hall. I think you said something in the first few paragraphs of that judgment. You referred to unlawful collusion, the word unlawful collusion.
Yes.
And the debate in the class was, but can we really say that a collusion is unlawful? Because collusion generally is per se illegal. It's one of those restrictive horizontal practices that the rule of reason won't apply to it.
No, I see your point.
Yes.
I get your point.
But that's not the matter I wanted to ask you about.
Yes.
The matter I wanted to ask you about is in relation to the National Union of Metal Workers of SA versus VR Laser Services.
Laser, yes.
You remember? And this case is important, and I think
business rescue case.
The business rescue one, and
Yes.
and I quite enjoyed reading this judgment, and I think it is one of those important contributions where the judgment per se deals with business rescue, but it intersects to some respects into the aspects of labor law, right?
Yes.
Where you have to deal with Section 189 of the Labor Relations Act.
Yes.
And I see that you, in the judgment, you focused more on the security that creditors have during business rescue and the role of the business rescue practitioner in relation to disposing of those assets during the process of business rescue. And I agree with your reasoning. But the thing is, you also referred to Section 189, and you did not go to the distance with it. But I just want to ask you a general question in relation to that. There is an issue currently in the Labor Code where the issue of forum shopping is actually arising in relation to retrenchments that employees bring during business rescue proceedings. Because the argument is business rescue provides you with a moratorium, right?
Yes.
Then that means one cannot be able to be taken to court, litigated against, and all those things. You are given 3 months to breathe so that those things happen. Just want to understand, how do you see the South African law developing in terms of retrenchments that are brought during business rescue proceedings?
Well, I mean, we already have a lot of checks and balances in the law itself. They need to be part of it, they consulted, and they are made, if I recall, preferent creditors. There's something about post-finance debt and pre-finance debts and something to that effect. Just for the record, VR Laser was a very painful case for me. And the counsel that appeared before me was involved with me in my struggle days. And I said to him, the heart bleeds on this case. Because what had happened there is that those employees were asked to work for 3 months without pay. And now when it came to having to pay them their back pay, it was told this money is going to go to the bank. And then I looked at the law, and that's when it came out that unfortunately it had to go to the bank and not to them. And it was quite painful. There's some really heart-wrenching affidavits put by some of those employees as to what was happening to them in their lives. But yes, the 189 process does provide for that, and fortunately, some of the unions do take advantage of that. It's a long time since I worked in labor law. I was very good at it when I was at the bar, and it's because I was a trade unionist. So I know labor law fairly well. I know it from the side of the trade union, so yeah. And I know what happens in the retrenchment processes. But I was one of those who argued at the time that the consultation process must be a meaningful process. It mustn't just be a formalistic process. I consulted you, I can dismiss you now. It's done. In fact, if I recall, and it's going back more than 20 years ago, Justice Malambo wrote one of the leading judgments at the time on what consultation should mean. And I was one of those who was a strong proponent of that view. So what we can do here is give them, maybe we can, and the court can probably ensure that their interests are receiving the due attention when the business rescue practitioner is already running the process rather than only just their creditors.
No, thank you very much, Judge Valley. I think on a lighter note, I realize that your judgments in most of the cases are pretty long. Yes. I think you need to practice reducing them, which you will be successful to the Supreme Court of Appeal, because this might work in the Constitutional Court, but I doubt in the Supreme Court of Appeal with the guidelines that are available there, this might work. Perhaps a judgment like this, it might take 17 pages or so.
I'm happy to learn. In this profession, we learn every day. I'm happy to learn how to. But I also hope, Commissioner, that they also have academic value. You said to me it was in your class. So I also hope they have academic, they also have scholarly value.
I wouldn't comment on the scholarly, but yes, definitely value, certainly.
Well, okay, thank you. Thank you.
Any further questions, colleagues? Oh, sorry, Commissioner Steinberg.
Afternoon, Judge Valley.
Afternoon.
I'm the member from the GCB at today's hearing, and it's incumbent upon me to raise some of the concerns that they have raised in the written report before you.
Yes.
Firstly, to say, I read the letter from my colleagues at Tulamela, and I think there's a lot of truth in it, and they certainly hold that view dearly. But I don't think that erases those who hold a different view. And there are many in Tulamela who asked me to please raise that concern about temperament and rudeness. So I merely ask you to acknowledge that the positive view doesn't erase the negative view, and perhaps it's something that you could take on board.
I'm happy to take on board, and I'm happy to change my ways where I'm wrong, and I'm happy to admit where I'm wrong. I am wrong I can be wrong many times. But it also helps Commissioner Steinberg. If one gets details and one gets told this is you were wrong here, so then you can actually absorb, digest it, you know. And once you absorb it, then you can make changes. It's sometimes very difficult to do so. It comes across as if you don't take that criticism into account, but you don't if no one brings it to you. I would like them to raise it up front and say this is where it was and this is what went wrong. I would certainly take note of it. I'm very happy to change my ways in any of that.
Thank you, Judge Valley.
Thank you.
One of the issues that hasn't been raised, on page 140, paragraph 14.2, I can actually read it to you, it's not long. The GCB says, the candidates sometimes disregard for binding nature of precedent.
Okay, I know that one.
And in particular, his reliance on his own decisions is concerning. Even if the candidate has sound reason for disagreement with the higher court's decision and articulates this in the judgment, precedent is binding. Failure to follow precedent may be interpreted by the public as a disregard for the rule of law. And then they give, I think, 3 examples where the appeal court has expressly criticized your judgment
let's look at these
for
examples.
Disregarding clear precedent. One of them is the Capitec Coral Lagoon judgment, which I see in the transcript you were questioned about last time.
Yes.
And you responded by saying that the problem had something to do with a conflict between the approaches of the SCA and the Constitutional Court, but the question wasn't followed up, and I'm interested to do so now. What did you mean by that?
I don't know what you're referring to as what was said last time, but let's just take this issue one step at a time. The first issue is, as I understand it, is disrespect for or non-compliance with precedent. I think that's the first and most important issue. I think that's not correct. And I think as a statement, it's very important to accept what they're saying is true. We must, the stare decisis principle must be applied. Otherwise, rule of law becomes meaningless. There's no quarrel with that point. Did I not follow? That's the underlying theme. Did I not follow? And I see you nodding, meaning that's the question. That's what the focus is on. Did I not follow precedent? My answer is no, that's not correct. At the time Capitec was out, Bideka was not out. At the time I dealt with Capitec, I had written Atlantis, a very detailed and carefully thought out judgment, which judgment, by the way, has been supported by Froneman J in Bideka. Of course, he's a minority, but it was. If you look at his judgment, he talks about the same issues. But what I did in those cases is followed Botha versus Rich, which is also Constitutional Court authority.
Sorry, you followed what?
Botha versus Rich, which is Constitutional Court authority, which I drew from and looked at in the context of its previous Constitutional Court judgments. Barkhuizen was one of them, Everfresh was another one of them. And I said, this is the precedence that is coming out of the Constitutional Court. And applying that precedent, this is the conclusions I come. But at that stage, there was this debate as to what exactly is the one that's coming out of the Constitutional Court what's law, or is there a difference between what they're saying and what the SCA is saying? So I followed, as far as I can understand, the Constitutional Court. Since then, the Constitutional Court has clarified its position.
But in those cases you mentioned, pre-Bideka, the Constitutional Court in no way said that the express terms of a contract can be disregarded if it's unfair, in the view of the judge.
No, I don't know if we're on the same wavelength. I've never said that express terms can be disregarded just for that reason. I've said express terms must be interpreted in a specific form. And I said, if you need to look at Atlantis very carefully. You need to look at it because you can't read Capitec without reading Atlantis.
Judge, I can assure you I've read
And
those
so,
cases.
in Atlantis, I spell out what the Constitutional Court says as to what the approach should be. I then look at what the Constitutional Court did in Barkhuizen, what it did in Everfresh. I also say that what the Constitutional Court said in those cases appeared to be different from what the SCA said in Bredenkamp. And in Bredenkamp, they had their own in Bideka. Froneman tells us quite clearly, Bideka, as far as he's concerned, Bredenkamp, as far as he was concerned, is wrong. So I was grappling with those issues, but to say that I've just gone ahead, I don't know about unfairness. I spoke about good faith. And good faith is an important consideration. In fact, it's one that's bedeviling the contract law all over the world. And one of the better judgments is that in the Canadian courts. There's also Lord Steyn, who's a previous South African, who's also written a number of extrajudicial articles on good faith. So I've looked at good faith and I've looked at our courts' judgments on good faith. And I went right down to the beginning of it. So I don't think it's correct to say I ignored stare decisis, I ignored precedents.
But you did expressly follow your own minority judgment.
But it was following, but the judgment is followed, and I said in that minority judgment that I'm following constitutional court judgments. I'm following what the constitutional court has said. And that's where the difference lies.
And
It's a debate I'd love to have with you, and I'd love to have them with the judgments in front of us, all of those judgments.
Okay, I'll leave
And then you'd be able to see. I was just told I should be careful about being over-elaborate in my answers.
No, I accept that.
And I'd love to have this debate. In fact, after writing Atlantis, I was quite happy to give a lecture. In fact, I was invited by one group to come and lecture to their group members, and then they invited everyone else. And then I don't know what happened. I can't remember the entire details, and it didn't take place. So I was quite happy to face anybody and say, and discuss with academics, advocates, whoever, and say, let's look at it. This is an issue, of course, it's going to be a difficult issue. It's going to be with us for a long time.
Judge Valley, the fact remains that...
Has the point not been made, though,
I would just like to conclude this point.
Okay, all right.
With your permission.
Yeah. Let's just try to round off.
That the GCB points out 3 judgments of the SCA, which 2 of them expressly upbraid you for not following precedent. Those are the Capitec case and the municipal workers case. And in the De Beers case, they note that the judge was shocked by the sentence you imposed, suggesting again you haven't followed precedent.
Oh, that's a different matter now.
No,
Sorry, De Beers is a different issue.
Let me ask my question, Judge.
Yes.
There are 3 judgments that are pointed to here.
Okay, give me the paragraph number.
Paragraph 7.3.5.4. So we're on page 130.
7.3.5.4. Right. Sorry. 7.3.5.
No. 7.3. We're in the 7.3s. So 7.3.4.2.
That's the one about the LRA.
Yeah, that's South African Municipal Workers Union.
Okay, Ms. Steinberg, we heard earlier about forum shopping. This is a matter in which the union came to the High Court, and the question was whether the High Court has jurisdiction or the Labour Court has jurisdiction. I applied what I believed, or what was my understanding, of a constitutional court judgment called Kaba. Kaba is a judgment that talks about when you can go to the Labour Court and when you can go to the High Court. The SCA said no, they should never have come to the High Court, they should have gone to the Labour Court. I respect there were differences, we came to a different conclusion. But there was a constitutional court decision, and still anybody who knows labour law will know Kaba was a leading case. In the early days when we had this huge uncertainty as to when can you go to the Labour Court and when can you go to the High Court. And there's a number of judgments before that as to, well, I think they have concurrent jurisdiction, they have this. So this particular case there was a special plea, and it was a very long time ago, it was 2016. There was a special plea which said, you're in the wrong court. And I said, no, but they're not in the wrong court because they're not raising labour issues. They're not relying on labour law rights. And Kaba says, They can't come to this court when they're not, and that's the conclusion I came to. I've subsequently been overturned by someone. But you must, if you want to understand these issues, Commissioner Steinberg, you need to know a lot more about what the law stands for.
No, I take issue with that. You're suggesting I don't know what
No, I'm saying no, I'm not suggesting. Please, I apologize if that's the suggestion I made. No.
My final question. Are you saying then that in both cases where the SCA expressly upbraided you for not following clear precedent, they are wrong?
No, what I'm saying is, they may be right by saying, I misread Kaaba, but I applied Kaaba. No. Are we understanding each other, Ms. Steinberg?
We are, thank
Please,
you,
if there's any issues you've got, I'm happy to clarify them.
Thank you, Judge.
Thank you. Commissioner Lucas?
In the interest of time, let me forgo my opportunity. In the interest of time, yes, please.
Okay, thank you. Commissioner Moimang?
Thank you, Deputy Chief Justice. Good afternoon, Judge Bali.
Good afternoon. I can't see your name because you're not appearing on the screen.
Muimang.
Muimang.
Muimang, yeah.
Thank you, Commissioner Muimang.
Just two areas that I want to converse with Judge Valley. The first one is the question that you responded to in terms of what is to be done with contracts that are made by corruption.
Yes.
In the Transnet versus IGS Consulting. If we could just explain the importance of ensuring that the beneficiary of corruption do not benefit from the fruits of corruption. If you can just elaborate on that. But it's also linked to the point that was canvassed earlier on ECON versus ESCOM, because both are matters of state owned entities that were recently in the news, not only as a result of corruption, but also the issue of load shedding. And I think the thrust of the judgment respond positively to the calls to stem out corruption. Now, the second point is taking further the point that was raised by the minister in the matter between DA and the Minister of International Relations. And I appreciate the acknowledgement from your side that in certain instances this matter are polycentric. However, given the judgment, which is more or less similar to what happened with the al-Bashir matter, because in that instance, the executive took a political decision because of our approach to international relations, which is correctly captured in Chapter 7 of the National Development Plan. Our entry to the global politics is through Africa, and more so the relationship that our country has with the former frontline states and the SADC region in particular. Don't you think that sometimes in matters of this nature, the courts should exercise judicial restraint? And linked to that, don't you think that sometimes judgment of this nature are the one that leads to the criticism of our courts, and also Clarion calls for judicial deference in certain matters of this nature, and also calls for a change in terms of our democracy, moving away from constitutional democracy to parliamentary supremacy, under which judicial action is extremely limited and not much is expected on the proactive role of the judicial action. Thank you, Acting President. Thank you, Judge Valley.
Thank you. Acting President.
Thank you, Commissioner Moimang.
Acting President, I'm going to try and give a short answer. I just want to say I respect that there are polycentric issues. I also respect, and more importantly, this is one not focused on, I respect that the executive make decisions in ways and on basis very different from the way courts do. What we regard as law of evidence, they don't necessarily regard it. If they find something is a fact, they don't have to have it proven, and they make a decision on that. That said, so therefore I accept, and a third point I accept, is that courts must never assume that they have greater wisdom than other branches of government. But at the same time, I say that those branches of government must operate within the rule, within the Constitution and the law. I say courts too must do that. And I've done, and I say that's how we'll only solve this problem. I'm not sure, as far as issues of parliamentary supremacy and that is concerned, I don't want to get into that in this forum. I know it was not accepted by our government in 1993-94 when we had this changeover. We specifically went for constitutional democracy. What happens from now on, I don't know, it's not in my purview. That I leave for people better qualified than myself. Thank you.
Judge Valley, we are almost at the tail end of your interview. And before I excuse you, is there anything that you want to say to the Commission? And if so, I will allow you only 3 minutes.
Thank you, Chair.
Sorry, AP? Sorry, AP, have you remembered the people?
Oh, I'm sorry. I'm sorry, just bear with me for a moment, Judge Valley. Commissioners who are on the virtual platform, Commissioner Barnard.
Thank you, AP. Judge Valley, I'd like just want to take further the question about the criticism of the GCB regarding certain of the judgments. And the question I have is with regards to the judgments that have been overturned on appeal, what lessons have you learned? And I ask it specifically against the backdrop. I've categorized the criticisms of the higher courts of your work into 3 categories. One is regarding evidence. So in the Maropa versus Chemical Industries, which is referred to in 7.3.1.5, they criticize you for not interrogating evidence properly. And then in 7.3.54, in the Leka property versus right, the criticism launched by the court is your manner of conducting the trial by allowing a witness to read the evidence extensively from the affidavit. So those 2 I've categorized under evidence. The binding precedent, my colleague has already questioned you on. So that's the Capitec and the SA Municipal Workers Union, which were both dealt with it. In the SA Municipal Workers Union versus Mokgatla, it was said that you failed to follow 2 principles laid down by 2 constitutional court matters, or the principles like that. And then, of course, there's the errors in discretion with sentencing, which induced a sense of shock on appeal. So those are various things. So with all of that backdrop in mind, what are the lessons that you've learned from matters where matters have been taken on appeal?
No, I think it's very important to learn from other people as to where you went wrong. It's a hard job to sit alone first time round and make the decisions. And I accept that I've been overturned in these judgments. And I think the lesson to be learned is try and be more careful and take note of what they've said as to where you went wrong. So the next time you get the same case, I'll now know where to go. I'll look at what they've said with regard to that. So yes, I will take on board whatever criticisms they've made. If you want me to respond to each one of them, that's a different matter. I'm not sure I understand you to want me to do that.
No, it's just a question generally.
Generally, yes. No, then I've answered. Then I believe what it has taught me is just take note of what they've said if ever you get the same or similar case again. I will take that into account.
Sorry, I interrupt you.
Sorry?
No, okay, I thought I interrupted you. Sorry.
Oh, is it? Sorry, are you on? No, I was saying, as far as I will definitely take note of what they've said in those cases. But, I mean, as you say, you don't want me to respond to each specific one. So my answer is a simple one, which is they've pointed out to me very significant errors on my part, and I must take note of them, and I will take note of them. And then do so when I continue in my next case, other cases. I've done that. I will do that. I do not believe I have all the answers to all the problems.
Thank you. My last question is just, what would you say to if someone were to argue and say that, when there are matters being investigated by the JCC, it might be wise for the JCC to first, hold, wait the outcome of that before making a recommendation.
I would caution against following that approach in this case, because I believe that unfortunately that was brought to me so late, but I've explained why I think there's no merit in it, and I believe that the Supreme Court of Appeal has already pronounced on it. The Supreme Court of Appeal has found the judgment to be unimpeachable. And if that is so, then the judgment's correct. The complaint can have no merit in that circumstances. The complaint, and I've tried to explain here and now for the public and everybody to know what the complaint's about. And I've admitted where the error was, but it doesn't affect. It does not affect. It does not affect my answer, which is that there's no merit in it. And there's no reason to wait for that. There's no reason to wait for it. It's unfortunate it came to me so late. It came to me just a month ago. And there's a danger if you follow that, Commissioner, that somebody can just do that in the last minute. Something that happened last year. And if they can do that, then they can frustrate you. So you also have to take that into account, Commissioner. I can't see your name, Commissioner, so please accept my apology if I don't call you by your name.
Thank you very much. It's Commissioner Barnard, and you have answered. Thank you very much.
Thank you, Commissioner
That's my question.
Barnard. Thank you, Commissioner Barnard.
Just a small point of correction, Judge Vali. As I understand it, what went to the SCA was actually just an application for leave to appeal, which was dismissed.
Correct.
And you said the SCA has found your judgment unimpeachable.
Which means that no other court will come to a different conclusion.
I'm just reacting to the unimpeachable. The SCA has not delivered any judgment on the issue.
I'll accept that.
Yeah, it
But
may
when
just have agreed with the result
Yes.
you gave in your judgment.
Yes.
That's it. Just that tiny correction.
I'll accept that.
Yes.
A follow-up on DCJ, follow-up? Yes. Judge, I just want to, in most instances in a country where you have different courts, lower courts and superior court, there seems to be this idea that when a lower court is overturned by a superior court, as a matter of fact, the superior court is correct. And I think we will be doing ourselves a serious disservice if we adopt that kind of analogy. Yes, of course, lower courts can be wrong, but so too the superior courts. Now the question is, when you get a judgment of a superior court that overturns you, do you engage with it just to see perhaps maybe your reasoning maybe was flawed? How do you kind of like deal with it?
It's a complicated issue and it's a complicated question. First thing I must point out to you, sometimes the case they take to the Superior Court is not identical to the one they bring to you. They can change emphasis, they can change, it becomes more nuanced. So then you don't know whether you've learned any lesson when you read there because it was not put before you. So that's that. But where it was put before you and you came to a different conclusion, then you must accept. If you were wrong, you must accept it. And I'm accepting that. I don't think one must ever take the view that they're always wrong and you're always right. That's wrong. And anybody who holds that view, I think, needs to reconsider. So yes, and then the other view, sometimes the Superior Courts, sometimes you find the first judge has been upheld when it goes further. Good examples are a first judge gets overturned by the SCA, then gets upheld by the CC, Competition Court. That's happened so many times. So, but if you catch the person at the moment where we only have the SCA judgment, you'd say, but you made these errors. And then comes, of course, the Constitutional Court and they say, but we don't think there were those errors. So it's very hard. It's a very difficult situation. And of course, it will have to be dealt with on a case-specific basis. And you have to look at the criticisms carefully. You need to look at it. So yeah, I'm with you. I agree fully with you, Commissioner.
Thank you very much.
Commissioner Marumo
Agai.
Commissioner Breitenbach, do you have questions for Judge Valley?
Thank you, Deputy Chief Justice. I'm covered.
Oh, thank you. Judge Valley, I understand that my colleague on my right had given you an opportunity to address us.
Thank you very much.
Just briefly, if you have anything
Thank you. No, I don't have anything I wish to say. I just to say thank you for the opportunity to present my candidature to you.
Thank you to you.
Thank
too.
you. Well.
All right, you're excused.
Thank you all.
DCJ, it looks as though we are going way beyond the 15 minutes that you try to keep us to, or within. I think we need to strive. This board is capable of limiting its members to 2 questions, but only in extreme situations that we can go beyond 2 questions. And even those 2 questions must not be too, with preambles and all that. Thanks.
You're quite right. Well, it has not helped that some of the candidates tend to be long-winded, and I'm loath to interrupting a candidate in flight. Being interviewed is a tough experience as it is. But I think the responsibility lies with us just to be careful with the way we couch our questions. Half of what is put to candidates is actually not questions, but debates, and then ends up being a long dialogue.
And also that, DCJ, if you think your question has been answered, you can, inform the candidate that, no, I'm actually covered, so that he or she doesn't go beyond what you already were looking for.
But, Deputy Chief Justice, I thought it's lunchtime or something. I thought it's lunchtime. Because we are left with 2, and if we come back and take the approach that he is indicating, we'll still be in order.
I'm sorry. I was asking if we could not just interview the next one, because we should not be long with someone who's been here before, and then we can break off for lunch, especially after the the warnings that have just been issued by Commissioner Club, I think we'll be more exerting with how we ask our questions.
I thought the minister wants to come in here.
Oh,
The reality is that we are very hungry.
you are hungry? Yeah. All right.
And
Can't
it looks
argue
like
with
it's
that.
still two, so I think.
Can't argue with that. Okay. How long is this lunch going to be? A full hour? 30 minutes.
No,
Yes,
I
yesterday.
also want to speak about that issue of 30 minutes because remember that we work here and we work somewhere else. So during break, we try to respond to all of the things that are happening in this country and eat at the same time. So we take the 30 minutes to eat and take the 30 minutes to do some work. So and that's how we accepted to come and spend all of these days here. So when you restrict us to 30 minutes, we completely lose the whole week. It's not going to work for some of us because we're all sitting here knows some of other responsibilities that we hold in society. So it can't be that we are non-available for the whole week. So 30 minutes is for eating and 30 minutes is for doing some work and then come back and concentrate here because it's not decent that when a candidate is here, you see an important call, you rush outside. This committee looks like it's not organized. So we allow calls to pass because we'll attend to them during break. So 30 minutes, it disadvantages some of us.
Colleagues, what do you say to the...
Because when we adopted this thing, you said we have a break for 1 hour.
So we take an hour then?
Yeah, but when we come back, we strictly stick to what Honorable Kaba was saying.
3, we should not be making our way back here. We should be sitting here ready to start with the candidate. Is that a deal? All right. We'll come back at 3, at 5 to 3. Good afternoon, Judge Wiener.
Good afternoon, Justice Meyer.
How are you?
I'm fine, thank you.
All right. The JSC interviewed you for a position at the SA not so long ago.
Yes.
Just remind me, when was that?
April 2021.
It was just last year. Well, as I recall, at that interview, it was established beyond doubt that you're an experienced, hardworking, and efficient judge who is committed to transformation and mentoring and training of women and young and upcoming lawyers, which in fact is why the SA has kept inviting you back to act whenever there's been an emergency, and you have so many acting stints under your belt.
Yes.
But despite all that, you did not make the cut. And I think you'll recall well better than me that your age was a matter of concern for a number of the commissioners. I'm not saying that's why you were not recommended for appointment, but it was an issue. So I'm not going to waste your time. We have, we know who you are. We have your record of the recent proceedings. I just want you to tell us in your own words why the JSC, I mean, it's a year later now, you're a year older. Why should the JSC change its mind and recommend you?
Yes. Justice Meyer, as you know, in the past 3 or 4 years, the SCA has lost 11 of their senior judges, either through retirement or elevation. All had served more than 15 years. With my 33 years of experience at the bar, 15 years as a silk, and coming from the busiest division in the country, I do believe that I have the knowledge and experience which could be of benefit to the Supreme Court of Appeal at the moment with the experience that has been lost. I have been acting since when I took silk in 1995. I acted in the Gauteng, that was then the Transvaal Provincial Division, and then the Gauteng Division, for a few weeks every year or every couple of years. So I gained a lot of experience on the bench. And as J.P. Malambo pointed out last time, with the judiciary in particular, the more experience a judge has, the more resourceful and productive they can be. If I look at the Gauteng local division, for instance, the more experienced judges contribute enormously. They do a lot of the training and lecturing. They take on many case managements, commercial court matters, special motions, and they feel comfortable, as I did, dealing with virtually every sort of matter that may come before the courts. As will appear from some of the comments from the law bodies, my practice as a silk, as well as being a judge in Gauteng, I dealt with virtually every possible type of case that could come before those courts and before the SCA. You also feel more comfortable as an experienced judge to discuss things with colleagues that you might feel uncomfortable doing when you're a younger, less experienced judge. I have absolutely no qualms in going to my senior colleagues, and even some junior colleagues, I must say, who to discuss matters that I have, if I have some issue that might be worrying me. And I think as a younger judge, one feels that you might be regarded as stupid or inexperienced. So it's something that comes with age. And, you know, as one gets more experience, it makes things a lot easier, so that every day is not so quite challenging as the day before. With that experience and the knowledge acquired along the way, one hopes that fewer errors occur, and they're all part of the learning process that increases one's feelings of self-confidence and security. As you know, I first acted in the Supreme Court of Appeal in 2019. And unfortunately, there were no vacancies in 2019. And then there was 2020 was COVID. And in October 2021 and March 2022, there were no vacancies either. So I have sat in the SCA as an acting judge during all those periods when, if there had been vacancies, perhaps I would have been able to fill one of them. So although it is now sometime a year and a half down the line, and I then had approximately 6 years, and I now have 3.5 years, I do believe that with my experience that I've had, as I've set out in my practice as an acting judge, as a judge, and now as acting in the SCA for the past 4 years, that I can bring that wisdom and experience to be used to the benefit of the court. I have helped and mentored younger colleagues at the SCA and of course at the local, the Gauteng division, and I'm willing to do so and continue to do so. And I feel that I can still add a lot to the SCA, even if it is for a relatively short period of time. And I must say, it's not unprecedented. In the last interviews, 5 men who are either the same age as me or the same period of time left were appointed. And as was mentioned earlier by, I think it was Commissioner Malema, that our Chief Justice only has 3 years to go. So it's something that I believe I can add to the court. I can use my wisdom and experience, and hopefully I won't be taking up somebody else's position for a long period of time, which would allow the court to appoint someone else. I also think that transformation insofar as gender is concerned has been very slow in the legal profession, more so in the profession than the judiciary. But if one looks at the Supreme Court of Appeal, Judge Leonora van den Heever was appointed in 1991. After that was Judge Lewis, Van Heerden, Snyders, and Matlanta. But since 1991, there have been 18 women judges in the Supreme Court of Appeal, out of very, very many more men. It does remind one of what Ruth Bader Ginsburg said when she was asked, when will there be enough women on the Supreme Court in America? And she said, when there are 9. And they looked shocked, and she said, why? You weren't shocked when there were 9 men. So I think that transformation in the judiciary has advanced well, but as far as gender goes, it is still lacking. And as I will speak of more if I'm given the opportunity, the problem is that the transformation in the profession is slow. And if one's going to get gender and race parity on the judiciary, one has to look at the profession, because that's where judges are drawn from. And those sorts of transformation issues deserve to be dealt with in a very serious way. So I believe that I can contribute in that way. I've always been a mentor since my first years at the bar. I've assisted in aspirant judges training, in the acting judges training, in diversity training, and I believe that the intergenerational collaboration on a bench such as the Supreme Court of Appeal needs the diversity that comes from age, gender, and race, and that way the judiciary can actually be strengthened. So that is what I believe. I think that I can add to the experience needed at the Supreme Court of Appeal. There are other ways which I believe I've been quite, if I can put it, influential in seeking to develop social cohesion at the Supreme Court. I don't think many people realize that most judges that are there that are not based in Bloemfontein permanently all come there and rent out small Airbnbs or apartments and are basically alone. And what I've tried to do is arrange a dinner, and I have invited you, acting AP, once a week when judges are not sitting or when the presiders are not sitting. And we've got together something like 10 and 12 judges every week from right across the spectrum. And it's been a very enjoyable and social cohesive process, which I think has really added to the collegiality that is present at the SCA, and which I believe, Justice Meyer, you had an important role in developing that cohesion that exists at that bench at the moment. Sorry, I can't hear you.
Mic is not on. Do you have any health issues?
No. Not that, as you're all aware, I did have cancer in 2010, but I've been in remission since then. I've had one or two problems with my eyes this term, but it's due to my prescription having changed, and I've had to have new glasses. But I think that is for most people, if I look around the tables, that everybody at some point needs some sort of aid with spectacles.
Yes. Well, I can vouch for the fact that you're one of the fittest and healthiest, people I know in our age range, that is. All right, I'll hand over to my colleagues to put questions to you if they have any. Commissioner Nyambi, you may start asking your questions.
Thanks, thanks, DCJ. Afternoon, Judge.
Good afternoon, Commissioner.
I've read your interesting article that you wrote some years back about women at the bar. Where have the young girls gone? And if you look at the judiciary today, part of what we're grappling with is the reality that you spoke about, how they are excelling academically, but in all the divisions that we have in the country now, they are led by males. If you look back then what you wrote and the current challenges facing the country, what might be the challenge that is making the situation that we have that is not right?
You mean insofar as transformation of the profession and the bench is concerned?
Definitely.
Yes. There have been improvements, I must say. I've looked, when I was at the bar and when I became a senior counsel, I was the only female doing commercial law at the time, or contract law, not matrimonial law. But that has changed, especially in the high courts. I mean, there are several female silks now. There are several very competent young females doing commercial law, and one is proud to see that that has happened and that it continues to happen, and it's not that unusual to see females in these complex matters in the High Court. However, surprisingly enough, it doesn't filter through to the Supreme Court of Appeal. In the time that I've been there, in my matters, I've only had 3 female counsel who've appeared. They've been juniors, but those that have speaking parts, as they're so called, are very few and far between. I think that there are more females in the Constitutional Court appearing in the Constitutional Court and in commissions of inquiry and various other tribunals. But it seems to me that there's just so much that we as judges or even advocates at the bar can do, because it's a mindset that the profession has. It's a mindset that attorneys have. It's a mindset, unfortunately, that I think the state attorney has, because the briefing patterns, the biggest briefer is the state attorney. They have the most briefs, and they do not brief women as much as they brief men. And it is very difficult to understand why this is happening. And it really has to be a complete change of mindset. We did at the bar try various things, such as bringing in a third junior, which was paid for by the Silk, which I think has worked quite well. I did that throughout my career as a Silk. I would bring in young black or female juniors. And that way you get transfer of skills, you can recommend them to attorneys, etc. So it can happen from within the profession, as I think it has been happening. There are some excellent female Silks at the moment who are showing that it is certainly possible for them to advance. And as I say, it just needs to now lift up to where it becomes a matter of course as opposed to a matter of exception. But I believe there's still a lot of work to be done in that regard.
My last question. We interviewed you in April last year, as DCJ has indicated. Any particular thing that stand out that we have to consider this time around? What has happened in your life since then and now?
Well, since then, I've continued to act in the Supreme Court of Appeal. So I have, I think, shown my worth to Justice Meyer and Acting President Petse. And I have developed sort of more knowledge of the ways in which the SCA works. I've got a lot more experience. I have been called in to assist younger judges in some of the judgments that they're writing. And I've also been involved since then in a lot of judicial training, as I've said, of aspirant judges, of judges in the high courts. And I think that that has added to my experience and my ability to offer what I have to the Supreme Court of Appeal.
Thank you, Judge Wena. Thank you, DCJ.
Oh, she's missing.
Thank you, Commissioner Nyambi, but I'm not the DCJ, unfortunately. Commissioner Matolo Lepo.
Thank you, Acting Judge President. Good afternoon, Judge Wena.
Good afternoon, Commissioner.
I just wanted to, Commissioner Nyambi took everything that I wanted to ask you. I think maybe you are sitting next to me. But now I want to applaud you for the role that we are playing with training women in law. And to me, you know, we are one of the people, when we talk transformation, we can see it. And I hope you'll take it along wherever you are going, because you bring so much hope to these young women attorneys, especially attorneys. They really get excited when you speak about Judge Wayne, because they can actually give you a call and you respond. But just to follow up on what Commissioner Nyambi is saying, I think we have been speaking about, especially your article about where are the young women going. You know, some of us get very despondent, you know, because we've been preaching this women empowerment and it doesn't seem to move, you know. And we are trying, the legal sector code is not moving. So what other things can we do? I mean, it's just maybe a comment from you.
I think that there needs to be more effort made on individuals' parts, because insofar as institutions, big firms, and the state is concerned, sometimes the process is simply too complicated for them. But if one looks at it individually, and I know there are many, many men at the bar as well as women, and in the attorney's profession, where you are seeing women rising to higher positions in attorneys' firms, but there are many men and women at the bar who not only get involved in advocacy training and training of attorneys and helping development of skills, but development of skills only goes so far. One needs then to see some sort of result from this development of skills. And I think the way in which it's being done, and it just needs to be done more, is what I keep saying, is that young women, young blacks, and even at a higher level, need to be brought into matters. They need to be given a chance. That's all they're asking for. Because once they're given a chance and they prove themselves, they can go off and people will then want to brief them and want to bring them into matters. So it's really simply a thing of, please, will the senior people in the profession give people a chance? You know, it's this, there's this wonderful author called Peggy McIntosh who writes about the invisible knapsack of white and male privilege. And what she says is that white men are considered competent until the opposite is proved, whereas blacks and females are considered incompetent until the opposite is proved. And I think that is the biggest problem, that it is perceptions. It's immediately, if you're black or female, you're possibly unable to do the job. Whereas if you're a white male, it's simply taken for granted that you can. And that is where the whole process goes wrong. Just if the profession, if the state can give people a chance. I've tried even on the bench when I see, when I'm doing some training and I see potential in young blacks or women, or young black women, I immediately contact my colleagues at the bar and attorneys that I know that used to brief me. And I say, these people are excellent. Please bring them into your matters. And they do. So I think from an individual's point of view, it's one thing that people can do strong, in a more strong fashion and do that consistently.
Thank you very much.
Thank you, Commissioner Matolotutu. Commissioner Steinberg.
Thank you, Acting President. Just a comment, Judge Wiener.
Yes.
I also just want to acknowledge the extraordinary contribution that you've made to women. It's sad, but not all women actually support women. In a profession where we compete with each other.
Yes.
And you truly have been inspirational to generations of women and have not only trained but have opened doors, made opportunities, encouraged, and it's really a heartfelt thank you for that. And I also noted that this business with age seems to apply more to women than to men, and I am wondering why that's the case. Thank you.
Yes, that is a good question. Yes, thank you, Commissioner Steinberg.
Are you done, Commissioner Steinberg? Thank you. Professor Maru Bukhwai.
Thank you very much, AP. Good afternoon, Judge.
Good afternoon, Professor.
I've heard the benefit of reading some of your judgments, and I was quite intrigued on those particularly that you dealt with business rescue and your approach. But I'm not going to deal with those. There is one judgment that you wrote when you were still an acting judge. I hope you still remember it. And that judgment, I think, in the area of law which it was on, in my view, it is a seminal judgment in that area, and better than all the judgments that came even before, after it. F versus F, I'm not sure if you remember, it dealt with child location disputes.
Yes, Justice Meyer was in fact the judge who upheld my judgment in the SCA.
In fact, before it went there are two judges who agreed with you at And of course, Satchwell J disagreed with you and took a very feminist approach to it. And I will tell you why I'm raising this issue with you. In that judgment, you raised a serious question, which none of the judgments, including the judgment by Justice Meyer at the time, and Jackson versus Jackson as well, they did not grapple with that issue because they took a constitutional element and the rights of women and all those things. But you asked a very important question in relation to how do we look at the custodial parent who wants to actually relocate with the child. And the fact that she particularly wants to relocate, does that necessarily mean that that is in the best interest of the child? And I'm not sure if other judges, including the Supreme Court of Appeal, has actually grappled with that issue. By not looking at it from a feminist point of view, but just looking at the child and the parents who are looking. I'm not sure, do you have any view in relation to that?
Yes, I must be quite honest, and I appreciate your stating that it was a seminal judgment. I did consider it to be so as well, because there was, at that stage, I think it was 1990, it's here somewhere, it was simply assumed that women should get custody. And if they were relocating, it was a matter of course that the children would go with the mother. But this was one of those cases where the father had an equal input into the child's life. And I thought that one can't simply look at it as, well, the mother must get custody of the child because she's the mother. It was a very difficult decision, I must admit, because these relocation cases are tragic most of the time because there's one parent that gets left behind. But if I looked only at the best interests of the child, which was the test that I applied, the child did not want to be removed from her father. The mother had the option of staying here. It was simply more convenient for her to go back to the United Kingdom, where she said she might have more support, but she had no concrete reason to go. And I just believe that it was in the best interests of the child that it's taken into account what her father offers to her as well, and that whereas the mother had the option to choose between the two, she was not choosing the one option for very serious reasons. It was simply a preference on her part. And I believe that it was in the child's best interest not to allow the child to go with her.
Well, I think that is their best case in child relocation disputes. I've played a very central role in my thesis as well, and I want to say thank you to that.
Thank you, Professor.
Thank you, Professor Marumohai. Minister Lamula.
No, I'm covered.
Thank you, Minister. Commissioner Dodovo.
I'm also covered by Honorable Nyambi, Chair of the session.
Thank you, Commissioner Dodovo. Commissioner Magwanishe.
Just one question. Thank you very much, Acting President. Good afternoon, Judge.
Good afternoon, Commissioner.
It is just a follow-up from Commissioner Steinberg. In your experience as a judge and as an advocate, how has the system made women to be agents of patriarchy?
Sorry, just say that again. How's
How has the system made women to be agents of patriarchy within the legal profession?
It has certainly contributed to that. In a society such as ours, where patriarchy is so deeply embedded into our society, one has to realize the value of the participation and contribution that women can make to the system. And it is a barrier that has been up for much too long. The glass ceiling needs to be shattered. It has started to be shattered, but it needs to be completely destroyed. And when I gave you the example of men being looked at in the sense of they're competent just like that, whereas women have to prove themselves. That is proof of patriarchy. That is the assumption that people have. And to break that glass ceiling takes a lot of courage. I mean, I must have threatened to leave the bar at least once a week in my earlier years because it was so difficult. It was in the 1970s. I'm now really giving away my age. It was in the 1970s where it was simply unheard of. There were 6 women at the bar of, I think the bar was about 500 at that point. They were all doing matrimonial work, and I do not denigrate that in any way, but I simply didn't want to be put into this box of that is what you are going to do because we say so. So I wanted to escape that box, and I managed to do so. And I do believe, as I thank Commissioner Steinberg for saying, that I did have some influence on the progression of women at the bar and assisting them to break out of the cages into which they were put.
Thank you, President. Thank you, Judge.
Thank you, Commissioner Makwanisha. Commissioners Barnard and Bredenbach, any questions for the candidate?
Close it.
Yes, you may proceed, Commissioner Barnard.
Thank you, Judge Wiener. I noticed that you were on one of the Bobroff judgments.
Sorry, you see.
Around certain interpretation and transgressions of the Contingency Fees Act.
Yes.
And I know currently our minister is grappling with part of this as part of the South African Law Reform Commission's report that's lying on his table. Question is this, is how do you see the future of contingency fees in South Africa? What can work and what should happen in that regard?
I think that a contingency fee agreement in itself, there's nothing wrong with it, but I think it is being used by certain practitioners, or should I say it's being abused by certain practitioners, because at the end of the case, they simply say, well, this is what they've done. There's no checks and balances in that regard. And it has to be, I think, stringently regulated in the sense that if someone is going to enter into a contingency agreement, it needs more than simply this layman to sign a document saying they understand. There has to be something more that needs to be further regulated so that litigants know what they're getting themselves into. It can be checks and balances along the way as to each consultation or each appearance, because in that case, they were simply adding a 15,000 Rand fee, general fee to every case, every matter that they had as I'm not sure quite how they described it, but every case had a 15,000 Rand charge to the client. So it needs to be regulated, it needs to be very well supervised, and judicial scrutiny is essential. And I think that was part of the Maswanganyi case that was decided by the SCA it was actually my first judgment in the Supreme Court of Appeal, where judicial scrutiny was deemed to be essential, especially when public funds are being dispersed. So I think that there needs to be more regulation and stricter observance of the rules, and perhaps this is where the LPC may come in, although I know they're very overburdened. But these sorts of things need to be dealt with in a very stringent fashion.
Thank you, Judge. Thank you, Acting President.
Thank you, Commissioner Barnard. Commissioner Bredenbach.
Thank you, Acting President. I don't have a question, just a statement, and forgive me for not switching on my camera. We're having load shedding, so I've got serious connectivity issues at the moment. Good afternoon, Judge Wiener.
Good afternoon, Commissioner Breitenbach.
I just have a sort of a statement. I just want to agree with Commissioner Nyambi that age is not the determining factor, and that older people do have things to offer. And just to mention that your comments about the glass ceiling, certainly yourself and your colleagues at the bar at that time, yourself, women, others, inspired a lot of women, myself included, to get through that glass ceiling. So we owe you a great debt. Thank you.
Thank you, Commissioner.
Thank you, Commissioner Breitenbach. Judge Weiner, I see that your first acting stint at the SCA was in April 2019.
Yes.
And since then, you have acted for 9 terms in that court.
Correct.
And how many judgments did you write during that period?
I've got the note here. I wrote 15 judgments. And I think that 6 have been reported.
Thank you. I had the benefit of reading the record of your previous interview, and I couldn't pick up anything adverse, unless I missed out something.
I hope not.
And what would your response be to those colleagues who believe that, or who have some reservations about your judgment writing skills, especially writing for the SCA?
Well, I started off with a baptism of fire. My first judgment was written for Justice Meyer and Justice Wallace. And he certainly taught me a few lessons in my very first judgment. When I looked at it, though, it appeared that it was mainly structural, not so much the content, but the structure that he felt needed to be changed. There were one other judgment that I had some problems with, I admit, and I went to discuss it with both Justice Ponen and Justice Wallace. And we discussed it, and I worked it up with Justice Wallace. That was the, sorry, just let me get that. Umgeni water tariff matter, which Justice Wallace did change my original judgment quite substantially, which I accepted his changes, and in fact I suggested to him that the judgment go out in both our names. In fact, I first suggested to both Justice Ponen and Justice Wallace that it goes out in Justice Wallace's name, but they both said that I had put in a lot of work into the judgment and they thought that it should go out in both our names. It was then overturned by the Constitutional Court, and that is one of the judgments that isn't here insofar as judgments that have been successful on appeal. So there were 4 and that were mentioned, and this is the other one that came out later. And so, yes, there are 5 judgments in which my judgment has been overturned. So insofar as judgment writing is concerned, I think that I have produced good judgments. Most of them have been, other than those 2, the judgments have been well received with certain structural changes. It's a stylistic thing, and a lot of, some judges like to put up front what the case is about and they're the legislation, and others like to do it differently. So it is it's quite difficult to follow sometimes because you're not quite sure which way the presider will prefer. But I believe that I have written useful and constructive and good judgments in most of the cases.
From that experience you had with those two judgments, can you now reassure the Commission that you can produce proper and well-written, well-reasoned judgments for the SCA?
Well, I believe so. As I say, I've written 15 judgments, and those were the only two in which I received quite a lot of assistance, which I took on. They were both very senior judges, and I accepted what their advice and their comments that they'd made, and I hope that I learned from that and have gone on to write much better judgments since my first two.
Thank you.
Follow-up.
Before we excuse you, is there any other thing that you wish
Sorry,
to...
AP, can I follow up from the question that the last question that you wrote?
Oh, I beg your pardon, Professor, you may.
Yes, I said, can I please, I may. All right. Thank you very much, Judge. You know, the thing is, I'm getting some sense of unease with the way things are happening at the Supreme Court of Appeal, and perhaps one day we'll get a full sense of what is going on there. My discomfort is this. Judges are appointed to different divisions of the High Court, and they write many judgments. Well, we know writing, it's a different sport, right? And all of us have views on how other people write, and we can criticize each other, and that is fine, academically and in practice. There seems to be a way in which one writes for the Supreme Court of Appeal. And if one doesn't write in accordance with how one should write for the Supreme Court of Appeal, then the judgment might be thought, the draft might be thought of not being proper, not being adequate. I have some unease with that. And the question I want to pose to you is this. When judges comment on your draft, genuinely, when you receive the comments, do you genuinely believe that they improve and help you, or is it a matter of conforming to what is going on in that court? Because they are seniors and they are assisting you. I just want to understand your true and honest feeling in the assistance that you got in relation to the initial judgment because I have a serious unease with what I'm hearing is happening at the Supreme Court of Appeal. Thank you.
Yes, I understand your sense of unease, and I think not so much today, but a few years ago, like when I first started acting, there were certain judges who have certain ways that they thought judgments should be written. It was my very first judgment in the SCA, so I was a little unsure because there is a different writing style in the SCA. One doesn't go through all the facts and etc. One tries to keep it concise and on the particular point. It was an interesting judgment because, in fact, I thought that I was going to dissent from everybody in that judgment. That was the Masangani case about the RAF and agreements. Because when we first started discussing it, they all said, well, you know, it's an agreement and the parties concluded it and etc. And I said, one needs to understand what goes on in the high courts, such as my division, where we get hundreds of RAF cases. And there is a scam going on. People are being paid money. You get an agreement and it says 2 million rand and the person sprained their ankle. And I said, we have to look at these judgments, at these agreements, because this cannot carry on. No wonder the RAF is bankrupt. So I managed to convince, well, I think Justice Meyer was already on that side, and Judge Wallace also came over. There were 2 dissenting judges in that matter. But I did think that this is my first case. These are very senior judges. I can learn from them. In the end, the judgment was structurally slightly different to what I'd prepared, but I thought that my judgment was adequate, but I took the advice and I took the comments simply because...
No, thank you. I think you have answered me.
Yes, thank you.
Thank you, AP.
Thank you, Professor Moromokhai. Judge Weiner, you would of course know that when colleagues provide you with their suggestions, it is up to the scribe
Yes.
To decide whether you want to adopt or reject them.
Yes, absolutely.
And indeed, some colleagues would even say so in so many words, here are my suggestions, please adopt or reject as you
Yes.
wish.
That does happen, and I have done that ever since I have been writing judgments in the SCA. As I say, I did, when there are valid comments and contributions, I will adopt them, but I'm also independent enough, I think, to believe that what I think is a good judgment is in fact so.
Thank you. Is there any other thing that you would want to draw to the attention of the Commission before we release you?
Well, there's just some stats, if I can say, that since I've been a judge, I've written, as far as I can see from the records, 224 judgments. There are over 30 that I could find only recently. For some reason, the earlier judgments didn't come up in my searches, but there are 30 that have been reported. Since 2018, I've written 70 judgments, and 13 have been reported. So I believe that I have the experience from my years. As I've stated, I don't want to repeat myself, and that experience can be of a benefit to the SCA for the time that I have left to serve and which time I would like to serve on the SCA. Thank you.
Thank you, Judge Weiner. Just bear with me for a moment. Judge Weiner.
Yes.
Judge President Mlambo.
Oh, sorry, JP.
There's a short question for you.
Yes.
Good afternoon, Judge Weiner.
Yes.
This is basically a follow-up to the transformation questions that were raised with you earlier. I think I'm just asking for your views, if you have any, about how we can deal with it. My experience since I became JP of Gauteng, even with the labor courts, is when it comes to senior members of the profession, they do not easily avail themselves for acting appointments.
Yes.
Both black and white. And the trend is it's the recently acquired silks who usually avail themselves even for permanent appointment.
Yes.
It is a hurdle, it is a challenge to us as heads of courts, because we need to address the challenge that has been mentioned here of lack of leadership from the female ranks in the judiciary.
Yes.
Do you have any comments to what I'm saying? Because we really need help.
I think that the seniors at the bar, and I'm not sure of the attorney's profession because I wasn't a member, have abdicated their responsibility to both the judiciary and to the bar. If you look at the bar councils, they consist of very junior members. The silks are junior silks. None of the senior people avail themselves of those positions. It is a great responsibility, I concede, but it is something that is so essential for the administration of justice, for the rule of law, that those people make themselves available. And I'm not sure if this is what you do, but I would, if I can just give a little piece of unasked for advice, I would ask the senior silks to give you a time, throughout any time in the year, where they are prepared to serve for even 2 weeks, because having them on the bench adds gravitas to the bench. It will make people want to appear more frequently. We know that people are going to arbitration, and I think that if there were senior silks who don't avail themselves for a permanent position, but if they make themselves available to act for a certain period of time, I think that that would assist. And as I say, I really do believe that the senior silks have abdicated their responsibilities.
Thank you, JP. Judge Winner, we have now come to the end of your interview.
Thank you.
And you are excused at this stage. Thank you.
Thank you.
You let me know when you are ready, Judge Matutjani.
I'm ready, Deputy Chief Justice.
Are you comfortable over there?
Yes, I am.
Okay. My goodness. You hold a number of academic qualifications. A B.Proc, an LLB, diploma in trial advocacy, 2 LLMs, and another diploma in corporate law.
Yes, Deputy Chief Justice.
And I see that you would have completed Well, almost all of them while you were already working.
Yes.
How did you manage that? Where did you find the time?
Chief Justice, remember when the new constitutional dispensation came into being, it was important for some of us to go back to school to study afresh constitutional law. And I did a master's by coursework in, I think it was criminal procedure, constitutional law, and evidence.
We are struggling to hear you. Perhaps
Yes.
bring your mic closer to you.
Sorry about that,
Oh,
Chief
that's better.
Justice. I was just saying in passing that after the new constitutional dispensation, some of us found the need to go back to school to sharpen and acquire new knowledge in constitutional litigation.
You started your legal career in 1992. No, it was before that. Oh, you did your articles of clerkship, then immediately became partner.
Yes.
You started your own firm.
No, I first did my article of clerkship for 2 years.
Yes.
Then thereafter started my own firm.
Was that a successful practice? How did things pan out?
Yes, as time goes on, the firm grew and it became, at one stage, I had 4 partners. So we're relatively busy.
And you remained an attorney until you joined the bench in 2010?
Yes, I think around 1995, I received permission to appear in the High Court, and I did a lot of appearances in the High Court whilst being an attorney.
And in these 12 years, you have also acted at the Constitutional Court?
Yes, I've acted first as a judge at the Land Claims Court, then I acted as the judge president at the very same court, then thereafter I subsequently acted as an acting deputy judge president at the Johannesburg High Court. I was also appointed as an acting judge at the Constitutional Court of Lesotho. I also acted for a stint at the Constitutional Court here in South Africa.
Yes. How long were you at our Constitutional Court?
It was for a term.
And you have, of course, acted at the Supreme Court of Appeal for
Yes.
a while now.
I have acted at the Supreme Court of Appeal for 6 terms.
Start there. When was your first acting stint?
Sorry, can you come again?
When was your first acting stint at the SCA? Do you remember?
I think October to December 2018.
And how have you found that experience?
I found it enriching. One was working with judges with institutional memory of many years, very intelligent, and it was interesting that, you write judgment, you are taken on appeal, you are either set aside or upheld. Now it becomes different when you now have to sit in judgment over your colleagues, and I think the experience was enriching, I must say.
And how did your judgment, well, I know for a fact that you write quite well, you write good judgments. How did you square up against the senior judges there generally? Did you get positive feedback on your judgments, on your draft judgments?
Yeah, the interesting thing is you have 5 judges writing one judgment. You are a scribe, you circulate your first draft. All 5 of them are likely to comment and make suggestions. And you have a choice. You can either reject their suggestions or proposal, or you can incorporate their suggestions. This, in my view, strengthens the quality of your judgment. You cannot say, because I am a scribe, I'm going to be arrogant and say, look, I'm not open to suggestions. I learned that nothing beats experience. Just to cite an example briefly, we had a matter where I was a scribe. It was a very complicated matter. And the presider there, on the day of the hearing, identified one point that disposed of the whole case. When we got to court, counsel readily conceded, and the appeal was abandoned. I asked this particular judge, I could mention his name, Judge Nafs. I said, but look, I've been reading this voluminous record for this long, and you are able to pick up one point that disposed of the whole case. How do you do that? He said to me, look, this experience, I've been doing this kind of work for many years, this type of cases. And I imagine that if I had given him my draft after I had exerted myself, I mean, his depth of experience would have been such that that draft of mine would have been changed substantially. The point I want to make is institutional memory experience counts a lot and assists in strengthening judgments. So I do not see any problem in having a colleague strengthening my judgment, even to the point of changing it substantially, simply because I don't believe that there's a senior judge who would append his signature to a judgment he's not satisfied with.
Yes. Did you get an opportunity to write a judgment when you were at the Constitutional Court? I am aware.
Yes,
of
I wrote a
Class A.
seminal judgment at the
Yes.
Constitutional Court, Class A and another.
Mm-hmm.
It dealt with, I think, that case exposed patriarchy even in our court system. Mrs. Klasse lived in a farm as a seasonal worker for over 46 years. Her husband got into a fight and he was dismissed. The matter went to court. The landowner got an eviction order that evicted Mr. Klasse and all those who occupy through him, which meant that Mrs. Klasse was evicted arbitrarily. She wasn't afforded a hearing. Her circumstances were not considered, and she had children and grandchildren that she had to look after. The magistrate and the Land Claim Court said that her occupation in the farm was through her husband, so she did not have agency. It wasn't necessary that she be considered. So I felt that our Constitution enjoins us to give effect to the rights that are enshrined in the Constitution, and that the ESTA has to be interpreted in such a manner that it's constitutionally compliant. So I concluded that she ought to have been joined in the proceedings so that her personal circumstances could also be considered.
I see that you managed to pull along luminaries such as former DCJ Museneke, Justice Cameron, and many others in that court, in
Yes.
that judgment of yours.
Yes, it was a very interesting academic challenge. Even at the Constitutional Court, you have 11 judges writing one judgment. They are not mere spectators who only correct grammars and put a tick there. They would come with proposal, even substantive proposals, and you must decide whether do you incorporate them or not. So it's not always a surprise if the first draft is completely different from the final product, because you have all these highly experienced senior judges also contributing to the writing of the judgment.
You have written a great many judgments from the High Court and in the other courts in which you've sat. How many of those did you write for the SCA?
For the SCA, I think I wrote about 7.
Mm-hmm. Were you able to get them delivered promptly?
Yes, they were delivered promptly in term, and at the High Court, I had a turnaround time of a week or 2 in delivering judgment.
Yeah.
For the simple reason that the Gauteng is a very busy division. Litigants want judgments, and if you put a judgment aside hoping that you'll have time to write a reportable judgment, it's not possible in Gauteng. It's just unbelievably hectic.
I see that you're also a member of the Women Judges Association. How did that come about? Are you a feminist?
Yes, I got to know of the organization, its aims, and its desire to crystallize the needs and aspiration of women judges and advance them. And I shared those ideals, and our local branch would send female law students to us that we mentor. They shadow us. And I found that to be invaluable, because some of us during our time, it was unthinkable to sit down and talk to a judge informally. So what I would normally do is, before going to court, I would give them a file just to go through. I remember in my case, when I finished my LLB, I had never seen a summons. So I would normally give them a file, go through it, we go to court, they listen to the arguments. After the hearing, we come back, we sit down, and we talk. So, in my view, that's another way of, showing these young and upcoming lawyers that everything is possible.
What do you think of gender representativity at the SCA? Are there enough women judges there?
Chief Justice Maya, it's, in my view...
It's Deputy Chief Justice...
Deputy Chief Justice. Let me
please.
Put it. In my view, diversity is not equal to representativity. In my view, maybe to give you an illustration, when I was acting as a GP at the Land Claims Court, I had occasion to attend the meeting of heads of courts. There was only one female judge, Monica Judge Leo. I think she is now retired. So it's all males. I got the feeling that this body, this deliberative body, is missing the diverse experience in law and social life of female judges. I just feel that when we talk about diversity or gender parity, the important point should be that women must also be heard. They have an experience to share. In deliberation, you don't have to agree with them, but hear them. There is just no reason why women should not be treated the same as men. In all my formative years at school, even at university, and even at the court, I've always had women beating me. I don't know why. I mean, I would always get position 2, and then it will be Dockers who always got position 1. And
I think that's a common trend across the eons of time.
Yes, it's...
Judge Matojan, and there can only be one reason why they always come tops.
It's Patrick.
Not
Okay.
far to seek.
Yes,
Yes.
Chief Justice Mike.
I know this is an unfair question to ask, but I'll ask it anyway.
Yes.
We have 5 vacancies here and 11 candidates. 1, 2, 3, and 4. Only 4 of these 11 candidates are women. Now, I'm not saying that these women candidates are not as strong as the male candidates, but experience has shown that because women are still being disadvantaged, they're always at the bottom of the heap. They rarely get a chance to write quality judgments even when they do get to this level in the judiciary, that is. So more often than not, women are always, they will lag behind the men in terms of experience. Now, if you were sitting where I'm sitting and you had to make a choice, and it transpired that the women candidates were not as experienced as the male candidates, but unquestionably the potential is there, what would you do? Or maybe you don't have to put yourself in my shoes, just advise me.
Let me preface my answer by saying, if you have a tattoo on your face, you must want it. The point I'm trying to say is, yes, I am for gender parity. Yes, I wouldn't really quibble if a female candidate is appointed over me. I would have no problem with that. The point I want to say is, this job, no social life, nothing. You must want it. Whether you're a man or a woman, you must want it. So the answer to your question, Justice Meyer, is I would have no problem in having a female judge appointed ahead of me, because in any event, that's a constitutional imperative.
Thank you for that.
Thanks.
Yeah. All right, I think this would be an opportune moment to hand over to my colleagues. You may start, Commissioner Marumakhai.
Thank you very much, Thank you very much, Deputy Chief Justice. Good afternoon, Judge. I'm here.
Oh, sorry. Sorry, sir. Commissioner?
I've had the benefit of reading some of your judgment. There is a judgment that you wrote, which I really thought it was a very good judgment, on Section 8, subsection B of the Insolvency Act.
Yes.
Dealing with the nulla bona returns and all those things. I thought that was a good judgment.
Thanks, Commissioner.
But nonetheless, I just want to ask you about something that really has, ever since I joined this body, it has sat with me in relation to what is happening in the Supreme Court of Appeal.
Yes.
As a court. I realized that, and please just bear with me, I realized that the most recent case or judgment that was delivered by the Constitutional Court, it has about 44 pages, right? And you'll understand now as to where I'm going. And in that judgment, you have majority of the judges from that judgment are from the Supreme Court of Appeal, right? And it is written by the judge who was elevated from the Supreme Court of Appeal, Mhlantla. And you have Majid, you have Matopo, Theron, GT. All those are from the Supreme Court of Appeal.
Yes.
Now, having that information in line, there is a judgment that you wrote quite recently from the Supreme Court of Appeal. The Rada Meya versus Ferreira.
Yes.
You remember it?
Yes.
It's about 10 pages, right? 10 pages, the whole judgment.
Yes.
And the judgment that you wrote when you were at the Constitutional Court, that last judgment.
Yes.
That judgment is about 96 pages.
Yes.
And you wrote about 31 pages of that judgment.
Yes.
Now, my question is this. There is a view that when you are at the Supreme Court of Appeal, you write concisely, you write straight to the point, you get rid of things, right?
Yes.
So now, as a judge who was at the Constitutional Court, I'm not sure at that point if you are able to come up with, and it doesn't mean that when you write longer, the judgment becomes automatically good. And equally so, it doesn't mean when you are writing shorter, the judgment automatically becomes good, right?
Yes.
I just want to understand, what is this thing at the Supreme Court of Appeal in terms of this length of judgments, that when you get to that, because I've seen some of your judgments at the High Court, they are relatively longer.
Yes.
Why is it that when you get to that court, what is so special about that court, that the judgments of that court has to be of a specific length? And if they are of that length, then they are concise. Because in my view, the judgment that you wrote in the Constitutional Court, 31 pages, it's concise and it's well reasoned. And I agree with it fully. So that's the thing that I'm really struggling with to understand. Can you please just help me in that one?
Thanks, Commissioner, for your question. Personally, I believe that as judges, we write judgments for the losing party. They want to understand why they lost. And it doesn't help matters if you waffle and restate the common law, and instead of just being precise, to the point, and give the reasons for your judgment so that whoever lost would be in a position to can consider his or her position, decide whether he or she wants to appeal or to save money by not proceeding further with the matter. The appeal court wants your reason so that they can decide whether you are right or wrong. Coming back to your question, at the SCA, you get told that they've got judgment style. And if you don't follow that judgment style, believe you me, a lot will be said about you. Coming to the Constitutional Court, they also have their style. And you just have to follow that style. It's understandable in the case of a constitutional court because then they would have to start by summarizing the issues that were before the High Court, the SCA, and then they would then have to deal with the issues that are before the Constitutional Court. So in summary, the answer that I can give you is yes, at the SCA, they've got a style that you just have to follow.
Thank you very much for your honesty, because I think there is a serious disconnect. It cannot be that a judge in the High Court behaves in a particular way,
Yes.
and then he goes to the Supreme Court of Appeal, is expected to behave in a certain way.
Yes.
Then that judge goes to the Constitutional Court, and that has to disregard everything that happened at the Supreme Court,
Yes.
Supreme Court of Appeal. I think there is a serious disjointment that needs to be really taken. But it's fine, I wouldn't take it further than that.
Thanks, Commissioner. And maybe just to add on what you've just said, Commissioner, it would be ideal and it will help in the transfer of skills if you can be told there and there that your judgment is terrible, your judgment, I mean, what's the point of not telling me that I can't write the judgment at this stage? I mean, you have a presider, is a senior judge, highly experienced. He's quality assuring your judgment. And if he sees that you are lost, you don't know what you're doing, what is that senior judge's responsibility if he genuinely wants to transfer skills to an acting judge?
Thank you very much.
Thanks, Commissioner.
Thank you, DCJ. Good afternoon, Judge. I'm just next to you.
Yes, thanks, Commissioner. Please.
Firstly, my first question is just a follow-up to your debate, your discussion with the DCJ. For a judge who seeks appointment to the SCA,
yes,
and a judge who seeks appointment as a judge to the High Court, it's just,
yes,
would you agree with me that we should actually apply a different standard in respect of consideration of these candidates? Because in respect of the judge for the High Court who applies for the High Court, definitely we have to look onto the potential of this candidate, whether does she have a potential, taking into account the fact that it's coming from practice, acting judge and so forth. For the SCA, there's somebody now who comes because that court is a national appeals court. That's a national appeal court, and it must, in a way, settle the precedent. It must develop the law, because it's just from it, it's just a constitutional court. From there is a constitutional. So what would you say on that?
Commissioner, I would say that there is no substitute for experience. If you are inexperienced, you do the heavy lifting. And I remember when I was writing this classic judgment, Judge Cameron said to me, have you considered such a case? When I went to look for that case, it was his judgment as a judge in the High Court. I mean, this person started at the High Court, he was senior counsel, judge at the High Court, judge at the SCA. He's now at the Concord, and you are sitting in conference. So, for an inexperienced judge like me, you had to read everything. For an experienced judge like him, I mean, he just suggests to you, have you considered such and such a judgment? Have you, in most cases, you find that he has written over that topic. He knows everything about it. So the point I'm making is this, that you can have a senior counsel, highly experienced, who can go straight to the Constitutional Court. You can have a highly experienced SC who who doesn't belong in the High Court. So it's, I don't have a specific answer, but the point here is this august body has to decide based on the judgments of a particular candidate whether this person has acquired sufficient, if it's in the case of an SCA, general knowledge of the law.
Yeah, my last question pertains to this debate with the Prof here, about the length of judgment, stance in the court of judgment. Is it not that at the level of the High Court, for instance, is
Yes.
where at the High Court is where you will hear evidence, witnesses there, and then the first judgment comes. And when you appeal, issues get crystallized, they are narrowed. By the time you get to the SCA, the issues are so pointed such that you won't be rewriting the entire evidence because issues have crystallized, you have a judgment in front of you. That's the first point.
Yes.
That in respect of the length of that judgment. I'm just thinking. And then in the constitutional court, obviously you start with the application for leave to appeal. You have to determine issues of the leave to be granted and other issues. And that's the final court of appeal. It has to define the issues that, would we really expect this court to write or to have judgments which are similar in nature, really? Would it be surprising that the judgment at the SCA would be short, precise, at the SCA would be have lengthy judgment, you have 11 judges involved, and with all those applications that comes in between?
I don't know if I understood the question, but what I can tell you is I was a court of first instance in that all pay, the so-called SASSA matter. It's one of the biggest tender to be awarded by the government. The tender was flawed, and I declared it unlawful, and I couldn't set it aside for the simple reason that I was told that to reconstitute the bids, to re-adjudicate this tender, it would take 3 years to reconstitute the bids adjudication committee because senior people in government, director general. So it meant, had I cancelled that contract, it meant that pensioners were not going to receive their grants. Children-headed families were not going to. In fact, there would have been a revolution had I set that contract aside. Now, when the matter came before the SCA, I remember I was set aside, and the matter went to the Constitutional Court, and ultimately the Constitutional Court granted the structural integrity. The point I want to say is the issues that were before me, by the time they went to the SCA and they were now refined. In most cases at the SCA, you have senior experienced counsel who'd really made concessions. They wouldn't just argue a point for the sake of arguing it. And they're helpful to the court. They would make you aware of judgments that does not even support them. So issues get narrowed, issues get defined, and I mean, when I read the judgment of the SCA and the Con Court, the issues being debated there were not before me.
Thank you, Judge.
Yes.
Yeah.
Thank you, Commissioner Nagesi. Commissioner Malema.
Thank you, Acting President. Judge, I just want to understand why what is your understanding in terms of why our prison system is called correctional services?
I think the idea is to try to reform offenders. Hence, even the language, they're not called prisoners and all that. They would refer them as I think the whole idea is to rehabilitate with the intention of reintroducing these offenders back into society.
So in the rehabilitation of these inmates and reintegrating them into society, what will the society benefit if we were to incarcerate an 8-year-old, rehabilitate and integrate into society? Because by the time he gets back into society, there's no longer a human being there.
I think you're asking a very good question, Mr.
There remains.
You're asking a very good question, Mr. Malema. But my answer to you is this, that you should understand the nature of our work as judges. Parties bring their dispute to us before court. Parties have legal representation who formulate the issues, who would refer you to authorities, decided cases and all that. And then, much as you have a wide discretion, you can't go beyond what is before you. You can't go on a frolic of your own, do your own little research on the corner there, and put it in a judgment because you think that is right. Your hands are tied in the sense that you are called upon to discuss a live issue. You are not called upon to speculate. You cannot, I mean, the question that you are asking me is really hypothetical. And the nature of my job is to hear evidence, be open to persuasion by counsel on both sides, research the law, and make an order in line with the arguments that have been presented before me. If I want to do my own private research, I must invite the lawyers to make supplementary heads, deal with what I think is a correct position. So, in short, Mr. Malema, the point I'm making to you is this, that as judges, we do not deal with hypothetical cases. Cases are fact-specific. You are guided by the facts of the particular case, the arguments that is presented before you, and then you are able to write the judgment.
But Judge Matojani, part of your responsibility as a judge is to take into consideration the budgetary issues, the interest of the country. I'm asking it hypothetically because I don't want to get into trouble. The last time you were here, I asked you a question, I got into trouble.
You want to get me into trouble also by asking a hypothetical question.
And I was alone. So I'm trying to think, because objectively and subjectively, all those factors have to be taken into consideration, that ours is to correct and reintegrate. And if you bring a frail, sick, old man before me and you want me to imprison, even if the facts are like, I can hear you, you're correct and all of that, it is in the best interest, is it in the best interest of our society to incarcerate old people who are not in line with what correctional service system seeks to achieve, which is rehabilitation and reintegration into society?
My short answer to you, Mr. Malema, is this, that you want to get me into trouble by giving an opinion on a hypothetical set of facts. And I'm saying to you, as a judge, I don't go out, look for cases and bring them before me for adjudication. It is the parties who come to me with their dispute. And my job is to adjudicate. And secondly, I know where you are going with that question. That matter is pending before the Supreme Court of Appeal. The lawyers use the term functus officio. I'm out of it. Whether I'm right or wrong, a higher court is going to relook at the evidence, and then they'll decide. If I'm wrong, they'll say so. So it's not really for me to answer that question, Mr. Malema, with due respect.
With due respect, Judge, I don't know which case you're talking about, because I'm talking about correctional, because we moved from prison system to
Yes.
correctional system, from prisoners to inmate,
Yes.
with the objective of exactly what I was saying. But if you are uncomfortable, it's okay. I'll leave it there. But because I'm worried, acting president, that what type of society will we become in line with corrective measures to imprison elderly people who are not going to benefit anything from them? Because if we invest, correctional system, in my understanding, is to invest in this person, rebuild this person, and take this person back to society to continue to contribute positively into society.
Yeah, but Mr. Malema, are you not raising that in a wrong forum? You are a public representative. You are elected to Parliament to go and make laws.
Yes.
This is an issue which, in my view, you should raise in Parliament.
You also make laws.
Judges don't make law.
There's case laws you make.
Mr.
Judges
Malema,
who are scared to make case laws are cowards.
Okay, let's see what the Constitution says.
That I appreciate, but I'm saying you make case laws. That's why there's always case law referred to by many others, including ourselves.
Malema,
Commissioner
Commissioner Malema, I'm sorry.
No, you can say Malema, I'm too young to you. You can call me anything you want to call me.
What I'm saying...
Excuse me, Judge
yes,
Matojana. Commissioner Malema, please be mindful. We reiterated before our lunch adjournment that commissioners must please confine themselves to the conventions of the commission. You are allowed 2 questions, and that's it, other than follow-ups. I think you have now exhausted your questions.
No, I raised one uncomfortable question, and I'm ready to leave it, because I can see you're also becoming uncomfortable.
I didn't get that, Commissioner. Are you done?
I raised one uncomfortable question. I didn't raise too many questions. I didn't raise 2. I raised 1, but I'm saying I can see you're becoming uncomfortable with it. I'm ready to let go of it.
Please, if you don't mind. Thank you.
Okay, thank you, Acting President.
Thank you, Commissioner. Commissioner Matolo-Zeppo.
Thank you, Acting Judge President. Good afternoon, Judge Matojana.
Yes, I can hear you.
Good afternoon, Judge Matojana.
Good afternoon, Commissioner Zeppo.
I've known you from the BLA when we were still young.
Yes.
Yes, that's why I'm declaring. And mine is just a comment. You know, you are very meticulous in your training, trial advocacy, and I really sometimes admire you.
Yes, I'm passionate about
yes. But and you've got so much experience, commercial law, and you know. What I just want to find out, why don't we attract people of your caliber to book competition?
To do what?
To the competition court or the land claims court, why will everybody want to go to the SCA? Why is it not appealing or what? The Competition Commission Court? The Competition Court or the land claims? I just want to find out, yeah. Is there anything that doesn't attract people to go there?
With the land claims court, I do know that there was uncertainty for a long period of time. There were no permanent judges. It's now that permanent judges are being appointed to that court, and I want to believe that it's going to be fully functional, and advocates and attorneys would get to know that court and what it's all about. And then you're referring to the other court. Which one was that? The commercial court.
Competition Appeals Court.
Competition Appeals Court. I'm speculating here. That could have to deal with briefing patterns. I remember my second master's was in competition law, because I mean, then would do divorces, array of matters and all. I wanted to get into that field, but you would know how difficult it is. I mean, conveyancing was ring-fenced. If you were not of the right color, you wouldn't get conveyancing work. Now, the government really, are they briefing black people in competition matters? I mean, I did this matter of ComAir against SAA. That matter was argued for 45 days every day. And they had a running record. Overnight, you'd get a transcription of the proceedings that took place the following day. The counsel who were appearing before me started the matter at the commission. The matter went to the tribunal and to the Competition Appeal Court. When it came to me, it was for quantification of damages. I tell you, all those counsels were unbelievably good. They knew the facts, the issues, as they knew the back of their hands. I don't take it away from them that they were capable, highly experienced clerks, but the fact of the matter is they started with this matter at the commission, tribunal, appeal court, and when they came before me, I tell you, the matter was voluminous. I mean, there were over 100 Acliver files. Witnesses were brought from London to come and testify. Everything was technical. The various experts that testified there also testified from the commission, tribunal, appeal court. So if it's easy to think that you would never reach that level, you have to be a genius, you have to have, exceptional abilities. In my view, given a chance, even puny judge like me, if I had started with a matter at the commission, tribunal, appeal court, when I come to court to argue quantum, I think I will excel. The point I'm saying is opportunities. Do people have opportunities to acquire the necessary experience and expertise?
Thank you.
Follow up, CJ.
Yes, you may proceed, Professor.
Judge Matojani?
Yes.
I'm here.
Yes, okay.
Yes. I think the question that was asked was, as a judge, why do people of the capabilities that you have will opt to go and be presiding officers at the Supreme Court of Appeal, as opposed to the Competition Appeals Court and the Land Claims Court, or even the Labor Appeal Court, perhaps, which I'm just adding there. Because those are specialized courts that can use people with your ability. I think that was the question, not necessarily from the practitioner's point of view and the opportunities that people get.
Yes, speaking for myself, with my master's in competition law, why am I not applying to the Competition Appeal Court? I never got briefed in that field of work. I only have the academic theory. I don't have practical exposure to that type of work. So I think I'll fail if I can apply to be a judge at the Competition Appeal Court.
Thank you, AP.
Thanks.
Thank you,
Commissioner.
Professor Muramukhai. Commissioner Nyambi? Or have you been taken care of?
No, I've been taken care of, Acting President, I'm fine.
Thank you, Commissioner Nyambi. Commissioner Muiman?
Thank you, Acting President. Good afternoon, Judge Matujani.
Good afternoon, Commissioner.
Just two areas from my side. What is that could be done to make the public aware of the provision of Section 165, 1 up to 3, that talks to the vesting of the judicial authority of the Republic in our courts, its independence, and also its impartiality vis-a-vis the positioning of the courts with regard to the role that they play in instances where there is a disregard to the values of the constitutions, amongst them the rule of law, the need for all the other arms of state to act impartially, to act rationally, to ensure that all the decisions that it take are in line with the Constitution, because Section 2 of the Constitution also talks about the supremacy of the Constitution, meaning that any conduct that is in conflict with the values in our Constitution through Section 165 grants the court the discretion to set aside those decisions.
Yes.
Thank you, the President. Thank you, Justice Matujani.
Thanks, Commissioner. I must say, you are raising a very pertinent, good question. Section 165, sub 2 of the Constitution reads, the courts are independent and the law, which they must apply impartially and without fear, favor, or prejudice. Judges are expected to have independent mind. How can I put it? The Constitution enjoins you to apply, to protect the Constitution and the rights embodied therein, without fear, without favor, without prejudice. You cannot be aligned to a political party or an interest group and still be independent. Independent presupposes that you would enforce the Constitution irrespective of how powerful or how influential a particular person is. Now, the rule of law, implicit in our constitutional offering, is the principle of legality. Public power should be used for the purpose it was granted for. Any law that violates the Constitution is invalid because the Constitution is the supreme law of the land. Whether you are a president or a gardener, you are subject to the law. If you are a public official, you have to act within the law. Now, interpreting a constitution is political in nature. There will be those tensions because a politician will say, I'm a public representative. I have a mandate from my constitution. The government will say, this is our policy. Now, as judges, we are not public representative. We are not elected. We are appointed in terms of the Constitution to give meaning to the socio-economic rights that are in the Constitution. So that will definitely create tension. If you are a politician, you would want appointed a judge that will be sympathetic to your cause or constituency. Or if you are an interest group, or for want of a better word, you don't want a judge who is independent and who will, without fear, fail or prejudice.
Thank you, Judge
Thanks,
Matlosane.
Commissioner.
Thank you.
I
President.
hope I answered your question.
Yes, definitely. Thank you.
Thank you, Commissioner Amwimam. Commissioner Pillay.
Thank you, Acting President. Good afternoon, Judge Matajani.
Good afternoon, Commissioner.
Judge, in your form, when you are asked to list your most significant judgments,
Yes.
At number 2, you mentioned the DA versus Minister of Cocta matter.
Yes.
Which was the constitutional challenge to Section 27(2) of the Disaster Management Act.
Yes.
And you mentioned that that's one of the most significant judgments, even though it was a dissenting judgment.
Yes.
I just wanted to ask you a question about that judgment, because what was striking in that case was that the majority took into account the fact that when the minister declared a national state of disaster under the Act,
yes,
she did so in circumstances where it was unclear or uncertain what the nature of the disaster would be.
Yes.
And in fact, no one in government at that stage would know exactly what it is that they're going to be dealing with, because this happens right at the onset
Yes.
of a disaster. And the court also took into account that a disaster being what it is, there would be a need for government to be able to act effectively and expeditiously
Yes.
in order to arrest the disaster.
Yes.
Now, those were the two central issues which the majority took into account in deciding that Section 27(2) could withstand the constitutional attack.
Yes.
Now, you, on the other hand, you in your dissenting judgment found that there was an excessive delegation of legislative power
Yes.
to the minister.
Yes.
And you then say that you would have declared the section unconstitutional and you would have remitted it to Parliament and have Parliament cure the defect in a certain period of time. I think you mentioned 2 years.
Yes.
Now, what was not clear to me reading your judgment, and if I was a parliamentarian who had received this, let's assume you were the Constitutional Court, received your declaration of invalidity, and you're now expected to cure the defect, it wasn't clear to me how you envisaged that defect being cured. given those two central issues, one, that it was impossible to predict in advance the
Yes.
nature of the disaster, and two, that there was a desperate need for government to be able to act efficiently and effectively.
Yes. Commissioner, your question is multifaceted, and it's a good question. The point I want to make is, you're right when you say a disaster cannot be predicted. We can have locust infestation overnight, and draconian measures have to be put in place on an urgent basis. But my point, my concern here is, up to now, I don't think the minister has placed that before Parliament so that Mr. Malema here can make an input as to the desirability or otherwise of banning people from buying cooked chicken, stopping people from running in the morning. The point I'm saying is, yes, the minister may have to act with expedition and take urgent measures, but what stops her thereafter from going to Parliament and explain herself and invite input from other parliamentarians? I mean, up to now, there hasn't been, I'm not sure whether there has been any legislation that came out since you remember, at one stage, every month, the state of disaster was being extended with no debate in Parliament as to the desirability or otherwise of further extending the state of disaster. I mean, the minister had such wide excessive powers that even overrode other legislation. We have the Liquor Act. She had power to control the sale and drinking of liquor. So my point was that you can't delegate excessive power. You see, in a democratic state, we could have the next government. Maybe AfriForum is in power. The EFF is it's a government of the day. Now, if we don't seek to regulate government power, if government can, delegate wide powers, unchecked, we are creating precedents would have difficulty in following. In summary, the point I'm trying to make is the role of Parliament is to have the public representatives deliberating and passing legislation, rather than giving the minister the power to legislate uncontrolled and unchecked.
The only point to raise, Judge, is that not only the majority in this case, but a number of courts, ending up all the way in the Constitutional Court, have recognized the imperative for the executive to have those powers in a disaster,
Yes,
a national state of disaster, because of the unique nature of a national state of disaster, and specifically the COVID pandemic which we dealt with,
Yes.
which was inherently uncertain and unknown.
Yes.
That was the difficulty that we were dealing with.
Can I come in
and that the
there?
principles that you espouse are principles which ought to apply and should be upheld, but almost in an ideal situation.
Yes.
But not necessarily
before
in a
you move
disaster.
further, can I come in there? The point here is, yes, the minister should have those powers, but she must account to Parliament. After, we can have an earthquake today, maybe in the next week or two, let her come to Parliament and have that issue debated and the relevant legislation passed.
Thank you, Commissioner Pillay.
Are there any further questions, Minister?
It's just a follow-up on that. Firstly, Judge, I agree with Commissioner Pillay that
Sorry, Minister, can you repeat that?
I'm saying, firstly, I agree with Commissioner Pillay that these powers were necessary for any eventuality in cases of disaster.
I also agree with her.
Yeah, and I also think that there is a platform to account. You will have, I heard you saying you are not aware, but several ministers responsible for some of those powers were called to their portfolio committees to account in terms of the exercise
Did they
of these
account in
powers.
Parliament?
Yes, in Parliament.
Yes.
They were called, including the Minister of Cooperative Governance.
Was legislation passed?
Obviously, they were invited in terms of this legislation that there is these regulations that we are dealing with. What are the issues? The political parties hold them to account. The biggest debate was whether there should be an ad hoc committee and all those kind of things. But they were called as executive authorities by their various committees to account.
Yes.
So I'm just raising that the act is not as wide as you, I hear you to be saying that it's an unchecked kind of exercise of power by the executive.
Thanks, Minister.
Judge, I'd just like to point out that legal commentators worldwide have commented on the dangers inherent in the powers given to the executive during times of emergency and the way in which they potentially threaten a democracy, a constitutional democracy. So while I certainly agree with a lot of what my fellow commissioners have said, I would commend you for raising the issue because it's something that as a democracy we need to watch closely.
Thanks, Commissioner. Just a short comment. During apartheid, they would govern through these regulations, and okay, maybe let me withdraw that. Thanks, Commissioner.
Commissioner Banat, do you have a question for Judge Matojane?
I do, DCJ.
Go ahead, please.
Thank you. Good afternoon, Judge.
Good afternoon, Commissioner.
Yes, you have an experience as a conveyancer. Is that correct?
Yes.
And what is the benefit of having former or people with conveyancing experience also as part of your SCA judges?
Yes.
But we heard there are some others earlier in the week, including the acting president, but you would be one of those if you were to be appointed. So what is the benefit?
Conveyancing is a specialized field where you have to acquire expertise in property law, interstate succession. You know, all these laws comes into place in a conveyancing transaction. Huge amounts of money are involved. And knowledge, let me put it like this. Every law relating to property, you have to acquire knowledge and expertise in every law that relates to property. So my knowledge of conveyancing, in my view, would add value in any matter involving property law. For instance, I wrote a judgment where an entity designed a software that was to basically automatically populate the platform with all the information that, in terms of the law, should be prepared by a conveyancer. And then they were saying they will employ conveyancers whose job will be just to append their signatures to the documents that would have been automatically generated. And I felt that because of you need to know disease estates, you need to know the law of intersection, the law of succession, you need to know the wills. You cannot have a non-lawyer doing the work of a conveyancer. It's a specialist field. They took the matter to the SCA. The SCA agreed with me. They went to the Concord. The Concord refused them leave to appeal.
You're referring to Proxy Smart versus Law Society?
I didn't catch that, Commissioner.
No, so thank you. I think you're referring to Proxy Smart versus the Law Society.
Yes.
Thank you very much.
Thanks, Commissioner.
Thank you, DCJ.
President Pedro.
Thank you, Deputy Chief Justice. Judge Matonjan, we've had a long day and there's still a long way to go.
Yes.
I've got a few questions for you. You acted at the SCA altogether for 6 terms.
Yes.
And when it comes to judgments, you would know that the scribe is not obliged to accept comments or suggestions from the other colleagues.
Yes.
But nevertheless, you would give serious consideration to them.
Yes, because in most cases, these are highly experienced senior judges.
Thank you. Then the last one is just an observation from the comments received from various professional bodies and lawyers' organizations.
Yes.
All of them attest to your scholarship industry, delivering judgments promptly and extensive professional experience.
Yes, I've noted that and I'm grateful for that.
Thank you. That's where I leave it.
Thanks.
Thank you, Deputy Chief Justice.
Thanks, Acting President.
Anything you would want to bring to our attention, ask us, address us on before we let you go?
Well, it's just a plea with respect that the commissioners should bear in mind that we are sitting judges. I may be in court tomorrow, and if I'm to avail myself for this process and get humiliated, what are we saying to the parties who are appearing before us? That's how far I can put it. The point I'm trying to say is this, that has a decisive impact on the rule of law, because you want litigants who appear before you to have confidence that their matters would be ably and properly adjudicated upon. But if in this platform it is insinuated that I don't know what I'm doing, why should a losing litigant accept that he or she was unsuccessful in that matter, when that litigant knows that I don't know the law? It's just a plea that commissioners should bear in mind that we have families. As judges, we have developed thick skins. if you go on Twitter and see the kind of things that have been said about me, I can live with those things. I mean, I've been in this game for many years. I've developed a thick skin. But if only commissioners could remember that we also have family members. We have children. They get to read about these things. We have litigants who are still going to appear before us, and they should have confidence that we'll dispense justice without fear, without favor, and without prejudice. That's all that I wanted to say, Deputy Chief Justice and President.
We have
Peter.
heard you, Judge Matotani. Thank you.
Thanks, just.
Okay, may we ask all those who are not commissioners of the Judicial Service Commission or the support staff to clear the room so that we can Good evening, Judge. I'm sorry, how do you pronounce your name?
It's pronounced Minoyam. It's a very difficult
Moyam.
surname to pronounce.
Oh, I almost mangled it. Okay, thank you.
Thanks.
How are you?
I'm well, thank you, DCJ. I hope you are too.
We do apologize for keeping you waiting for so long, but
No, I understand
it's
it.
very difficult to
Yes, no, I
to
appreciate
keep
it,
time in
thank
these proceedings. You hold 2 degrees, a BA and an LLB from Wits,
Correct.
and you became an attorney for a long time, a human rights
Attorney, yes.
attorney, yeah. From human rights to competition law, how did that happen?
It is an interesting journey, but essentially, I think that once there was the transition to the democratic government, the feeling was now that we've dealt with state power and a change, it's necessary to deal with private power, and a lot of competition law is about regulating private power, and that's how I got interested in this area.
Well, you have spent a huge number of years in the competition law space. You were a full-time member of the tribunal from 1999. I imagine that would be when this area of the law was emerging.
That's correct. It's when the new institution started.
Thank you. I'm sorry, I'm just going to interpose, Judge Moyam. Judge Valley, because we're interviewing for the SCA and you do not have the head of court is sitting right next to me. I forgot that there is a head of court over there now. Welcome. I do understand that you have come to represent the competition courts. Yeah, all right. Oh, it's the mask. Can you hear me now? I was just saying welcome. Oh, I was in the middle of a question. You were there right at inception.
That's correct. It's when the new act started.
And you spent 10 years in the tribunal.
Actually, it's 20 years in the tribunal, and I was chair for the last 10.
Yes, from 2009 until
Yes,
10 years
2019.
later. You have taught at a number of universities and are currently engaged at UJ, where you teach at the School of Economics. Do I have it right?
Yes.
What do you teach at the School of Economics?
Competition law. Because they see the interface between the two.
And how long have you been involved with them?
I've been with them for about 3 years, but I've mainly been, my longest stint has been with the University of Witwatersrand, where I've taught every year in their competition law postgraduate classes.
All right. You have, you started acting as a judge in 2019.
Correct.
And you also have experience in the income tax court. You had a stint there.
Yes.
And you were permanently appointed last year in June as a judge.
Correct.
Is that correct?
Yes.
Okay. And your current position, you got early this year?
Yes. So I was appointed to the Competition Appeal Court with effect from January of this year.
Yeah. Well, you are considered the premier expert in the field. The record is replete with those references. But I wonder, well, you'll tell us, because you were the chairperson of the tribunal after all, what leadership experience do you have that would qualify you to head the Competition Appeal Court?
Well, leading the tribunal is just to give context to it, the tribunal is the adjudicative arm of the competition authorities. There are 3. There's the commission, which plays the role of policeman stroke prosecutor in the system. The tribunal is the court of first instance, so it hears cases and it writes reasons. So it although it's an administrative tribunal, it functions like a court. And so as chair of the tribunal, you are really doing the same job as the leader of a court would do. You're appointing panels, you're seeing that panels run properly, you're planning, and all those particular functions. So that kind of experience in this area of law, I think, counts for the ability to lead the court, should I be appointed.
You know, what is the, let me just check, oh no, let me ask another question. How did you, well, do you know how it came to be that you are the sole candidate for this vacancy?
I don't know.
Yeah.
It comes as a surprise to me as much as to other people. So I don't know. And I was also surprised that there weren't other people who wanted to make themselves available to serve on the court as judges. As I understand, people didn't put their hands up.
How many judges are in the court? Permanent judges, that is?
Well, at the moment, according to the registry of the tribunal who run the court's registry as well, there are only 2 permanent judges, and that's Judge Valley and myself. And there are 10 acting judges who are appointed for the year. So in other words, their acting terms will finish at the end of this year unless they get reappointed. So altogether, there is a pool of 12 people available, 2 permanent and 10 acting judges.
All right, I'll leave it at that. I'll hand over to my colleagues to put questions to you. Commissioner Malema?
Thank you very much, Deputy Chief Justice. Do you think it is fair for us to interview only one white female for a position of this caliber and not test that against other more potential candidates?
You said one white female, one white male?
Female, black African, blacks in general. So that by the time we come up with a white recommended male candidate, we're spoiled of choice. And you know that you came from competing amongst the best.
Well, one might say there shouldn't be a monopoly in terms of position in the Competition Appeal Court, but let me give some context to it. This position was advertised last year as well, in July, and nobody applied for that position. So the position was again advertised this year. I'm the only other person who's put their hand up. Well, one could consider saying, well, we must wait again. But then is there an expectation that if it's delayed for another 6 months, that other people are going to come along? Because to the detriment of the court, that we haven't had a president appointed since Judge Davis retired at the end of 2020. And the court has got responsibilities and functions that got to be attended to. And I'm the person who's put their hand up. I can't help the situation that other people haven't applied.
Thank you.
Commissioner Nyambi?
Thank you, DCJ. Evening, Judge.
Evening.
I've got only one question. As this is a leadership position, what, in your view, are the immediate challenges facing the Competition Appeal Court that you'll have to deal with should you be affirmed?
I think the immediate challenge of this court, because it's a specialist court, is to actually solidify what its purpose is. In other words, are we going to try and find another model on which to base the court and how to run? For instance, the Labour Appeal Court might be a suitable model to follow. Because at the moment, the court has been somewhat ad hoc. The judges who sit on it are some permanently appointed judges and some acting judges, but the court has been sitting during the recesses. Now, there has been a move to actually start changing that already, and Judge Valley has been assisting in that, and with the help of J.P. Malumbo and DJP Sutherland, to give judges off during the term to serve on this court. But I think if we're going to restructure that court, we need to actually have a program ongoing where judges are released to do this by their divisions. Their divisions know that they're being released, so we don't create tension with the JPs, and they are released for a period of time to hear the whatever cases are coming up. And so what I would see is a transitional program as the work of this court starts to escalate through matters coming through the tribunal. We start to roll out how much time we need from the various judges who serve on the court, book them in advance so the JPs and the divisions don't feel that we're taking their judges away, and then start, in a sense, scoping how much requirements we need at a particular time. So we don't want a situation where we don't have enough judges when we need them, or that we have taken judges away from the division and there isn't enough to keep them going in the appeal court. So we need to, in a sense, work out what that mix is over a period of time. But I think we definitely need a model where the judges are released for some period during term time when they can read these cases, all of which are very long and fact-heavy, hear the case and write their decisions, and then can go back to their particular division. So something akin to the way the Labour Appeal Court functions would be something I think we should be doing with the Competition Appeal Court.
Thank you, Judge. Thank you, DCJ.
I made a mistake. Well, carry on, Judge Valley. It's fine. Is your hand up, Minister?
Your mic.
Thank you, DCJ. I don't understand the process here so well, so please bear with me. I had a number of questions for you, but I don't want to put you in a difficult position because I know how anxiety-filled it is to be sitting in that position. So let's see if we can just try and cover what I think are important topics in this. Judge Manoy, the first question I want to ask you is, do you agree with me that the tribunal is just a quasi-judicial tribunal? It's not really a court.
Well, its classification would be that it's an administrative tribunal, but it functions in every other way like a court.
Yeah, well, coming to that. In many ways, yes, they are, because it's adjudicative, and
yes.
That's what you're referring to.
Well, it's adjudicative, but
yes.
The way it functions, the way it hears cases.
Yeah, now please, I don't want to catch you out. I'm just trying to take us to a point of where I think this court should possibly go. And I want to see what example. What we have there, is an administrative tribunal called the CCMA. We then go to a court equivalent to a high court that looks into that tribunal, and that's the labor court. But then we go to a labor appeal court. Now that's a proper appeal court because it's sitting as a court in appeal of another court. And it doesn't, it's not, you don't review decisions of the labor court, you deal with appeals of the labor court. But here we have a strange structure. Now I don't know, and that's why I want to just go back to the history. Why was it necessary to set up this structure? What was behind the thinking of such a structure?
The thinking behind it was to have, there needed to be an appeal from an administrative tribunal. So the choice was whether you went to the ordinary courts, which could have been a choice of those who drafted the act. And the feeling was because you wanted to develop a specialized competition jurisprudence. Therefore, you wanted to have a specialist court. In fact, originally, the idea was to have on the appeal court 2 economists who would sit with the 3 judges. But the JSC at the time, under the leadership of Chief Justice Chaskelson, got an opinion, and they said, look, you can't have economists sitting on a court. So the economists were dropped. But the status of the court still remains as a specialized court, which hears appeals from the tribunal, and who then can be appealed to the Constitutional Court. So it doesn't go to the SCA.
Yes, I'm going to come to that in a moment. So we have the structure which goes like this. We eliminate the Supreme Court of Appeals altogether, but the structure goes like this. Administrative tribunal or quasi-judicial tribunal, appeal court, which is a high court, and then a constitutional court. which is not a specialist court, which is an all-round court.
Correct.
The Supreme Court of Appeal is excluded because this is supposed to be a specialist court. And the Supreme Court of Appeal has said you can't hear matters of a specialist nature. And I'm not sure that there's any sense in that. But what I can't understand is why we can't turn, why we can't turn the tribunal into a high court. Why we can't say administrative body, something similar to the labor court. You have a competition court which must be housed in all the high courts, like the equality court is, and then an appeal from there to the Supreme Court of Appeals. Is there any reason why such a structure would not be a more optimal way of using judicial resources?
Well, there are a number of reasons why the tribunal takes the form that it does. The first is that the tribunal is comprised not only of lawyers, but of economists.
Yes.
So you wanted to get the input of economists in that body. You couldn't get that in a court. Secondly, it relates to the kind of work that the tribunal does. For instance, mergers are a big part of the business of the tribunal, and they have to hear that all the time. So the court model wouldn't work for this particular structure and what it has to do. And fourthly is the tribunal has got inquisitorial powers, which is unusual for bodies in this country, but it's useful in the sense that it allows the tribunal to get in evidence and information to help it in its decision making. So those were the policy reasons behind what the design as it's taken.
Let's talk about the economists. And I don't want to monopolize this role because this is an important position that's going to talk about the future of this court. I just need to raise some of these issues.
Sure.
Let's talk about an economist. I mean, I've even seen economists chair and preside over in these matters. So in the tribunal that you say, we have economists presiding, but making decisions on issues now, and I think we need to grapple with this issue immediately. Making decisions on issues that are really legal in nature, because as much as we say it's a specialist court, most of the issues that they adjudicate about involve legal questions. In fact, a lot of the cases I'm dealing with, they're all law questions. They're not economic questions. I'm going to come later back to it. But it's all legal issues. Laws of evidence plays a very crucial part in there. And that's, of course, the hearsay evidence and all other evidence that we come up with as experts. So what is it that we need of economists? And if we do need them, why can't they just be an assessor to the court in a high court setting?
Well, it's been my experience that economists have added huge value to this proceeding. And in fact, economists have probably taken better to the law than lawyers have taken to the economics. You want to look at one of the best written decisions out of the tribunal, look at the decisions written by David Lewis. And people have said he must be a lawyer in the way he's written. He's written very good decisions. Andreas Wessels, who's the longest serving economist, has written really good decisions. He wrote the tribunal's Mediclinic decision. So it's a very, very thorough decision.
So which decision did he write?
The Mediclinic decision for the tribunal.
Oh, the one that I dissented, the one I wrote the minority, which was upheld by the Constitutional Court. The majority was, I didn't know that.
This is beginning to feel like watching a conversation between the two of you.
I'm sorry.
Commissioner Vali, you're a commissioner now.
Okay, I'm sorry.
Yes, can you just try to... The House rule is 2 questions per commissioner, but because you are the head of the court, we give you more leeway. But your questions still have to be questions and
I'm going to be
as crisply as possible.
My experience is, I mean, people talk of this as economics law. I'm still not sure what it is. And then it comes to economists. My experience is that we have 2 different sets of economists. Now, please tell me if I'm wrong, telling us which way we should go. And that is just purely giving us expert opinion evidence. And much of it is their opinions based on who they represent. In the sense that they're just hired by this party, they'll say this, and in the sense that. But there's nothing there that a judge doesn't deal with daily when he deals with opinion or she deals with opinion evidence. Now, is that wrong?
Well, yes and no. I mean, judges do all the time get experts. We have medical cases where we had experts on both sides. But I think what makes the difference is that if you've got an economist sitting there, they are able to actually interrogate which has got the better argument or which has got the worse argument. And they can be very useful in terms of the way they conduct the inquiry, what they ask the economists, how they test their assumptions. So they add value to these proceedings.
Okay, I'm going to move on. Talk about ask you questions of something else, and it's about the jurisprudence that comes out of the tribunal and the jurisprudence that comes out of
I'm sorry, Judge Valley, there is a request that you pull your mic closer to you. Some commissioners are struggling to hear you. Your voice is soft. Just speak to it just keep it as close as possible to your mouth.
Thank you.
Judge Manoyam, you too, I'm struggling to hear all of your answers.
Sorry about that.
What do you understand is the fundamental purpose of competition law, and how do you see that the tribunal and the CAC have achieved that purpose in this period?
Well, the fundamental, there are a number of objects of competition law. That is to ensure that markets are competitive.
Yes.
That is to ensure that markets are inclusive. In other words, and it's particularly relevant to the South African situation, that people who've been excluded from the marketplace can be included back in the marketplace, and not locked out because of restrictive practices by powerful dominant firms.
Can you give examples
of
this issue? Where people are excluded?
Look at the CompuTicket place, in which people, a powerful firm engages with the customer base in exclusive contracts. As a result, another smaller firm can't get contracts and can't get into the marketplace. So that would be one example. SAA was another example. SAA engaged in a loyalty program that almost paid travel agents more the more business they gave to them, not on the basis of a linear discount, but of taking business away from the other firms. So those would be two examples.
No, but you're talking of oligopolies, monopolies, and those sorts of things. But they're general to all societies, all capitalist societies. What I'm asking is, what's special? What is our purpose in this act? Well, let me ask you differently. Do you think there's any role for transformative constitutionalism within the competition law?
Yes, there is, because if we talk about inclusion in the marketplace, that has a constitutional imperative. We're saying to people who want to exercise their economic rights and enter the economy, well, this is one intervention which helps that process.
Okay. Okay, what's your approach to transformative constitutionalism other than just allowing people who don't have the economic power to get in, to try and get in?
Well, that's an enormously important thing on its own.
Is it that? Well, now that is in any other society as well.
Well, not
Germans, Americans, British.
Americans at the moment don't. There's an attempt at the moment by new leadership in the American competition authorities to make it more inclusive, but it hasn't been.
What's your approach to competition law? Is it just simply to make the market more efficient, more competitive?
No, it's not just to make the market, it's also about inclusion in the marketplace.
Okay. You know, I'm going to tell you what my impression was sitting there. My understanding of competition law is that it's simply trying to navigate an area where if you left untouched, like a neoliberals would want to be done, you could end up with abuse of processes, you could have more monopolies, oligopolies, centralization, concentrations of police corporations. And so what we got then is another group that came up, which we call the ordo-liberals. I don't know if you ever heard of them.
Yes.
Yes. And they're the ones who said we need to intervene to save capitalism from itself, and let's now introduce competition law, and that's what we got. What I found in the jurisprudence is a confusion amongst the tribunal and the CAC as to when they are following this system and when they are following that system. Would that be a fair assessment?
Well, you know, the Act doesn't say which philosophy you need to follow. Different sections, in fact, embrace different philosophies, and different people sit on the tribunal and the court at different times. So it's not surprising that they may emphasize in one direction or the other direction.
But, okay, you say we need a tribunal to have specialist economists, but now we don't have them in the CAC. So is there a problem there?
Well, to me, it's important to have judges who understand the economic issues, and that's why you've got a specialist court. We can't put on economists because there was the constitutional problem which Chief Justice Chaskelson identified. So that was the original model, which hasn't worked. So that's why it's important that judges who sit on the court have some appreciation of what the economic issues are and what the economic debates are.
Many of the judges who sat on that court and who've performed very well would say to you they have had no experience in competition law and no background in economics. And they've done quite well, they've written good judgments. Do you think that would be wrong?
I can't generalize about the particular people, but there are people who've been on the court who have actually practiced in this area quite extensively.
And there are others who've never.
There are others who haven't and have picked it up quite well. I grant that. There's been training given to the judges. They received that well and have taken it in.
Okay. What judgment of you, I mean, you've been a very young judge. What judgment of yours would you say can put up forward and say, this is a judgment which I think is a scholarly piece of work, meriting that of a court which is almost equivalent to a Supreme Court of Appeals?
If you're asking about in the competition area, I would say my judgment in the SAA case. And
that's in the tribunal?
Yes, in the tribunal.
You say a scholarly piece of work if we're meriting SCA?
Yes, and it's been quoted in an international textbook called The Lawyers for Economics.
I have another question about your candidates, but I'm going to leave it to other people and we'll come back towards the end of that. But thank you for your answers, Mr. Justice Manoy.
Thank you, Commissioner Vali. Minister?
Thank you, DCJ. And good evening, Judge Naomi.
Good evening, Minister.
Yeah, you have been with the tribunal for almost 20 years.
Correct.
What was your role to embrace or create a conducive environment for black practitioners to participate in this specialized area of the law in the tribunal?
Well, firstly, by who we got to sit as tribunal members over the years. Second, one of the reasons that I've been involved in lecturing over this period of time is to get new people into the area. And predominantly now, the people who are in my classes, it didn't start this way 20 years ago, predominantly now we've got black students in those classes. And the reason I'm lecturing there is to bring new people into the area. As the tribunal itself, we don't brief lawyers or counsel. They are briefed by the people who appear before us or the commission itself. But we've certainly tried to make sure that the bodies like the commission are briefing black lawyers.
If you are appointed, what do you envisage will be your role in terms of your philosophy with regards to the new Competitions Act amendment, particularly with regards to the abuse of dominance by the dominant firms in the country?
Well, I think important jurisprudence will, the new provisions relate to excessive pricing. There's been amendment to predatory pricing, and there's been the buyer power provisions, which have yet to be tested. So I think there are a number of challenging issues that are going to come forward, and the jurisprudence in those areas has got to develop, and is going to be very important because we're in fact going into completely new areas.
Thank you, DCJ.
Commissioner Pillay?
Thank you, DCJ. Good evening, Judge.
Evening, Commissioner.
Judge, I'm going to put my concern to you. At the moment, there are 15 heads of court positions, and not one of them are filled by a woman. Previously, there were 2 women holding head of court positions. The one was the president, now acting DCJ. And since she's been appointed as DCJ, she no longer holds a head of court position. And the second head of court, just retired recently. So that leaves a situation where you have one acting judge president, and that's the acting judge president of the Land Claims Court, Judge Mayer. And apart from that, no woman holding a permanent head of court position in the country out of the 15 positions. Now, for me, those facts tell a very dire story about the role of women within the judiciary, firstly, and within leadership positions in the judiciary. Now, against that backdrop, do you think it would be appropriate to appoint a male at this stage as a judge president?
Just one fact that I need to mention is that we're forgetting about Judge Madiba, who was appointed as head of the special tribunal quite recently. I think it was September. So she's a head of a specialist court. But that being said, it doesn't detract from the point that you're making. Now, I obviously can't contribute to gender diversity or race diversity by my appointment. But what I can do is to be an agent for change. And I've been an agent for change in the tribunal, and it would be something I would carry on doing in the court. Because what we need to try and do is to actually encourage women in particular, and judges of colour, to actually come and join the court, to be enthusiastic about the court, and to want to be there. I'm not there forever in the particular court. In fact, the Act requires the President to appoint judges to the court for a particular term. So I'm not there forever. I see myself as somebody transitioning from a particular situation at the moment where we've lost a number of the senior judges in the court to a situation where we can actually bring new people through. Because we can't walk away from the fact that no one put up their hand last year and no one is putting up their hand now. And that is to the detriment of the institution itself, which requires somebody to be its agent for change. So the most I can say is I can try to be that agent for change.
The issue I'm really raising is to what extent, what kind of tolerance level should we have for the kind of situation I've just described to you? And what would the message be that will be sent out if another male is appointed in the face where you've got, I'm not even sure if Judge Madiba's appointment to the specialist, it raises her to the level of the heads of court, which is what we're debating here. But what kind of message are we sending to the country about the role of women in the judiciary when you don't have one single head of woman leader in the judiciary? If you discount the DCJ, given that she's not a head of court.
Well, I think one's got to look at what is the competition, what is the composition of that court as a whole. At the moment, if we take the 12 judges who are part of the court, 8 of them are actually women in that court. So in a sense, if we're looking at what message we sent, a panel sits of 3 judges. If you're seeing that women are sitting on that panel, sometimes the majority. I've sat in some of the cases where I'm sitting with 2 other women judges. So you're sending a message that this is a court where women are judges and where they have an equal say. The fact that we haven't got a male head, a sort of a female head at the moment, is a consequence at where we are at the moment. But I don't think we solve it by not making an appointment, because if that's the solution, it's to the detriment of this institution. At the end of the day, we are responsible to all the people in this country for this institution working properly and doing its job.
Thank you. Just a quick follow-up. I understood you. In fact, let me just ask you to give us a proper racial and gender composition of that court, because
Yes, sure.
I recall you said most of the judges were there are only working there temporarily.
There are 12 at the moment, so in other words, the 2 permanent judges and the 10...
and the 2 permanent
The
are
2
the two
permanent
of you.
are Judge Valley and myself.
Yes.
Of the 12 judges then, that includes the acting judges, 8 are women, 8 are black judges.
But they're not permanently appointed.
They're not permanently appointed. They've been appointed for the year, and I would assume that if they are interested in wanting to carry on, the way it works is that the President of the Court approaches the Minister of Justice and asks for acting judges to be appointed. So that would be the process. So my assumption would be that whoever's the Judge President would canvass these 12 people and saying, are you interested in doing another year? If so, we'll send your names forward.
All right. Judge Valley?
I just want to follow up on this, and I want to tell you something. I also asked people around why they didn't apply. Being the acting judge president at the moment, I had to interact with all of them. And one of their concerns was that they've been deprived of the opportunity to act. And they felt that it would be a bit hasty on their part to try and come here. And a lot of them are far more experienced judges than you are, so I'll raise that right at the end. But they wouldn't apply simply because they were deprived of the opportunity to act. And they are more than happy to apply at the next time round if there's such a position available. Once they've acted and done a few cases and got, or 1 or 2 cases, and got their heads around this fact that there's a specialist court that they feel they haven't been able to sit in. Now, do you think that if what Commissioner Pillay is saying is correct, then, and that some of those people I'm speaking of are female, then it would be dangerous to appoint someone now and seal the position for, how long will you be? 11 years? You've got 11 years still left as a judge, or 12 years.
The appointment, the period of the appointment, the Act says quite explicitly that the President appoints the person and sets the period of the appointment. So this is not an open-ended thing that the person who's appointed is there until they retire. So term limits can be imposed on the person. So if the President wishes to make it for 5 years, the President can make it 5 years or 4 years, as the case may be.
Do I understand you correctly to say if you were appointed, you'd be happy to serve for 4 or 5 years?
I would, yes.
1 year?
I don't think you can, if you're doing a project building the institution, I don't think you can do it in 1 year. It's too short.
What is your project for the Constitutional Court?
Competition Appeal Court.
Competition Appeal Court.
It's to, in a sense, to build the model of how the court is going to work, how many judges we need, how that works. I'd like to bring in a case manager, a researcher. I want to build a website for the court. We want to build training for judges. We want to bring new people through all the time into the court. We want to liaise with the profession. All these are projects that require time and which somebody who wants to be the president can engage in, and to create enthusiasm around the institution and this area of law.
And if you're holding for 1 year and someone can come back and take it over, because a lot of that stuff has been attempted by Judge Davis. You may say maybe not with great effect, but if you're there for 5 years, it means many of these people will no longer be available, many of these women, because they'll be out of the judiciary. They're by far your seniors. They've been in the judiciary for 6, 8, 10 years, 11 years, some of them.
I think we've also got to talk about this institution. I mean, the reason I'm here today is because I'm passionate about this institution, these institutions in the Act. And I want to see them working properly and working according to what their purpose is. And that's what I can contribute. But I see us bringing people in all the time on a continuous basis. So there will be people to take over from me in a period of time, but at least come into an institution that has been built and is functioning and knows its purpose.
Do you think they won't be putting out a wrong message by allowing such a junior judge to become a leader of a high court over many judges who've been there for over 10 years?
Well, again, one's got to ask, why haven't other people put their hands up?
I've told you, because they've never acted. They've been feeling deprived, and you're benefiting from their deprivation.
Well, I think with respect that's not so. But anyway, I don't think it sends the kind of message that you're trying to imply that it will. At the end of the day, I think people want this institution to be doing its job. And that to them is an important thing, and I'm seen as somebody with expertise in that. So in other words, people see me, this is a specialist court in the area, and I'm somebody who's got considerable experience in that area. And that's been the feedback that you see from the various law bodies.
Thank you.
Professor.
Thank you very much, Deputy Chief Justice. Good evening, Judge.
Evening.
There are so many issues that have been raised with you, and I think some of them you may not necessarily have control over. But I just want to pick up from, perhaps maybe let's just talk law, you and I. I've had the benefit of reading most of the decisions that you authored at the tribunal, and most of them were really helpful. I just want to pick up one thing that I think I'm battling with in South Africa currently: the extraterritorial application of our competition law for those people who may do things outside the country. As to how, do you think in South Africa, I know that the Act, Section 3, subsection 1, deals with that to some extent. Is our competition law developing to an extent that we can deal with these extraterritorial competition law concerns that have an impact inward?
I think it is. It's the whole issue of the effects-based test. In other words, you can have a cartel that operates outside of the country and has an effect on prices in the country, but none of these people are located in the country. It's an issue that came up there is a case against the various banks, which is a current case, so I must be careful what's being said. But the issue is that people overseas in these chat rooms conspired to affect the exchange rate with the rand and other currencies. And they were saying, well, there's no jurisdiction over these people, there's been no attachment. So the appeal court has actually come out with quite a strong decision, founding jurisdiction based on Section 3 of the Act and applying some of the international jurisprudence. Whether that will be challenged at a later stage in the Crown Court, I imagine it will be, and we'll see what happens there.
My last question to you. This distinction, when we are dealing with restrictive practices, and we are trying to define them in terms of the per se rule and rule of reason.
Yes.
With how the modern economics is actually operating, will that distinction in the near future be sustainable?
I think this distinction is still going to be there. What I think we're worried about in the modern economy are algorithms. In other words, people can buy the same package of algorithms, never meet in the same room, but get the same prices. And so we've got to look creatively about those kinds of problems that may come up in the future.
Thank you very much.
Commissioner Steinberg?
Evening, Judge Manoyan.
Evening.
I must declare that we've known each other for many, many years. And
Yes.
I think from student activist days, probably.
Yes.
Although you're older than me.
I was hoping you weren't going to point that out.
I appreciate your response to Commissioner Pillay that you would see yourself as an agent for change. And I also commend you on the training that you've done, which is very well known in the profession. You are a young judge, but in my view, your 20 years on the tribunal do count for a lot, and I think they should be taken into account. I'm aware that the judgments of the tribunal are highly regarded in competition jurisprudence worldwide. And in fact, I'd be interested in your view in answer to one of Judge Valli's questions about what is unique in our jurisprudence. In complementing the tribunal, the early tribunal's jurisprudence, Eleanor Fox, who's probably the leading academic in this field, said that what the tribunal had innovated was to look at the impact on the consumer and not just on the entrance to the market or the competition between firms in the market. And she pointed that out as a unique innovation in the South African competition tribunal, and that was the tribunal under David Lewis, as I remember. Finally, I think of all the areas of law, competition law remains the most that you could characterize as the preserve of men. And I'm not sure if you'd agree with that, but I think that part of the problem we're seeing is that female practitioners don't filter up into that specialist court because they never get experience in their practices. Thank you.
I think if we look at the profession, what's interesting, and I can't explain why this is the case, is that a number of women have been very, very successful at attorneys' firms and have headed up departments. We also, in the public agency, the two heads at the moment, the head of the commission who's well known to you all here is now is Doris Seppi. The head of the tribunal, who was my successor, is Mondo Mzwai, and I'm very proud of both of them because both were my candidate attorneys when I was at the law firm. So I'm very proud that they've got these positions. You look worldwide, the European Commission in charge of commission is Margaret Vestager. The head of the Federal Trade Commission in the United States is Lena Khan. So women have actually played incredibly important roles in competition. What hasn't happened, or what hasn't happened sufficiently, is the number of women coming through as counsel at the bar. And I'm not sure why that is. I think the agents for change as to who gets briefed seem to me to be the attorney's firm. So it seems strange that women who are in attorney's fee aren't briefing another woman. I don't know what the answer to that is. Second agents for change are senior counsel who bring other counsel in. And the third agent for change is the commission, which is developing people. The problem with the commission is that they originally used to brief people in their own, in the tribunal. And because of budgetary constraints, the commission now briefs its own staff, amongst whom are a number of women, some of whom have actually gone to the bar. But private firms of attorneys are not briefing, they are briefing women advocates sometimes, but very few are being briefed, and not very often. And I'm not sure what that phenomenon is, but I think part of what we can project if I were to be appointed to this job is to go to speak to women at the bars and saying, don't be afraid of this area of the law. You can be the next Lena Khan or Margaret Vestager or Mondo Mzwai, Doris Seppi. Get into this area of law. Women can put their hands up and they can do very well about that. And I think if you project that, we may be assisting people coming into this area.
Any further? Oh, yes, Commissioner Matolo Rebu. Oh, sorry, it's JP Mlambo, and you'll follow after him.
Okay, thank you. Good evening, Judge Manuel.
Evening.
I'm here.
Sorry, can't see you.
All right. You know, you spoke about being an agent of change, and I'm trying to understand that what have you done when you were at the tribunal as an agent of change that you can do better now? Why didn't you do it when you're still at the tribunal, and what will make you do it once now you have been appointed?
Well, I'm not sure that I haven't done it at the tribunal. The fact that my successor is a black woman, and the longest serving member of the tribunal, Yasmin Karim, is a woman. When I was at the tribunal, the 4 managers who served were all women. So I have been an agent for change. So it's not that I haven't done that. That wouldn't be correct.
And for me, you were speaking about that private law firms. I mean, you should be speaking about the 5 big ones, because the other firms are not even getting that competition work. I mean, it's the 5 most known big firms that are doing competition law. The young black law firms hardly have an opportunity to do that. And how are you going to see to it that at least they're encouraged?
Well, I think there are certain limitations. At the end of the day, neither the tribunal nor the court can brief on behalf of people. But what we can do is to give people in these firms an opportunity for training, and that's why I've been doing the lecturing that I've done, and to give them the confidence to come actually into the system. And that's something, if I was appointed, I'd continue to do, with a degree of legitimacy, because if you're the head of the court and the fact that you're doing that, it will have